on behalf of Sierra Club and Vote Solar, and David Bender and Sunil Bechter are also on the line. And I believe Tim Laughlin is going to be appearing on behalf of Climate and Energy Project.
Yeah, good morning, Madam Chair. This is Tim Laughlin on behalf of Climate and Energy Project.
Thank you. And KCC staff.
Good morning, Chair Duffy, Carly Massentine and Cole Bailey appearing on behalf of Commission staff and the public generally.
Thank you, everyone. Does staff have a recommendation regarding notice?
Yes, staff has examined notice and reports that on June 16th, 2020, the Commission issued its order setting procedural schedule on rate design, which set the hearing to begin on today's date, December 16th, 2020 at 9 a.m. and continue into tomorrow, December 17th, 2020. The hearing dates were reaffirmed in the Commission's order granting joint motion to modify procedural schedule issued November 3rd, 2020. And the certificate of service for each Commission order included the address on file for all parties. And subsequently, there was communication between the parties in anticipation of this hearing. Staff notes the parties appear today in person, online, and therefore recommends a finding that notice was proper and that the Commission has jurisdiction to hear this matter at this time and place.
Are there any objections to notice? Hearing none, I find that notice is proper and the Commission has jurisdiction over this proceeding at this time and place. Before we turn to preliminary matters, let's go over some of the Zoom ground rules. First, if any party does encounter technical issues, ask to go off the record so that we can resolve them. Second, witnesses participating by Zoom are asked to keep their microphone off when they are not scheduled to talk. Third, if there are any witnesses in the hearing room, it is your responsibility to disinfect that room after you are done. If the Commission needs to deliberate, we'll be going off the record, entering a Zoom breakout room where you can't see us or hear us, and then we will return. Fifth, since we are participating at a distance, be very careful to identify yourself, exactly what you're referring to when discussing pre-filed testimony and exhibits. All of us have copies of that. We should be able to follow along, but do identify yourself so that the court reporter, although she has everybody's name, she understands who is speaking at the moment. Also, everybody mute their phones, please. And we will not be able to provide any of the other attendees their own breakout room. So if for some reason you all want to break out, that should have been established ahead of time. All right, so this technology seems to work pretty well. There have been a couple of hiccups, but nothing major, but please let us know if there appears to be a problem. And we will wave our hands wildly if you are still muted and speaking. Yes, it is the bane of Zoom. All right. Before we address the procedure for the hearing, are there any preliminary matters anyone wishes to take up? Okay, seeing none. Procedures during the hearing. I understand that parties wish to make opening statements. Evergy will go first, followed in order by Pioneer, Southern Pioneer, Liberty Empire, KEC, KEPCO, Midwest Energy Sunflower as a group, CURB, Climate and Energy Project, Sierra Club, Vote Solar, and batting last is the staff. After opening statements, we will follow the order of witnesses agreed to in the pre-conference hearing. At the pre-conference, the parties volunteered to consolidate their presentations and cross-examinations as follows. KEC, KEPCO, Midwest Energy, and Sunflower will jointly present their cases. Climate and Energy Project, the Sierra Club, and Vote Solar will also jointly present their cases. Likewise, the parties agreed to waive cross-examination of a few witnesses and agreed to order of cross-examination. I understand that at the pre-hearing conference, the parties indicated they will not make closing statements and that we also have a procedural schedule that allows for post-hearing briefs. We have a lot of information to go through over the next 2 days. We will enforce the time limitations on the opening party statement. Also, in terms of break, we anticipate we'll take a 30-minute lunch break somewhere between 12:30 and 1:30. We also, about every hour and a half, will take a 5-minute break. I think we all will need it. And I see the coffee cups are flying back and forth this morning. So I believe everybody will need to do that. All right, so folks, watch your limitation. We do not have a timer in the corner, but I believe it will be General Counsel Brian Fedotin that will remind you you're exceeding your time limit. So let's begin with Evergy and Ms. Dingus. Good morning.
Good morning. I will share my screen if that's okay. Can you hear?
Yes, your slides are on screen.
Great, thank you, Brian.
Sure.
Chair Duffy, Commissioners, good morning. I'm pleased to be here today on behalf of Evergy in support of our proposals for rate design for residential customers with distributed generation. Our proposed grid access charge is consistent with both the Commission and Kansas Supreme Court orders, is a first step in addressing the cross-subsidy issue created by DG customers' use of the grid, helps relieve the DG subsidy borne by standard residential low-income customers, and is not expected to inhibit the growth of distributed generation in the state of Kansas. As the Commission knows, it's been a long path to get to this point with respect to Evergy Kansas Central's attempt to develop a rate design that would reduce the Commission-recognized subsidy that exists in favor of DG customers. However, because of that history, a robust record and set of findings already exist within the record in this docket and the 2016 generic docket. That set of facts and prior Commission decisions provide ample support for Evergy's proposal to implement a grid access charge in this remand proceeding. The Commission has already determined that DG customers should be uniquely identified within the rate making process because of their potentially significant different usage characteristics. That the two-part residential rate design is problematic and results in DG customers not paying the same proportion of fixed costs as non-DG customers, and that DG customers are being subsidized by non-DG customers. None of these findings were challenged on appeal or overturned by the Kansas Supreme Court's decision. They are final and can be relied on as a basis for the Commission's decision in this remand proceeding. The subsidy created by DG customers was further explained by Dr. Faruqi in his direct testimony on remand. DG customers dramatically reduce the amount of power that they buy because a large portion of go down with volume. When billed volumetrically under the standard two-part rate, DG customers do not pay their full cost of service. That deficiency in cost recovery is ultimately paid by residential customers without distributed generation. This creates the subsidy problem, which is in essence a cost shift from DG customers to non-DG customers. In addition, as Dr. Faruqi explained, this subsidy is more likely to adversely impact low-income customers as they are unlikely to install distributed generation themselves. All non-DG customers are affected by this cost shift, but low-income customers are disproportionately impacted and least likely to be able to react to the subsidy by adding distributed generation. As Dr. Faruqi explains, this cost shift has not only been recognized by this commission, but also by commissions in a number of other states, many of which have taken steps to adjust either their net metering policy or rate design for DG customers in an attempt to begin to alleviate the subsidy. In its opinion, the Kansas Supreme Court made it clear that KSA 66-117D prohibits utilities from charging DG customers a higher on DG customers for the same service. However, this means that the statute does not prevent a utility from charging DG customers differently if they are receiving a different service. This is consistent with prior commission decisions in Kansas law, where it is well established that customers who use utility facilities differently may be charged different rates. As staff stated in its reply comments on remand, the court's interpretation allows a DG customer receiving an additional service to be charged for that service, even if residential standard customers do not receive the same service and are not charged for it. In the generic docket, the commission found that DG customers have significantly different usage characteristics when compared to non-DG customers. There is also substantial evidence in this docket that DG customers and RS customers are not similarly situated, and that the service provided to DG customers by Evergy is not the same as the service provided to RS customers. DG customers are partial requirements customers who self-generate all or a portion of their load and who have the ability both to take power from and send power to the grid, unlike standard residential customers who only take power from the grid. This fact alone, that DG customers have a two-way interaction with the grid when RS customers only have a one-way interaction, is sufficient in and of itself to justify the conclusion that the service provided to DG customers is different. Thus, KSA 66-117D and the Kansas Supreme Court order do not prohibit Evergy from charging DG customers a different rate, even if it sometimes results in an overall higher price for some DG customers when compared to allowing them to remain on a two-part rate and continue to be subsidized by non-DG customers. The grid access charge that Evergy has proposed, which would be computed based on the size of a customer's installed DG capacity, would more appropriately charge DG customers for the service they are taking when they utilize the grid, when they are short on supply from their solar panels, and when they have an excess of supply. In other words, when they are using the grid in a two-way fashion, unlike all other residential customers. As Mr. Lutz explains in his direct testimony on remand, the grid access charge of $3 per kW of installed DG capacity proposed by Evergy will not completely eliminate the subsidy that exists in favor of DG customers. It would take a grid access charge of $6.50 per kW to fully eliminate the current subsidy. Instead, Evergy is proposing to apply gradualism and begin to make progress towards correcting the subsidy amount by setting the grid access charge at just less than half of that amount. In the testimony filed by Mr. Gilliam on behalf of Sierra Club, CEP, and Boat Solar on remand, he essentially repeats all of the original testimony he filed in this docket and the 2016 generic docket. Evergy has already filed rebuttal testimony in response to his arguments and cross-examined him extensively, all of which is in the record.
Hello?
And the commission has,
yes.
and the commission has already made findings on the majority of the issues he addressed, none of which were overturned on appeal. This includes the findings I mentioned a few minutes ago regarding the
Hey.
differences.
Court reporter.
I don't have any,
If we can stop and go off the record right
I'm
now.
not hearing anything, nothing.
When did that stop, Ms. Smith?
Ms. Smith, can you hear anything?
Hello?
We hear you.
Ms. Smith, can you hear us? Obviously, she can't. Michelle, is she still connected?
Can anybody hear me?
Unmuted.
Yeah,
Yes.
yes.
We can hear you.
I hear nothing.
Maybe if we can take the slide down temporarily and she can see if when she asks if we can hear maybe some hand signals or something. I don't know.
Okay, testing 1, 2, 3. Can you hear, Ms. Smith?
Yes, all of a sudden it came in. I don't
Okay.
know what happened there.
Maybe make sure the volume is turned up on your computer too, so.
Well, everything was going just fine.
And
That-
then, okay, all right.
Yeah, that's what is confusing to me.
Did you hear
Okay.
any of Ms. Dingus's presentation or?
Oh, sure.
Okay,
Okay.
so it's when she said, hey, okay, so if you can maybe repeat your last couple of sentences with Ms. Dingus, and then why don't we try to let her share the screen again, and let's just stay off the record and see if we're okay.
Okay, I also want to face something else, just to make sure.
Madam Chair, this is Robert Vincent. I went ahead and sent the link to the YouTube stream to the court reporter in case that can alleviate some of the technical difficulties running through Zoom. I believe audio and video should still come through our YouTube stream, and she's got a backup source of our feed.
It's just the YouTube stream will be delayed by a minute or so.
Yeah, that's not gonna work. Okay, so Ms. Smith, can you hear us still?
I do. Everything sounds just fine right now.
Okay, why don't we go back and just repeat the last couple of sentences for Ms. Dingus? Ms. Dingus, why don't you try and share your screen again? We'll stay off the record and then we'll just do a test.
Chair
Okay.
Duffy, do we want the court reporter to basically just read back where she was?
Yes,
She
Yeah.
became inaudible so we don't miss any of Kathy's presentation. I just want, or Ms. Dingus's presentation. I want to be sure
The
that-
last I have is $6.50 per KW to fully eliminate.
Okay,
Thank you.
okay,
I will share my screen before we go back on the record to make sure that doesn't cause any
Right.
interference.
so we are going to stay off the record until we find out whether you can speak and have your screen shared, if that was the issue. All right, go ahead, Ms. Dingus.
Can you hear me now, Ms. Smith?
Everything sounds
You can.
just fine right now, yes.
Okay. Chair Duffy, am I good to, I'll just start where she indicated that I left off, and if there are problems, we can stop again.
All right, we are back on the record.
It would take a grid access charge of $6.50 per KW to fully eliminate the current subsidy. Instead, Evergy is proposing to apply gradualism and begin to make progress towards correcting the subsidy by setting the grid access charge at just less than half that amount. In the testimony filed by Mr. Gilliam on behalf of Sierra Club, CEP, and Volt Solar on remand, He essentially repeats all of the original testimony he filed in this docket and the 2016 generic docket. Evergy has already filed rebuttal testimony in response to his arguments and cross-examined him extensively, all of which is in the record. And the commission has already made findings on the majority of the issues he addressed, none of which were overturned on appeal. This includes the findings I mentioned a few minutes ago regarding the differences in the service taken by DG customers, the problems with the two-part rate, and the subsidy that exists in favor of DG customers. As a result, I don't intend to repeat my cross-examination of Mr. Gilliam today, and instead ask that the commission rely on the evidence and previous findings in the record on these issues, and focus in this remand proceeding on the question of how to best address the subsidy, given the fact that the nature of service taken by DG customers is different from the service provided to non-DG customers. One of the common themes among the speakers at the public hearing held in November was that implementation of a grid access charge will have a detrimental effect on the installation of distributed generation in Kansas. This concern is unfounded. First, as Mr. Lutz discusses in his rebuttal testimony on remand, this has not been Evergy's experience when we implemented the three-part rate for DG customers, initially approved by the commission in this docket in 2018, despite the fact that we heard the same argument from Sierra Club and public commenters during those initial proceedings. In fact, solar installation numbers have continued to increase significantly, even since the three-part rate was implemented over 28 months ago, and over the course of 2020 as well. Second, as Dr. Faruqi explained in his rebuttal testimony, solar installation rates have steadily continued to increase, even in other states that have adjusted their net metering policies in an attempt to address the subsidy issue. As an alternative to the proposed grid access charge, Evergy also included a proposal to implement a minimum bill of $35 for all residential customers, both with and without distributed generation. No party has suggested that the minimum bill proposal fails to satisfy the provisions of the Kansas Supreme Court opinion. Instead, Sierra Club and CURB raised concerns about the impacts of a minimum bill on low-income customers. As Mr. Lutz and Dr. Faruqi explained in their rebuttal testimony, these parties significantly overstate the impact of the minimum bill proposal on residential customers. The actual impact for almost 92% of non-DG customers will be less than $1 a month, and over 87% will not experience any bill increase at all. However, in order to address these concerns, Evergy has proposed in its rebuttal testimony to work with customers and not apply the minimum bill requirements to customers receiving low-income home energy assistance program funds or other similar bill payment assistance. Evergy indicated that it could make provisions for customer service representatives to override the minimum bill for a specific period of time if a customer would make a request and provide support for their financial need. As you think about the record that exists in this docket and prior dockets, the result in these remand proceedings that would not be reasonable and would be inconsistent with that record would be to revert DG customers back to the two-part standard residential rate, as suggested by Sierra Club and CURB. That result would contradict all of the evidence and commission findings, which are now final, regarding the different service being provided to DG customers and the cost shift that's occurring. Instead, as Evergy's witnesses have concluded, the best solution for addressing the subsidy the commission has already found to exist is to implement a grid access charge. This approach is consistent with the Kansas Supreme Court decision and Kansas law generally, and is supported by ample evidence in the docket and previous commission findings. As an alternative, Evergy requests that the commission approve a minimum bill for all residential customers with the modifications we proposed in rebuttal testimony. Thank you.
Thank you. Next, we will have Ms. Glenda Kafer for Pioneer, Southern Pioneer.
Thank you, Commissioners. I had a PowerPoint I submitted. Do I go ahead and do it on my computer, or do you pull it up there?
I believe you'll be sharing the screen.
I'll share the screen, okay. Can you see that?
Yes.
Okay, thank you. I represent Pioneer and Southern Pioneer in this proceeding, but as we did in our comments and our testimony, I will just refer to them both together as Pioneer. Pioneer wasn't a party to the commission's initial phase of this docket, and they weren't involved in the appeal. And they're not weighing in now on the issue of what Evergy's rates should be. Pioneer's interest is in DG rates generally, and the interpretation and application of the Supreme Court's decision just in that regard. Pioneer filed comments and reply comments, and they are presenting a witness in this hearing on that limited issue. Our witness is Mr. Rich Mackey, and our comments and testimony express these specific positions. First, the Supreme Court's decision addresses only residential DG rates and customers. It does not apply to other customer classes such as commercial or industrial. That wasn't before the Supreme Court. Secondly, the statutes at issue 66117D and 661265E only address renewable energy resources, and they only apply to renewable energy resources. Therefore, the court's decision interpreting those statutes can only apply to renewable energy resources. And we all, including myself, for brevity's sake, refer or just use the terms DG customers, DG rates, et cetera. But I think that while we do that, we need to keep that in the context of what the statute provides for and addresses. Third, the court found that different rate structures as between DG and non-DG customers are acceptable, but that 66117D prohibits utilities from charging DG customers a higher price than non-DG customers for the same service. So said another way, having different rates for different services subscribed to by a customer is not prohibited under this decision, even if the impact on DG customers is different than the impact on non-DG customers. Services taken by DG customers that are not taken by non-DG customers can include backup power that they need during unplanned outages, maintenance power needed during planned outages, supplemental power for when they're not generating enough to meet their own need, economic replacement power when the customer can buy it cheaper than they can generate it themselves, delivery associated with those services, export services where the customer sells its excess generated power to the utility or other purchasers, or storage type services where the DG customer can net out the excess power it generates at one time with the power it needs at a different time, which is in excess of what it can generate at that different time. So these are services taken by DG customers, but not all DG customers take all of these different services. When you establish the procedural schedule in this this remand in this docket, you did it in a way so that you allowed the parties such as Pioneer and Southern Pioneer to intervene and participate. You recognized that this case involves general DG issues that could affect all electric utilities and not just Evergy and Evergy's customers. So Pioneer has recommended in its comments and testimony that the commission use this opportunity to clarify that in the future, in order for a utility to successfully propose rates that impact renewable DG residential customers differently than non-DG residential customers, the utility needs to identify its distinct services that are applicable to the DG residential customer and provide support through evidence establishing that those services are different different or additional to the services that are being taken by non-DG residential customers. So on a case-by-case basis, the commission would determine if the utility had provided adequate evidence to meet that threshold burden and establish that the services are in fact different. And the commission would determine whether or not to approve the rate that was proposed for this different or additional service, the same way the commission decides now whether proposed rates are reasonable in regular proceedings, just by determining whether that proposed rate is just and reasonable. So that concludes my opening statement. Thank you.
Thank you, Ms. Kafer. Next, we have James Flaherty with Liberty Empire.
Good morning, commissioners. It's good to sort of see you again. The Empire District Electric Company appreciates the opportunity to participate in this hearing. As you recall, Empire provides retail electric service to just over 149,000 customers located in the four corners of Kansas, Missouri, Oklahoma, and Arkansas. And that includes about 10,000 customers in Southeast Kansas. Empire currently has 34 active DG residential customers in Kansas. Empire does not currently have a separate rate for DG residential customers in Kansas, but those DG residential customers are subject to Empire's net metering rider, which is based upon the commission's regulations relating to net metering. As Empire indicated in its initial comments that were filed in this docket, the commission, like it does in most of its proceedings, has a duty in this case to strike the proper balance of the various interested parties in this proceeding. Empire's interests are identified in those initial comments, but let me just briefly repeat those here. First, Empire does support adoption of policies that advance solar development. However, that advancement should not be accomplished by the creation of a rate design that results in non-DG customers subsidizing DG customers, or a rate design that makes it impossible for a utility to recover its cost to serve customers. The commission's adoption in this docket of a new rate design policy or philosophy that recognizes what I think most people would consider a logical premise, that utilities should recover their fixed cost through a fixed rate and their variable cost through a volumetric rate, not only solves the legal issue that was raised by the Supreme Court in this remand case, but also provides a rate design that will promote solar development while at the same time balancing all the interested parties in this proceeding. Empire does not have a witness to present during the hearing, but looks forward to the opportunity to asking questions of the witnesses who will be testifying in an effort to highlight Empire's position in this docket and to assist the commission in making its decision in this matter. Thank you.
Thank you, Mr. Flaherty. Next is KIC and Mr. Vincent. Good morning.
Good morning, Madam Chair, Commissioners. The core focus of this remand proceeding is to determine an appropriate rate design for Evergy Kansas Central's residential customers who use distributed generation resources. KIC believes limiting the scope of this proceeding to this issue allows for the exploration of important policy topics while preserving as much of this docket's approved non-unanimous settlement agreement as possible. Most of our interests lie in cost causation. Numerous proposals would require the use of regulatory accounts and would not be determined until Evergy Kansas Central's next rate case. In these instances, we believe these regulatory accounts should follow the customer class which created them. In the case of residential customers, if there are any revenue deficits or surpluses, let them be collected from or refunded to the residential customer class. We also have an interest in reducing litigation expense. We believe proposals like Evergy's grid access charge are worth exploring. However, we believe the grid access charge, as it's proposed in this docket, may only lead to further litigation and costs for our clients and for ratepayers. The record will show Evergy has attempted to design a neutral, non-discriminatory grid access charge. No doubt, a non-discriminatory rate for distributed generation customers is needed to address the Kansas Supreme Court's holdings. But a program neutral on its face may still be discriminatory in its effect. As we understand the grid access charge, we can foresee continued litigation if adopted. We look forward to building the record in this matter and bringing a degree of finality to these important policy issues. Thank you.
Thank you, Mr. Vincent. Next is Susan Cunningham, representing KEC, KEPCO, Midwest, and Sunflower. Good morning.
Good morning. Thank you, Madam Chair and members of the Commission. Again, I am Susan Cunningham, appearing for the KEC Group. And the KEC Group, as you just noted, consists of KEC, KEPCO, Midwest Energy, and Sunflower, all interveners in this docket. From our initial comments in this docket to the testimony you will hear from Mr. Douglas Shepard, the KEC Group has consistently argued that rate structures for distributed generation, or DG, customers can be different than those for non-DG customers when those differences are based on the utility providing a different service. Mr. Shepard's cross-answering testimony recounts the KEC Group's initial comments, noting 3 key ways in which the service provided to DG customers differs from the service provided to non-DG customers. First, DG customers are partial requirements customers since they supplement their own generation with utility supply. Second, the energy flow between the utility and the DG customer is bidirectional. That is, they import supplemental energy and export excess generation. And third, DG customers use the utility for virtual storage for excess energy credits, which they draw upon their generation does not meet their needs. Now, the KEC Group's position is consistent too with Commission staff's testimony presented by Dr. Glass, where he notes, staff agrees that Evergy provides a different service to distributed generation customers because of the dual importing-exporting behavior of the distributed generation customer. Additionally, following extensive examination of DG issues in docket number 16 GIME 403 GIE, the Commission found that DG customers may have significant differences in usage characteristics than non-DG customers. The Commission has the opportunity to preserve that distinction in the record here on remand. In the instant docket, Evergy proposes charging DG customers under a grid access charge rate design, or in the alternative, implementing a minimum bill rate structure. The Supreme Court was clear that a customer's DG status could not be the basis for charging them more than non-DG customers for the same service. We believe the grid access charge structure proposed by Evergy falls within the confines of the Supreme Court order and relevant statutes, as it is based on providing a different service to the customer. Evergy's alternative rate proposal, a minimum bill, is similar to a flat rate, which was specifically noted in the court's opinion as a possible rate design option as well. The Commission has the opportunity to address Evergy's DG rate, ensuring that 1, more appropriate and accurate price signals are being sent to the customer, helping DG or potential DG customers better gauge the economic value of investing in their own DG system. 2, inequities among customers are mitigated to a greater extent. And 3, action to address these key concerns happens sooner rather than later in the context of this docket. Thank you so much for your kind attention and for the opportunity to present the KEC Group's position.
Thank you, Ms. Cunningham. Our next opening statement is from Joseph Astrab with CURB. Good morning.
Good morning, Commissioner. Sorry if I'm waiting. I had to reach up in the meeting. Let me pull up my screen share and see if I can make it work as well. Can everyone see that okay?
Yes.
Great, thank you. We'll begin. Good morning. My name is Joseph Astrab, and I, along with Consumer Counsel David Nickel and Co-Counsel Todd Love, represent the Citizens Utility Ratepayer Board. CURB's primary duty is to advocate for all residential and small commercial ratepayers in obtaining reliable and efficient utility services at the lowest cost. As residential customers comprise the primary rate class that is being impacted by this docket, CURB places a lot of value in pursuing goals and positions that protect the most vulnerable of ratepayers, which include those with low or fixed income. It is these individuals who are the most affected by rate increases. CURB acknowledges that this is just one of many perspectives in this docket. The Commission is tasked with balancing the interests of ratepayers and the utility companies in its decisions. To that end, CURB believes that the Commission should be mindful of 2 salient points that came from the Kansas Supreme Court's opinion remaining this case back to the KCC. Pardon me, let me get my screen going here. First, the free rider problem identified by the company associated with DG customers' lower use of electricity may very well be a feature of the system rather than a bug due to the relationship between fixed cost and the variable energy charge. Evergy's proposals are designed with the goal of reducing and eventually eliminating this problem. But in accomplishing this objective, these proposals will have consequences that outweigh the benefits of increased cost recovery from DG customers. The second point is that the remand is based on the court's interpretation of the statutes made by Kansas legislators. It is not the court's role to determine whether the statutes represent good or bad policy. The ones best positioned to determine Kansas policy towards distributed generation are the policymakers themselves. They are the representatives of the people. If the level of public participation from the November 5th public hearing is any indication, it shows that the people are willing to be vocal about the issue. With the recent attention on these issues, the next legislative session is likely primed to provide some definitive guidance on the laws and policy of Kansas in this area. Some parties feel as though legislative action is not particularly reliable or expedient in this case. There are a number of pressing topics that the Kansas legislature is likely anxious to address. However, this should not discount the importance of legislative action as a whole. There is still time left before Evergy's rate moratorium ends. This provides ample opportunity for additional study to further refine rate design for all customers. Additionally, adopting a new rate design prior to definitive legislative movement risks pigeonholing advocacy efforts. Subsequent statutes could invalidate any new rate design from this docket and force parties to start again. To prevent such an outcome, groups may find themselves having to advocate for a specific position with more at risk. In any event, resolution of this issue for Evergy is going to require legislative input. Turning to the grid access fee, or GAF, CURB has concerns about the risk of conflict and litigation surrounding the GAF. CURB has highlighted a number of similarities between the GAF and the rejected demand charge, and other parties have thoroughly briefed the legal basis for implementing a new charge for DG customers. While CURB is not offering a conclusion about the legality of the GAF, CURB is weary of the risk of litigation and the possibility of a second remand. Rushing into a new kind of rate design while the cloud of litigation looms is not reasonable under the circumstances. Without additional legislative support, implementing the GAF at this time presents an undeniable risk for such an outcome and a further delay of progress. With respect to the minimum bill, KERB believes that this proposal unduly favors Evergy's interest in increasing fixed cost recovery at the expense of all ratepayers. This proposal, a first for regulated utilities in Kansas, fails to adequately balance the need to recover fixed costs from DG customers with the number of bills that may see an increase in the future. Evergy witness Brad Lutz explains in his direct testimony that the current proposal of $35 for a minimum bill would only be collecting half of the undercollection of fixed costs from DG customers. To fully recover these costs, a minimum bill set at $77 is required, says Evergy. And implicit in this observation is the notion that the minimum bill and also the GAF have room to grow. KERB witness Brian Kalsick has submitted testimony in which he evaluates the break-even level of consumed energy needed to accumulate a $35 and a $77 bill. Introducing a minimum bill rate design opens the door for a higher minimum bill as fixed cost recovery becomes more critical and the benefits of gradualism start to fade from Evergy's perspective. As the break-even level of energy consumption increases, so do the number of bills that see increases with no corresponding changes in behavior or service. This type of rate design risks raising the bills for non-DG customers who choose to use less energy for whatever reason. People who choose to conserve energy to save money every month may lose out on that avenue to help make ends meet. Evergy has not shown that it is at a point where its continued operations in Kansas hinged on improved fixed cost recovery from the DG class. Mr. Kalsick, in his direct testimony, further concludes that the increase in fixed cost recovery would likely need a proportionate rate reduction of fixed costs that are contained in volumetric charges. In turn, large energy users would start to see bill decreases, while those who fail to consume enough energy at the break-even level would see increases. The minimum bill risks increasing the cost of using electricity in Kansas during a time where legislators and regulators are looking to bring rates to a regionally competitive level. In light of the issues in this docket, KERB has provided a third option for the Commission to consider. Mr. Kalsick outlines KERB's proposal in his November 13, 2020 testimony, in which the Commission would, 1, cancel Evergy's residential standard distributed generation tariff, move all the RS-DG customers back to the company's residential standard service two-part rate schedule, and third, permit Evergy to track the foregone revenues that would otherwise be obtained from implementing a monthly GAF of $3 per kilowatt of installed DG capacity in a regulatory asset for potential recovery in Evergy's next general rate case. KERB's proposal has the potential to accomplish several objectives without the drawbacks associated with Evergy's proposals. First, it provides immediate relief to all current RS-DG customers who are paying the demand charge and places them back into the same rate structure as non-DG customers. This results in virtually zero risk of a discrimination claim under Kansas law. The costs associated with extensive litigation and possible remand are eliminated with KERB's proposal. Second, KERB's proposal is not intended to be a permanent solution. The short-term nature imposes little impact on the wider non-DG population with no change to their bills today. This also provides flexibility in the face of additional regulatory and legislative action. Whether the legislature authorizes different prices for DG customers is unlikely to impact the legality of the two-part rate design currently in place. If the legislature does allow for such pricing, the timing of it is likely to fall in sync with Evergy's next rate case. KERB's proposal is structured to make way for that next rate design mechanism without causing significant disruptions to the status quo on its own. And third, KERB's reference to Evergy's calculations for the GAF and revenue tracking provides a discernible amount of money that is up for recovery. This use of a regulatory mechanism does not differ far from Evergy's proposals. The restrictions of revenue neutrality on Evergy during the rate moratorium necessitates some degree of accounting to ensure compliance. Both the GAF and minimum bill will require the use of some kind of accounting mechanism to track differences in revenue between the newly approved rate design and the prior demand charge rates. The question of recovery in each of these three proposals differ only in amounts of revenue eligible for recovery. KERB emphasizes that the amount of revenue associated with the DG class in this docket are not tantamount to Evergy's immediate financial future and should be weighed against all the plethora of problems with the GAF and minimum bill as highlighted by KERB and other parties. Thank you.
Thank you, Mr. Astrab. Our next opening statement is from Mr. Bender with CEP, Vote Solar, and Sierra Club. Good morning, Mr. Bender.
Good morning. Good morning, Commissioners. My name is David Bender. I'm counsel of record for Sierra Club and Vote Solar. We're also coordinating, as the commission heard this morning, with Climate Energy Project. So these opening statements will be on behalf of all three organizations. We're here today because the Kansas Supreme Court reversed and remanded a discriminatory three-part RSDG rate. Supreme Court held that customers with generation, predominantly, if not exclusively, customers with rooftop solar, cannot be charged more for their electricity service than customers without generation would be charged. In response to the Supreme Court's decision, Evergy proposes two rate design options that are the subject of hearing today. Unfortunately, the first of those options, the grid access charge, repeats the problems that caused the Supreme Court to reject the three-part rate. The other option, the minimum bill, while not discriminatory, is terrible policy. It's halfway to a straight fixed variable rate that negatively impacts the lowest use and disproportionately the most vulnerable customers. At bottom, the remaining issues in this proceeding are based on a false premise that there is a subsidy specific to customers with rooftop solar. That is a common utility talking point across the country, but it reveals monopoly utilities' aversion to competition by customer self-supply. It lacks a factual basis, especially in this record. Evergy, and to some extent staff witness Glass, offer three theories for this so-called subsidy or cost shift. First, they argue that all residential customers are responsible for $77 per month in what they call fixed costs. Those are based on residential class-wide average of all demand and customer allocated costs. But under this theory, any customer who uses less than the class average kilowatt hours in a month receives a subsidy. This theory does not identify a solar customer subsidy. It identifies an alleged subsidy to about half of all residential customers. It also ignores the relationship between the timing and level of customer use to demand costs, including significantly lower demand costs caused by solar customers. During cost-causing summer peak hours, solar customers' generation reduces their contribution to demand costs by a greater amount than it reduces their revenue to the utility. Second, Evergy's witness, Dr. Faruqi, presents a calculation of an alleged solar subsidy under several different rate designs. This calculation uses two inputs: a revenue requirement representing solar customers' alleged costs, and estimated revenues based on assumed billing determinants. By using a cost estimate that is too high and a revenue estimate that is too low, he produces a false subsidy calculation. The revenue requirement from Evergy's 2018 cost of service study that Dr. Faruqi uses is not the approved revenues established through the settlement approved by the commission in this case. Recall that Westar's initial proposal and its 2018 cost of service study would have increased rates, but the commission approved a $66 million rate decrease in this case. Yet Dr. Faruqi's subsidy calculation uses revenue requirement from Westar's original proposal, not the one the commission approved. The fact that no class, not commercial, not industrial, not residential, returns the revenues reflected in Westar's 2018 application means that Dr. Faruqi's calculations, if applied to those, would show a subsidy for all classes. Additionally, he uses revenue estimates for DG customers based on Westar's unadjusted billing determinants rather than the billing determinants that the commission approved in the settlement, correcting Dr. Faruqi's too high revenue assumptions and too high cost estimates and too low revenue estimates eliminates the so-called subsidy. That's also consistent with staff's cost of service study filed in this case, which showed that Westar already overcollects costs from RSDG customers under a two-part rate. Lastly, staff witness Glass uses the three-part rates that the Supreme Court reversed as a measure of demand costs and compares those to single-month revenues from select DG customers in an attempt to show a subsidy. Dr. Glass claims that because there are some DG customers who would have paid a demand charge, but would not pay a kilowatt hour base charge during certain months, there must therefore be a subsidy. That analysis, though, conflates the illegal demand charge with cost causation. It ignores low actual DG demands during cost causing hours and applies a monthly match requirement between costs and revenues that is not applied to any other class. Contrary to what some parties have stated already this morning, what they stated in testimony, we do not take the position that DG customers have no differences. There are some degrees of difference, but those differences result in lower costs to serve DG customers. Applying a neutral analysis to the actual load data in this case confirms what staff's cost of service study told us more than 2 years ago. There is no subsidy to solar customers. But even assuming for sake of argument, despite the record that there were a subsidy, the grid access charge paid only by DG customers is virtually indistinguishable from the demand charge that only DG customers paid and that the Supreme Court reversed. The company's minimum bill alternative increases bills for tens of thousands of non-DG customers, disproportionately impacting low use and other vulnerable customers, and only increasing revenue from a few hundred DG customers. It'd be disproportionate response even if there was a small subsidy to DG customers. The utilities proposals in this docket are either illegal or bad policy in search of a problem that does not exist. The commission should accordingly reject both of them and instead set the RSDG rate to the same rates as RS customers pay and require Evergy to refund any over collection of charges from DG customers while they collected the illegal 3-part rate. We also propose the commission allow the utility to defer any revenue deficiencies that can be calculated for recovery in a future general rate case. Thank you.
Thank you, Mr. Bender. Our final opening statement is Kansas Corporation Commission staff, Carly Massenthien. Good morning.
Good morning, Chair Duffy, and good morning, commissioners. I'm going to go ahead and share my screen here. Okay. My name is Carly Massenthien, and I represent staff in this matter. Since joining the commission, I have often heard the phrase, rate design is a balancing act. I cannot think of a case that exemplifies that sentiment better than this one. Today, our task is to provide evidence so the commission can choose a rate design for Evergy Kansas Central's distributed generation or DG customers that balances the interest and contributions of both DG customers and non-DG customers. The rejected 3-part demand rate was implemented in an attempt to provide a more equitable capture of costs created by DG customers' activity on the electric grid. In docket number 16 GIME 403 GIE, the commission found that DG customers were not paying enough in rates to fully recover the costs they placed on the grid. The effect of this was that non-DG residential customers were paying beyond their own costs to make up for that disparity. To quote, the commission finds DG customers are thus being subsidized by non-DG customers. The commission reiterated this finding in the prior proceedings in this docket. In its order approving non-unanimous stipulation and agreement, the commission explicitly found that Westar's current 2-part rate for DG customers is problematic because it results in a cross-subsidy from non-DG customers to DG customers. The commissioners are finders of fact, not the Kansas Supreme Court, and the commission's finding of this fact was not challenged on appeal and is not at issue in this remand. Today, you may hear distractions disguised as claims that the subsidy does not exist, or that it would be acceptable to place DG customers back on the 2-part residential rate. Yet the commission has found the subsidy to exist, and now we must move forward to choose a rate design that addresses that subsidy while remaining within the bounds of KSA 66117D. The fact that the distributed generation advocates are still denying the existence of a subsidy is a disregard of the Commission's prior finding of fact and an inappropriate attempt to relitigate a decided issue that was never raised on appeal. As such, it is not appropriate to return DG customers to the two-part rate. The primary focus of today's proceedings should not be to entertain ideas of returning to the previous rate structure or to relitigate the existence of the subsidy. The issue before us today is very narrow. The primary focus remains to establish evidence to support a rate design that best balances mitigating the established subsidy while remaining within the mandates of KSA 66117D. This brings us to two potential solutions to be discussed over the next 2 days: the grid access charge and the minimum bill. The grid access charge is a fixed monthly charge based on the installed nameplate capacity or the theoretical maximum generation possible of a customer's distributed generation system. The court determined that charging customers differing rates for the same service violates 66117D. Proponents of the grid access charge argue that because DG customers receive an additional service and because the GAC will show up on each customer's bill, albeit with a charge of $0 for non-DG customers, that they are not charging customers different rates for the same service. Yet staff believes this rate design looks too much like the rejected demand charge. Although non-DG customers will see a charge on their bill, only DG customers will see that charge rise above $0. Staff sees this option as having the potential to lead to further litigation and place us in this same position, still litigating over the proper rate design for DG customers a year from now. Turning to the minimum bill, this option's implementation is based on the customer's average kilowatt hour usage per month. If a customer uses less energy than the minimum bill threshold of 278 kilowatt hours per month, then the customer pays the minimum bill of $35. If the customer's bill is already greater than the minimum, the customer will pay his or her regular bill. Thus, the minimum bill only affects customers whose bills are already less than the minimum bill, or those who use less than 278 kilowatt hours of energy per month. And to put that into perspective, Evergy's average residential customer uses 853.5 kilowatt hours of energy per month. Staff ultimately supports the implementation of the second option, the minimum bill, with modifications to minimize impact on low-income users. As seen in filed testimony, both staff and Evergy have already proposed ways to mitigate the impact of a minimum bill on low-income users. The minimum bill both mitigates the subsidy and, because it results in the same fee to all residential customers regardless of DG status, it is clearly within the bounds of KSA 66117D. All things considered, staff believes the minimum bill is the most straightforward, fair, and balanced option for rate design. KCC staff are first and foremost public servants. Our main goal and role is to balance a multitude of interests, always keeping in mind that while rate design is complicated and rarely is it perfectly equal, the end result must be fair and not unduly discriminatory. Staff believes the minimum bill is the best option to satisfy that goal. Staff appreciates the opportunity to work with all of the parties to correct the perceived violation of 66117D and appreciates the opportunity to provide information on the subject at issue so that the Commission is able to make a decision regarding which rate design is most appropriate going forward. Thank you.
Thank you, Ms. Massantine. We will now begin with the witnesses, and Evergy, if you will call your first witness, please.
Yes, thank you. Evergy calls Brad Lutz.
Good morning.
You want to raise your right hand? Do you solemnly swear that the testimony you're about to give and the cause now pending will be the truth, whole truth, nothing but the truth, so help you God?
I do.
Thank you.
You're welcome.
Can you please state your name and business address for the record?
My name is Brad Lutz. I work for Evergy at 1200 Main in Kansas City, Missouri.
And did you cause to be pre-filed in this docket 14 pages of direct testimony on remand with 3 schedules and 21 pages of rebuttal testimony on remand?
I did.
Do you have any corrections to that testimony today?
I do not.
And if you were asked the same questions today under oath, would your answers be the same?
They would.
I would ask that the testimony and exhibits be admitted into the record and tender the witness for cross-examination.
Thank you. Seeing no opposition, it is accepted. Okay, cross-examination. Pioneer, I believe you're first.
Yeah, thank you. Good morning, Mr. Lutz.
Good morning.
I'm so sorry. Commission first. Okay, Pioneer, go ahead. I'm sorry.
No, we have commissioner questions for, I don't know if Commissioner Keene or Commissioner French wants to begin. Sorry for a cross examination.
Okay, right. I'm not seeing anybody speaking up at this point.
I'm happy to jump in.
Oh, I'm sorry. Okay, thank you. Commissioner French, I apologize.
I will say I'm used to the commissioners going last, and maybe that's maybe that's the more prudent approach to let others go first and ask the better questions. But maybe I'll ask a few, and then I'm certain I'll have questions after the parties ask questions.
Absolutely.
Good morning, Mr. Lutz.
Good morning, sir.
This is an interesting case. And certainly the Supreme Court has given us a lot to think about. I think, the first thing I wanted to talk to you about is I'm trying to get a handle around sort of the size of subsidy as we have it right now. If you accept that there is a subsidy flowing here, and obviously if there is a subsidy, we would certainly be concerned with any subsidy where it flows from lower income customers to more affluent customers. So I think we do need to get a handle around what's happening. As I look at page 10 of your, I believe it's your direct testimony. I'll let you pull that up.
I am there.
And I'm looking down at the bottom. Let's see, it'd be line 20, I think is where you identify it. It looks like you identify a number of $205,000, $491.60 of revenue. And do I understand correctly that may not be the total level of subsidy that you're identifying, but that is sort of the level of subsidy that at that time you were calculating that the grid access charge would solve for?
Oh, no, I wouldn't say it that way. Actually, the determination of the grid access charge itself was based on the subsidy amounts, but the application of the charge then in turn to the growing customers produces this amount of revenue.
Okay.
So there's a timing issue really behind the data that's used that's supportive and from our last general rate proceeding versus where we sit today. So there's kind of a mismatch between the two.
So at the time you calculated it, that was the level of subsidy, but based on DG customer growth, it's going to produce potentially less, but probably more revenue.
Well, and depending on how you look at it again, in the general rate proceeding, if you were to recalculate all of the numbers and within that proceeding, you're likely to get a different number on the subsidy amount. For this proceeding, the calculation of the grid access charge embeds some of those numbers that we measured largely at the 2018 timeframe to set an initial charge, and that's somewhat behind the idea of using the gradualism approach and trying to just create a starting point for the charge, and then allow it to roll forward into the normal rate making cycles where it can be calculated more precisely relative to other costs and other revenues. But this number in line 20 is just reflective of the grid access charge applied to the DG customers known at the time of the 2019 DG report that we offer in the state of Kansas.
Okay, that makes sense. So what I'm trying to get at here is your view of what the materiality of the subsidy is, and it's not a trick question in any sense. I'm going to share my screen real quick, and what I'm going to share is this is just the most recent Evergy annual report. It's the 2019 Evergy annual report filed with the SEC, and I'm going to go to. Can you see it on your screen there?
I can.
Okay. I'm just going to go to, this is the Evergy Kansas Central Inc. Management's narrative analysis of results of operations. And really all I'm pointing to here is these are your revenues collected from the various retail customer classes in 2018 and 2019. And as I look, can you see it, the highlighted items?
I do.
Okay. And do those numbers look, roughly correct within your experience of what was collected as revenue from those classes?
Sure, I accept that.
Okay. I guess where I'm going here is, I look at the $205,000. And I calculated out that that's about 0.025% of the $794 million that you collected from residential customers in 2019. And it's only about 0.01% of the $1.925 billion that Evergy Central recovered from all your retail customers. And it's not a trick question, but I just would like to get your take on, those seem like very small percentages to me, almost impossible to pick up in a class cost of service as to whether those percentages are or are not a subsidy. And I'd just like to get your take on, when it is such a small percentage of the overall revenues that are collected, why do you or the company believe it is a material subsidy that there's a pressing issue to solve?
Yeah, and I appreciate you shifting from material to pressing, because I would agree. I would agree that if you measure this entirely around the idea of materiality, that's a more difficult measure for sure. But it is still a pressing issue, somewhat accentuated because of the timing of the legal challenges and the things that kind of have brought this back to the forefront. But certainly, I don't think anyone will disagree that it's a problem that will continue to grow, and that we're afforded an opportunity here to catch it early and try to establish some sound rate making and sound policy at a time when that materiality may be smaller. If we gain from the experience of others and look to the jurisdictions where they waited or they reacted, like in, say, maybe in the Arizona or even California jurisdictions where penetration levels are much, much higher. I imagine you could find folks that would say, if we could go back and get it earlier, that would have made sense. I mean, that just logically, if you can, alleviate problems based on, simple observations of others' experiences, it makes sense to try to address this now. So it's important, it's pressing, but I would agree, it's not a material item towards the company's revenues at this time.
Okay, thank you. I do appreciate that answer. I mean, it really genuinely is not any sort of trick question. It is just trying to understand the company's viewpoint of why we need to address. So that is very helpful. I'm going to go into another issue, and perhaps this is legal in nature, but to me, 90% of the issues in this case are legal in nature. And so if you have any discomfort in answering, I'm happy if you want to defer that to council or defer it to briefing. But as I went back and reviewed the history of this docket, I reread the record in the 16403 investigation. And I looked at that final order, and the commission pretty clearly found, and I'll read a quote here. The commission finds DG customers should be uniquely identified within the rate making process because of their potentially significant usage characteristics. And then a couple paragraphs later, the commission found the current two-part residential rate design is problematic for utilities and residential private DG customers because DG customers use the grid as an electric grid as a backup system, resulting in their consuming less energy than non-DG customers, which results in DG customers not paying the same proportion of fixed costs as non-DG customers. And then I think in the next paragraph, the commission said, because of those distinctions in the ways that the DG customers use the Evergy grid, the commission found either a demand charge or a grid charge would be appropriate. And then the commission went on in this docket, I suppose, in a long time ago, to find that three-part rate with the demand charge would be appropriate, and citing back to those the rationale in that 16403 docket. So it would be your position that we established in the 16403 in this docket that the DG customers have different usage characteristics and take a different type of service than standard residential customers, correct?
Correct.
And it would be your position that that's the distinction, that distinction in the character of service is what allows us to apply differential rates to those customer types.
Yes, I do.
Okay. I want to look at page 9 of your rebuttal testimony.
I'm there.
Okay. And at the top of the page, you cite to Mr. Mackey's testimony in this case. And I want to just say I really appreciated Mr. Mackey's testimony because I thought he did a good job of laying out, at least trying to forge a path forward of what are the standards that we should use. And he says here, in the middle of that block quote that you have for him, I guess at line 9, he says, accordingly, the commission should make a finding that in order for a utility to propose rates that may impact DG residential customers differently than non-DG residential customers, it must identify its services provided to DG residential customers and how they are different from the services it provides to non-DG residential customers. And then he goes on to say, commission would have authority to design a rate. And I guess my question here is, let's ignore what the Supreme Court said. Do you believe that throughout the 16403 docket and this 18328 docket, that I guess, would you agree that the commission did do that for the demand charges?
Yeah, I would. In my opinion, I think when it moved up the courts, I think the issue became more focused on the application of the rates than the question of service. If I recall the commission, or excuse me, the court's opinion, there's very little that talks about the service. I think they just kind of make maybe a couple of sentences about it, but all of the focus is on the application of the rate. And it's my opinion that a more direct approach, somewhat like exactly what Mr. Mackey has laid out here, would help set a better perspective for the record, and also would help alleviate some of those concerns as if this were to go back up through the courts again. It would set up a better scenario where the rate could be better justified.
Okay, I appreciate that answer. I mean, I think it's pretty obvious what I'm getting at here, and I'm not I'm not leaving any mystery. I'm grappling with the difference between a grid access charge and a demand charge, and whether or not I would have applied a demand charge in the first place as a matter of policy, I don't know. But I tend to think that we met these standards, or the commission met these standards at the time, and so I'm grappling with why, if that is unlawful, why a grid access charge is lawful. And I think you have provided some distinction to me. It sounds, I guess the question here is what you're saying that really there materially isn't any difference. It other than the more direct identification of the different service.
Right. Right, and the application of the charge to the service, that before the demand charge chose to go through the customer's measured demand in the application of it, where in the grid access charge, it looks at the customer's installed generation capacity. Okay. So in a way, the customer or the grid access charge is more focused on the cost causation driver than the demand. I think they get to the same place, and maybe that's where you're seeing a lot of the parallel. But I would say the grid access charge is a little bit different in that approach. And certainly, I do believe that the key part is the substantiation of the different level of service. That's the key part that would make this approach ultimately more strong in a legal challenge than the demand charge was.
And you brought up the cost causation. I want to one piece of testimony that made some sense to me from Mr. Gilliam, and I guess I want to get your take on it, although I think you do address it in your rebuttal testimony. If I understand correct, he takes issue with the fact that the purported reason for the grid access charge is the additional cost of providing that two-way service in how they push a DG customer would push power onto the grid, and that causes additional costs that you need to recover through the grid access charge. And I think his criticism is yes, but the grid access charge is not recovered or calculated on the basis of those incremental extra costs. It's calculated on the basis of the existing, fixed grid costs that everybody incurs. One, is that your understanding of his criticism? And two, is that a fair criticism?
It is my understanding of his criticism. I don't know that it's necessarily fair. I mean, this is one of those, to me, and when you get into the rate design realm, and especially in the class cost of service realms, there are alternate views that mathematically or logically are sound, but it starts to come into a judgment of application, context. All of those kind of things have to start to factor in to differentiate between what are largely mathematical sound perspectives. So in this regard, I don't agree. I mean, I think that the class cost of service approach provides a very reasonable place for us to start with that rate making and the identification of the subsidy attempts to give a very structured scale to what we're trying to accomplish with these rate designs. It takes into account the embedded approaches that we take in our general rate making. I fear some of the things that Mr. Gilliam offers moves into like marginal costing and some things that we just traditionally have not done in a rate making point of view. So, while I can respect his opinion, I disagree that it applies here.
Thank you. Just a couple quick questions about minimum bill, and then I'll let the professionals take over. Or, well, I guess we'll let the other commissioners go.
Correct.
On minimum bill, I have to admit, when I first was looking at this issue, I made, I guess, sort of a dumb mistake of conflating the concept of a minimum bill with the concept of a customer charge. And so my first thought was, gosh, this seems pretty harsh. 141% increase to the fixed customer charge. But now, as thinking about it and understanding it better, I understand. No, it's not. That's not really what's happening here. And it strikes me that the $35 minimum bill is much less harsh than the large increase to a customer charge. Is that correct? And if it is less harsh, why?
Well, I mean, first of all, the concept of a minimum bill is not necessarily foreign, even for Kansas. We both Evergy companies, Central and Evergy Metro, have minimums today, but they happen to be set at the customer charge level of $14.50. So what this is trying to do is to add on to that the minimum that we think we need to address the cost shifting, or at least our gradualistic approach towards that, on top of the customer charge amount of $14.50. Which is historically been set to capture a very specific set of charges, mostly around meter reading, customer service type things. So we've historically tried to keep that charge very focused, where this minimum bill would append to that additional costs that represent some of those demand and other services that we're providing to customers that we need to get that recovery as well to cover that cost shift.
Couple things more on the minimum bill. I do still have, I think probably everybody has heartburn as to the impact that this might have on small users, low income users that are really trying to control those costs and maybe do normally have bills under $35. I appreciate your response to staff's concerns and your testimony. It strikes me, though, that the response is still pretty general. It's still sort of, we'll figure it out. And I just wonder, has the company talked about, if this was a path we were to go down? I know from my perspective, I think we need more details and maybe tariff filings. How would you foresee the implementation of that?
Okay, there's a couple questions in that. The first one, if I may, I want to go back to the low income element, because that is certainly a puzzle, to all rate making. And, especially under many of the pressures we're under today, it's even more accentuated. But from my experience, trying to identify what does a low income customer look like, or what does it represent, is terribly elusive. It's not a cookie cutter result in any way. In every effort that we've ever tried, from mathematical efforts to anecdotal efforts, you just see everything that kind of fits in that category. You could have a low income individual who, to the testimony that's in this proceeding, has a very small bill. Absolutely. But we can also find many examples of low income where multiple families are cohabitating in a home and their bill is much higher as a result. and they're just as low income as that single individual. So the measurements and the attempts to identify low income is so difficult. And in part, that's why we chose the resolution to the minimum bill that we did, where in some part, the only way to be certain is to have them self-identify, and have them come to us and say, hey, I fit this model, I need help, or I need to be able to avoid this charge. And we're willing to go there. I mean, because that's perfect. That's when you address the need most specifically. Otherwise, I think you run the risk of misapplying or taking the wrong policy step because you're working off of a presumption that's not necessarily true.
So are you? Sorry.
Go ahead.
So
No, go ahead.
you're thinking perhaps there could be an application process that you publicize that allows people to apply for an exemption from the minimum bill for their account.
Certainly, that's what we've offered in our rebuttal testimony to staff. I appreciated Dr. Glass's idea of the dwelling type. That would have been a pretty good start. But unfortunately, just a couple of things came to mind on those that made that less than perfect. And I addressed that in the rebuttal. But this self-identification path would go a long way to remove those uncertainties or the unintentional consequence of some kind of a broad brush approach around the minimum bill.
And the only other question I'd have on minimum bill is I guess another sort of unintentional consequence. I assume this would apply to all standard residential accounts, but I mean, would there be any account types that are, largely inactive or routinely use, little to no energy every month that are going to get swept up in this and might create sort of an unjust result? Have you talked about that?
Well, I did in my rebuttal. The word that you used at the end, the unjust, is probably the one I want to speak to a little bit. But certainly, what we've observed is we certainly have a number of residential accounts that are potentially garages or outbuildings, or what's most predominant are apartments that are empty or homes that have been empty, that have not sold or for whatever reason are just standing empty. So yes, those types of homes or situations would see quite a considerable change. Now, whether that's unjust, I'm not quite as certain about. I mean, for example, many of those, like let's say a garage, it might be idle for days and days, but maybe on the weekend it gets a lot of work or lots of usage.
Sure.
So I mean, just due to the nature of them being connected to our systems and relying on those systems, I think it starts to support the idea that they should contribute to the cost recovery more fully than just to pay the customer charge. And because the minimum bill amount is so low at the 278, the equivalent of about 278 kilowatt hours, that does not seem to be out of line for buildings and situations of that type, where you've got those empty or largely unused accounts. Are there others? Certainly. I mean, that's the one thing that you can count on from the residential class is that there's always something out there that's, distinct. So we can probably find you examples of everything under the sun, but those are the ones that we probably anticipate the most of and being more impactful.
Okay.
Particularly when you look at the overall impacts to the class, those really tend to draw down or I don't know, sway the calculations of averages or presentations of numbers. Okay.
Well, I guess, and it raises the question for me. I mean, you talk about that, it's perhaps people's responsibility, to see that they have a vacant building or an unused building, and if they're connected to the grid, they're going to have to pay it. Is there a concern that there's a material number of those buildings or accounts out there right now. And yeah, they've been paying the customer charge at $14.50, but once you bump them up to a minimum bill of $35, you're going to get a wave of folks that say disconnect that building. I don't know if that's a material consideration for you or not.
Well, I mean, it could be. Again, back to your approach earlier, if we look at the total number of residential customers, I'd have to believe that percentage would be small. Otherwise our usage in the residential class would be much lower. I mean, our average in the residential class is around that 850 kilowatt hour a month. To me, that's representative of a larger number of true users, I might call it, than those extreme cases where there's kind of an empty site. To be fair, I mean, we're more than willing as this goes on. If we observe things happening, we can work with staff, work with CURB, others to adjust and respond as these, roll forward. I hope that was clear in our testimony that we don't have 100% of the answers on every potential impact of this, but we're given, quite a challenge to try to address something. And now is the time to do it. So this, we feel, is a good gradual approach to start the discussion, to apply a charge that's balanced and reasonable, and then grow from it.
Thank you, Lutz. Mr. Lutz, I appreciate your thoughtful answers. I'll turn it back to my fellow commissioners.
Thank you.
Thank you, Commissioner French. Commissioner Keen, do you have questions right now?
I do indeed. Good morning, Mr. Lutz.
Good morning.
Can you hear me all right?
Yes. I can.
All right. By way of overview, it strikes me that this remand from the Kansas Supreme Court really presents the commission with several tasks. Ideally, I would think that the result of this process would be a residential DG rate design that simultaneously does several things. First, it would, I think, encourage energy efficiency. It would be a design that would not deter the development of solar, residential solar. It would provide solar customers with the opportunity to utilize their solar investment. It would allow Evergy to receive a lawful authorized rate of return. It would not disadvantage Evergy non-solar customers. And to cap it off, I think it would be a design that overall would be fair and equitable and in the long-term public interest. Nothing to that, right? So with all of these tasks to reconcile, it strikes me that this proceeding on remand presents some very challenging and potentially difficult balancing propositions. Mm-hmm. As a result, my cross-examination is going to be primarily examination not only of yourself, but of all the other witnesses that come before us in this matter. Is going to be primarily focused and directed toward fact-finding. And if I can paraphrase one of my favorite fictionalized TV characters, the Dragnet detective, Sergeant Joe Friday, which probably dates me way beyond most participants this morning. He was fond of saying, "I'm after the facts. Please just give me the facts." Mm-hmm. I'm going to encourage you to do that, but I would encourage you to certainly, you can mix your opinion with the fact. I would expect that. But what I'm looking at is letting the facts lead the way. That's really what I'm focused on. Mr. Lutz, my first question, and I don't mean to be at all redundant. I think the questions posited by Commissioner French were excellent, but I'm going to take maybe a little different tact in asking similar questions, and I appreciate your indulgence of that. My first question would be this, and it's kind of a three-parter. Within the context of residential electric rates, if solar and non-solar customers pay identical rates, in your opinion, is there the potential for an economic free rider or subsidy problem? the second part of that question would be, if you believe that that is the case, please describe how and why that arises or occurs. And the final part of this three-parter is, in your opinion, did the Kansas Supreme Court, in this particular matter, in this instance, did it acknowledge the existence of this circumstance?
Okay. The first answer is yes. I do believe that under an identical rate, a subsidy and cost shift occurs. And I think that we have observed that most directly through the historic two-part rates that DG customers were under early on. I want to say prior to, say, 2016, maybe 2018, but in that range. The point being that under that rate design and how it occurs is through the consideration of the net metering process and the generation of excess energy. The net metering effect and the potential for excess create the situation where the DG customer is able to avoid payment of charges levied under those identical rates. So although the rates are identical, the nature of their service is different and results in a different revenue outcome in that scenario. So the third part on the Supreme Court element of that, our court reporter is unhappy.
Our court reporter is, is it the same situation, Ms. Smith? You can't hear us? All right, you need to unmute.
It looks like she was in our waiting room for a moment and I just admitted her. So I don't know if she got knocked off the feed or not. I'll let her speak. That may be an issue.
I did. I have missed part of this. I don't understand what happened. It's very frustrating, but do I understand that this is being on YouTube so that I can go back and fill in what I have missed? Or do we need to have me show you where I stopped and we have to repeat?
Mr. Fedotin, is that correct that it is on YouTube and being recorded?
It is being recorded, but I would suggest out of an abundance of caution to go back and get the transcript just in case there's any issues with the recording. But so.
Okay.
So
it's been a while because I had to re-log in, go to the thing. I mean, it's been a while.
Was it before Commissioner Keene started asking?
Yes, I did not. I don't have Commissioner Keene at all. But I can go back. If that YouTube's there, I can go back and know exactly what, follow along on my transcript, see where I ended, and then record and insert that in the transcript so the transcript can look totally normal.
It should be there. Is somebody from IT able to confirm that we do have a valid recording?
Michelle?
It's up and running, and it is recorded too. I don't know if, well, I don't know, on a lunch break, she could probably go back, but we can always go back to it later also.
Yeah, we should have a Zoom recording and it should be on YouTube.
All right, with that, I feel comfortable in that I can put this together in one transcript.
Okay, and just for why don't we start with Mr. Lutz's answer to the three-part question. And after Commissioner Keene asks questions, I think we will take a break, okay? Just so everybody knows. Does that work for you, Ms. Smith?
Yes.
All right. Okay. All right. Thank you. If you will resume and just repeat your answer, Mr. Lutz.
So back to the first part of the three-part question.
Mr. Lutz, if I could interrupt briefly, if we're going to be able to use the Zoom recording plus the YouTube recording to get us to where we are right now, I think you were answering the third part of my question, having to do with whether you believe the Supreme Court in this instance acknowledged the existence of this, whatever you want to call it, a free rider problem or a subsidy.
Right, you're exactly right. So yes, on that third part, I believe yes. And in my rebuttal testimony, I spoke to that just a little bit. I respect the position that Mr. Gilliam took about the actual words that were used in the excerpts that mentioned free rider. Certainly the court was, I don't know if it was purposeful or if it was just careful or what. I can't speak for why they did what they did in those particular sentences. But I can say through the course of the opinion and my understanding of the proceeding, I think that yes, I think that they accepted that there was a free rider issue and that still had to be resolved as part of the remand back to us. And I think that's why they offered some of the examples that they did as far as the potential rate designs that they thought might work, because those did in some way address that concern. So I have to believe that if they thought there was no concern, they would have offered very different rate design approaches in their examples.
All right, thank you for that answer. Actually, your answer is a segue to my next question. And what I'd like to do is if we could turn to the Supreme Court opinion, if you have it there. I have the slip opinion. I'm looking at pages 12 and 13 of the opinion.
Okay. If you'd like go ahead if you'd like, if you're going to read from it. Otherwise, I need to find it. I don't have it on my screen.
Okay, well, I'll help you out, hopefully, with the question then.
Okay, thank you.
If we look at page, as I say, 12 and 13, on page, first on page 12, and then on 13, the court identifies several alternative rate designs or structures that, in the court's opinion, satisfy KSA 66-1265E for authorization for use with DG customers. On page 12, it takes up time of use rates and minimum bills. Moving on over to page 13, it discusses flat fees charged to each customer hooked onto the grid, as well as sliding scale rates with further description of time of use rates. And it's interesting on page 13 that the middle paragraph there begins with this statement. And I quote from the Supreme Court. We can think of several ways the utilities could attempt to reduce or eliminate their economic free rider problem without creating a regime of price discrimination. To me, that's a pretty direct statement. Okay. Here's my question to you. From among all the alternatives, especially those that the Supreme Court tends to indicate would be acceptable, Evergy is now recommending that the commission adopt the grid access charge, or as I understand it, as a fallback in the alternative, the minimum bill. So let's look at the grid access charge first. In your opinion, how would this grid access charge differ from the demand charge that the court found to be unlawfully discriminatory?
The charge is different in a couple of ways. The first being is that it's applied against the actual generation source itself, as opposed to the demand measured by the meter. So that's one of the characteristics that is different. But to answer your question, I think, as I interpret your question, I think the part of what would make it different would be how it would be presented or approved by this commission, and how it would be necessary to recognize the type of service received under that rate as the support for it, that would make this charge ultimately different than what the Supreme Court opined on with respect to the demand charge.
All right. To that end, if we could turn briefly to the Southern Pioneer slides that were proffered this morning by Ms. Kafer. And I'm looking particularly at, I think, which was page 3 of those slides.
Okay. I admit I do not have those.
I should be able to share the screen if you give me a second.
Okay, please.
Can people see?
Yes.
Yes, it came up, Brian.
Yes. Yes.
Page 3, if you would.
Thank you.
You're welcome.
Mr. Lutz, do you recall this page when Ms. Kafer reviewed it this morning?
I do.
In a nutshell, is this a partial or complete list of maybe the distinctions that you think would make a difference in distinguishing the demand charge that was considered discriminatory with the grid access charge you're now suggesting?
Yeah, these are the types of services that are different. Yes, I think that it is a broad. I hesitate to say all inclusive, but I think it captures the main areas of concern around the different type of service that we believe is provided to a DG customer.
And do you believe these are distinctions with a difference that would take the grid access charge beyond the offending or discriminatory aspects of the demand charge?
Yes, I think in characterizing and asserting that the service level is different, then an approval of the grid access charge would withstand the Supreme Court's opinion around those statutes. Yes.
All right. If we could turn to, first of all, your direct testimony, please. Pages 7
Commissioner
through
Keene,
10.
if I may interrupt, this is Brian Fedotin. You may want, for the purpose of the transcript, to mark either that page or the slides as an exhibit. Just
certainly.
To be sure we have it clear.
I would suggest that this be introduced as Evergy Exhibit 1.
The slides or just page 3?
Just page 3.
Okay, so any objection to that? Seeing none, it is entered. Commissioner Keene, do you have more questions?
Oh, I do. I appreciate your indulgence.
No, please go ahead.
Yes, if we could, Mr. Lutz, let's turn to your direct testimony. If we could take the slide off the screen, Michelle, thank you. Pages, I believe I said 7 through 10.
I'm there.
All right. And I'm looking with some particularity here at basically the question posed on line 8 and your answers from line on page 10. Let's take a look at lines 8 through 22.
Okay, I'm there.
All right. Coupled with basically the pages 7 through 9 that were a lead into this, it strikes me that this these pages basically provide an explanation of the grid access design that you anticipate or that you're advancing be approved. Am I correct in that?
Yes, I would agree with that.
And if we look at back to page 10 again, with some particularity here, lines 8, which is the question, and then your answer 9 through 22. This strikes me as your attempt to provide some level of granularity and detail about what you anticipate would be the customer impact of the grid access charge.
That is correct.
Am I correct? Mm-hmm. And so help me through this. Help me through this.
Okay.
If you would, for the benefit of everybody, especially those who don't have access who are joining us here and don't have access to the specifics of what I'm referring to here, if we could focus first on lines 9 through 15, what's the essence of what you're saying here?
Yeah, the essence of what I'm saying is that I tried to rely on, or I did rely on, the 2019 compliance report that Evergy Kansas Central files to document its net metering customer base. And to me, that was the most public and readily available data source for what would be a typical impact. So of that report, we had 833 residential customers that were on that. And in that report, we're able to know the installed capacity of each customer's DG system. And so based on applying our $3 per kW charge to that list of customers, we developed the averages that you see on line 13. That is the average impact experienced by that population of customers. And then going on, I identify the lowest, smallest system and also the largest system within that list of 833 customers. And I generate or calculate the grid access charge for each of those scenarios to give you the upper and lower bound to what the impact would be for that population.
Okay. Again, for the benefit of those who are listening here, and I think for the benefit of the record, with your indulgence, I'm going to read lines 12 through 17 because I think it's consequential. Beginning on line 12, I quote, it says, if calculated as proposed, the average monthly charge resulting from the grid access fee would be $20.56 per month or $246.69 per year. That's the average. It goes on. Back to the text. Using the smallest residential system DG capacity on record, the minimum amount of the grid access charge applied would be 57 cents per month or $6.84 per year. Continuing on line 15, using the largest residential system DG capacity on record, the maximum amount of the grid access charge applied would be $176.40 per month or $2,116.80 per year period. Mr. Lutz, did I accurately portray what is your testimony on page 10 of your direct testimony?
You do, sir.
So I guess my question now would be this, so that I can maybe more holistically understand your testimony correctly. Under the proposed grid access fee, the minimum monthly bill for residential DG customers is not an established or fixed amount, as would be the case in the minimum charge. There's no fixed amount that would be like $35. Is that correct?
That is correct.
Is it also correct that the minimum monthly bill could potentially be less than 20?
Certainly, yes.
And indeed, in the one instance which you're showing, using the smallest residential system as a method of calculation, it could be less than $10 per year.
And yes, and that is for the charge itself. Now, in this particular case, our other minimum, our $14.50 minimum, the customer charge
Yes.
that's in our current tariff would have to be paid. So this is just the additional grid access charge on top of that.
Okay. All right.
Now, I guess I would go on. If you go a little bit further, I did try to speak to the distribution in the next sentence, because it's not a perfect curve as far as the distribution. So I wanted to point out that 193 customers. Only 25% of that total would experience something greater than the average. So it's slided to the lower size as far as customer count.
Yes, I appreciate that.
So that's one.
Pardon me. Go ahead, please.
No, I was just going to say that's one other element of an effort to give a better representation of the distribution.
I agree. I think it adds in the whole element of trying to see in total what we're trying to grasp in terms of this particular option. Let's take a look at your direct testimony, if we could, pages 11 through 13. We're indirect. I guess we just turn the page. 11 through 13, obviously, this is your direct testimony regarding the alternative minimum bill that is an alternative you're suggesting to the grid access fee. Is that correct? Mr. Lutz?
Sorry, I didn't catch all of that. Could you repeat that, please?
Yes. I'm looking at pages 11 through 13 of your direct testimony.
I'm there.
Okay. And this is your discussion of the nuances, if you will, of the proposed minimum bill, if that alternative were to be chosen. All right. Okay, so far? Can you hear me, Mr. Lutz?
I can. Yes, I can now. Yes.
All right. For the benefit of all of our participants here, could you summarize again what do you see as the customer rate impact of this proposed minimum bill?
Okay, there's a couple of approaches there. The first I would offer would be on the absolute bill, and what I'm talking about there is that we currently have a minimum bill of $14.50, and what we're proposing is to increase that to the $35, which we've calculated to be equivalent of usage of about 278 kilowatt hours of energy. So the impact, if you were below that number, then that's minimum impact will be the difference between the 35 and the 14.50. However, if you use more than 278 kilowatts of energy, by design, you would exceed the minimum and would have no impact whatsoever. You would pay the bill that you would be calculated on your usage, and the minimum would not apply.
Okay. All right.
Now the other part of that would be to try to explain the revenue from it? Is that the direction that you were wanting to go as well? Or was it more at an individual customer's perspective?
I was more concerned with the impact on the customers.
Okay.
If we could turn to your rebuttal testimony now, please. And let's take a look at page 7, especially lines 1 through 7. Page 7.
I'm there.
Let me back off that just a little bit. Actually, if we go back to page 6, I'm looking at lines 7 through 23 there on page 6. Then on over to page 7. Yes, lines 1 through 7 taken together. Playing off a bit the line of questioning posited by Commissioner French, because I share a common concern, I think that we all do, about the impact of any of these options on the lowest income ratepayers and the extent of that impact. So as I understand your testimony in response to the questions from Commissioner French, and from your direct testimony here, or from your rebuttal testimony here, you have a concern also about protecting low-income, economically challenged customers. And so my question would be this: that's with respect to the minimum bill. What about that same class of customers? Is there any kind of comparable relief that's contemplated for those types of customers, the ones who are economically challenged, in the event a grid access fee was approved?
I don't think that we're against considering that, but to be very, very direct, I guess, in my answer is that it's been our observation that the cost of installing a DG system on a home usually provides a reasonable filter to ensure that those customers are not low-income customers. At least that's been our observation to this point. Now, if there's some policy change or something that we can be, made aware of where, low-income customers are shown to be installing DG systems on their homes, then I think we would certainly embrace some similar protection for low income. But to this point, we've not had any evidence that that's a risk for us.
All right. If we could turn to the slides that were presented this morning by Ms. Dingus on behalf of Evergy, pardon me, especially pages 8 and 9.
Brian, do you want to share those, please?
Brian, I'm happy to do that if you'd like me to.
I'm almost there, so I think I can do it, but I
Okay.
appreciate the offer. I may in a second tell you that I've got second. I'm sorry, what page did you want, Commissioner Keen?
Let's start with page 8, if we could, please.
Sure. And I assume everybody can see the slides.
Yes, sir.
Yes, Mr. Lutz, I found, and this was captured also in your testimony, these slides. Was it in the direct or rebuttal? Do you recall?
It was in the rebuttal.
It was indeed. I think it was pages 19 and 21. Let's take a look at that.
Okay, I'm there.
Yeah, there's a certain irony in this to me of sorts, because when we look at both of these, both in terms of the installations that are portrayed on page 8, and then look at the, on page 9, and the installations on 8, having a little technical problem of my own here this morning, and the applications on 9, there seems to be a strong growth in the net metering installations since the original commission order in this docket that set forth the demand charge and the as it turns out now, the discriminatory and offensive demand charge, because the date of that docket was 9/27/18. And we take a look at just the applications and the installations during 2019 and 2020, it's a rather incredible growth here. My question to you, Mr. Lutz, is how do you explain this growth? To what factors would you attribute this growth?
Right, absolutely. And the testimony of Dr. Faruqi speaks to this a little bit more directly. But I would offer that it's driven mainly by the costs of the solar panels and the costs of installation of those solar panels themselves as being the primary driver. I would offer the secondary driver is probably the customers themselves and their desire, to be engaged in their generation of energy and to be environmentally conscious. That those two things come together strongly to drive folks to install. I think we saw that in the public hearing with a number of those folks, that they quickly offered their concern with the environment as being a driver for them. I think that the rates that they're under are certainly a consideration, but they're less so. I think that they're driven by the bigger question about installation cost and their kind of what I would call their policy or their belief around environmentalistic support.
I appreciate your answer very much. About 3 more questions and I'm there. Okay. My next, I want to flip back again to a consideration of the the minimum bill option, if we could. And if we could take the Evergy slide off of there again, thank you very much. Here's the most holistic answer I think I can posit to you with respect to the minimum bill. If this were actually chosen as an alternative to the grid access fee, would it not result in an immediate across the board rate increase for all Evergy residential customers? Initially, yes, and you suggest through the slides it would be de minimis, but what about as the minimum bill evolved over time? Would this not be a rate increase for all Evergy customers?
No. The minimum bill in its design provides a pivot point or a threshold. And to the extent customers' normal usage is above that threshold or that pivot point, there's no impact or no rate increase to those customers. So it would only be a rate increase for those customers that fell below that threshold. Now, if your question was it does it generate more revenue for the company in its application, then that's certainly possible and probably plausible. And that's where we actually recommended that we have some kind of a tracker, to keep those numbers in mind so we can adjust and take that into account in the next general rate proceeding. But as far as our individual customers and whether or not they experience an increase, I would offer a very large percentage are not going to see an increase. That their normal usage month in, month out is above that current threshold, for the application of the minimum bill.
All right, thank you. Two more questions. The last two, I want to focus on your take on some of the proposals proffered by the other interveners, if I could. Let's start with CURB. Certainly, and it was reviewed, I think, well in the slide presentation they gave incidental to the opening statement. So my question to you in a nutshell is, I want your take on any concerns that you have about their suggestion that we return to a two-part rate design.
Right. You know, and Ms. Dingus talked about it in our opening. I mean, that really boils down to our belief and embracing the fact that we think that issue has been identified and answered, that the two-part rate is simply not an appropriate rate. And to return to them, return customers to those rates, even in an interim basis, doesn't help the issue at all. It only serves to exacerbate it when the time comes, or when the future issues are addressed to resolve it and deal with that cost subsidy and that cost shifting ultimately. So, I mean, the two-part rate, I can understand people's tendency to embrace it because of its, you know, it's been in place for a long time. It's something simple. And to be very frank, it's a structure that benefits customers, DG customers. It's a system that, with the net metering, with the concepts of excess, can generate added benefit over and above any other benefits that they might enjoy from having a DG system on their home. So I can see the attractiveness of it, but as the prior commission has already addressed, it does have an impact on those non-DG customers. And, you know, if our goal is to make progress, maybe in line with the spirit of staff's opening and their guidance there, going backwards to the two-part rate does not achieve anything.
All right. I would, my last question, I'd like to have you address, if you would, the approach that is subjected by the Climate and Energy Project, the Sierra Club and Vote Solar. If you would summarize for me the concerns that you have about that. If we could briefly, before, just as a lead up to that, because I'm trying to be fair to everybody here, if we could take a look at, again, at your rebuttal testimony on page 3. Specifically lines 8 through 11.
Right. Yeah, go ahead.
No, please go ahead.
I guess I was just going to start by offering that, you know, the testimony offered by Mr. Gilliam parallels the testimony by Mr. Kalsick in a number of ways, as far as wanting to return customers to that pre-existing state, that two-part rate. You know, the difference being, you know, that CURB proposes the proxy charge as kind of an interim measure to help kind of keep the company whole, where Mr. Gilliam pivots directly into the desire to refund customers during the time when the commission approved demand rate was in play. So, you know, I think I did speak to both in my rebuttal, and I think that my comments on my concerns around the two-part rate apply to the Sierra Club testimony equally. And as for the question of refunding, I mean, we defer that in some degree to the commission. as far as how they want to proceed with that. I do believe that there's concerns with that approach. Number one being just the passage of time and how customers have moved in and out of these rates over that time. And then also the fact that there have been customers that have benefited under the demand rate. And we've had a number that have stayed under that rate to this day. So in its entirety, I tend to disagree with that as an approach. But I could certainly understand the optics or the desire to try to make that whole. I guess I just would caution that there are people on both sides of that equation within the DG population.
Okay, I'm going to fall back and ask you one more question yet. Let's go back to the grid access so that I have a really holistic view of what that is. From what I understand with your testimony, that even for the smallest of customers, on the smallest use, the very smallest, the ones that you identified in your testimony, the minimum charge for them would in no event be less than $14.70 per month. Is that correct?
Correct. The grid access charge would exist within the current residential tariffs, and those tariffs are subject to that $14.50 minimum today.
$14.50, I understand correctly. Thank you. All right, Mr. Lutz, I appreciate your indulgence of my questions, and I appreciate your answers as well. Same to all the participants. I appreciate their indulgence. And with that, Madam Chair, that concludes my question to Mr. Lutz.
Thank you, Commissioner Keen. I know I promised a restroom break, but I just very quickly, Mr. Lutz, the minimum bill of $35 is a beginning, right? You talked about gradualism. So ultimately, right now, it really should be at 77 if it were implemented, correct?
If the goal were to alleviate all of the cost shifting, yes.
Is that Evergy's goal? To recover all the costs? So if it is, what is your plan to get to the 77? How you talk about gradualism, explain what that plan would look like.
Well, and I think some of the parties have mentioned it or have through the questions from the other commissioners, that, you know, there's certainly some uncertainty. There is some uncertainty about how this is exactly going to play out. So I think that it's to our advantage, to our due diligence, to watch how this develops, how this flows through our customers, and examine this in future rate proceedings. In that time, we would have the data, we would have the support to judge whether any additional change is needed to that at that time. You know, whether, you know, I think as we sit here today, we don't anticipate this being a quick move. You know, that doesn't serve anybody's benefit. But it's certainly something that if we're to be conscious about what I'll call some of the flaws in our current rate design structures, and let me kind of deviate just a little bit there if I can. We're very reliant on volumetric sales. And if we take a long-term view of things, that may not be the best kind of rate design. You know, many other jurisdictions have started to explore other rate designs that lessen that dependence on volumetric sales. And to the extent that factors in, that could influence how the minimum bill might be utilized. It also would allow for other changes to occur in the other rate designs. So if other rate designs come into play that are able to account for changes in customer usage, the need for the minimum bill might be minimized, and we may never get to that 77 level. The recovery or the rate making or the rate designs would shift and in a sense modernize to show and recognize those customer behaviors more appropriately and make us less reliant on those volumetric sales. So I think the short answer to a difficult question is we don't know exactly what it would look like as we move forward, but it would be an incremental process where we would look at it holistically around the impacts of the minimum bill itself, but also our other rate designs and how we're approaching our rate design portfolio, if you will, for all customers in making that final determination.
Okay, thank you. As I looked at the chart that Commissioner Keene referred to in Evergy's opening statement about the increase in the number of net metering, residential net metering installations, and the growth is there, would you, I believe you stated that it was due partly to two things. One, the cost, meaning the subsidy that is now being offered to those taking advantage of solar panels or solar roofing. Is that when you say cost, or do you mean the savings? I was not clear on that.
Thank you. No, my specific mention of the cost was the actual cost of the panels themselves, the cost to go and procure the equipment that would become the DG system. It's that cost has been reducing and declining dramatically over the years and has made the installation of a DG system on your home much more affordable, and probably in my mind driving the interest more so than any rate design or other factor.
And you said the second reason was because of perhaps their passion to be part of a solution to climate issues or whatever, but more with perhaps the heart and the head together. But isn't there a third, the savings that they'll ultimately receive by the installation of the product?
Certainly, and the right away, I mean, they have the benefit of being able to consume their own energy right away. But the other part, and they also have the ability to benefit through the sale of excess energy. But what I have heard, and I think it was even stated in the public hearing this way, that these customers are not necessarily installing these systems to escape their share, as I think they've put it. These folks are they're bright, and they understand a lot about how things work in the world, and that there's a cost to things, and they're not seeking to unload on other people. But I think that given just the way that the net metering process works and our rate making structures work, it sometimes can be the effect. And so that's circling back to your question. That's why I don't think it's a huge driver, because I think that they're driven more by that passion. I think that was a perfect word to use. And when you marry that with that, it's just simply less cost to put a solar system on the house than it was in years prior. It makes the perfect connection. The rate design certainly factors in the overall, maybe in the payback years or other considerations. But as the data seems to show, it's not been enough to necessarily impede them from moving forward. Go ahead.
All right, let me just ask. So if I installed that today, is there a federal subsidy, or can I take that off my taxes right now?
I believe there is still, and there may even be some state level incentives of some sort around that installation. Yes.
So I read the other day in an article that with the new administration, there is thought that these incentives probably will continue and be in place. Would you agree with that?
Sure. And I would even go further to say that I think applied in those manners, it makes more sense because it's a matter of public policy to provide those incentives. To flow incentives through some kind of a rate making approach to me is less appropriate. The rates and rate making should be more focused at the cost of service and our regulatory compact, and we leave the incentive mechanisms in many ways to other vehicles that are more direct. In the neighboring jurisdiction in Missouri, they've long utilized solar rebates to help drive installation, and I embrace that. I mean, that makes sense. It's a very transparent way to support that need, but I draw a little bit more concern when we try to do things with rates that are oftentimes better achieved with other vehicles.
So thank you. I would also echo Commissioner French's concern about the materiality of the $205,000 in the scheme of $794 million. I'm really having trouble wrapping my head around that, especially as I want to understand that you view the DG customer as having perhaps a more elaborate grid access. Is that correct? Do they really, or why are they different than me? As I mentioned during our public hearing on STP, I replaced a 32-year-old dryer. I don't think that meter spins as quickly as it used to.
Right.
Or as I replaced all my light bulbs, knowing that they never reach 7 years, but as I've gone in and made changes, why is the fact that behind the meter they installed something that makes them use less of your energy? What is different?
Right. There's really two elements that I would offer. One being in our opening, we spoke about it, the act of putting energy back onto the grid.
Does everybody put energy back on the grid all the time?
Well, no.
Not all the time, but does
Right.
everybody put energy back on the grid?
Let me
And
say
is it a consequential amount?
everyone has the capability to put it back on. There are a lot of dynamics between the size of your load and the size of the system that would dictate the frequency of how often that happens. But I think it's been our observation that in most cases, customers have had the occurrence. I can't give you a number of how many or if that's absolute. But maybe if I give you the other part of this, it'll help. The other part of this concern, or what's different, is what was highlighted by Dr. Glass in his testimony, and that is the customer that is the positive demand, no usage customer. And that's what's also different about net metering versus your situation where you installed more efficient appliances or lighting. In that scenario, those customers are making use of the systems, the grid, but because of our rate making and the structures of our rate designs, we have no mechanism to bill them for that usage. In his report, he identified a number of customers that have that condition where they are positive demand. They are certainly creating a demand on the system, but there is no usage. Under the two-part rate, we don't have a bill mechanism to recover that cost, the cost of that service. So those two things kind of conspire together, if you will, to create the difference. The fact that customers have the opportunity to push back on the grid and utilize the grid in a certain way, different than you as a non-DG customer, but then accentuated by our billing systems and our rate designs, have a way of escaping any kind of cost recovery for that service received, is what creates the difference. Is what.
Do you believe that the fact that you aren't receiving compensation, it's because it's in the wrong bucket, and it should, so that you would receive that, it should be in a different bucket?
Can you give me more on the bucket?
Okay, so there are different things that go into the charges on a bill.
Mhm.
So what you're talking about, you're saying you're not receiving payment, they're a positive demand. What if it was in a different bucket of a different charge?
Mhm.
Does
Right.
that alleviate the problem? Because I believe the growth will continue with solar, and so you'll continue to, as you said, not be paid
Right.
for the service that's rendered.
Right. Both the grid access charge and the minimum establish, if not distinct buckets, at least ways to continue to contribute to an existing bucket. Let me say it that way. But both of those charges will create mechanisms that will help ensure that there's some amount flowing back for those services received. Under the two-part rate, there is no mechanism to achieve that. And under the net metering construct, there's the ability for a customer to be in that positive demand, no use scenario that Dr. Glass highlighted.
Okay. One other thing, are you familiar with the Illinois situation where they have a cap of like 5% before? And right now that's in discussion as to whether the utility overrated the amount and believes they're at the 5%. But bottom line is they had a cap.
Correct.
So what is your thought on a cap?
I believe, right. And I believe that we are covered by similar caps. And certainly they were there, to help protect the utilities grid. And it's certainly, not surprising that as that grows and as the companies experience that additional DG, that they would look at wanting to potentially change those caps. That's logically what you should consider. But I don't think that those really serve to influence the facts around the rate designs and the cost shifting. Those I would offer were offered more around the operational concerns of customer generation within the overall grid, and have a purpose. But I don't necessarily connect them to the rate design issues and the challenges that we're faced with there.
Do you think it's I don't want to say a stall tactic, but till we kind of a measure until it's figured out in a better way, the issue? I mean,
Right.
we're not the only ones dealing with this.
Right. And that, to me, that's somewhat of our argument, is that we want to gain some insight from others who have been through the higher levels of penetration, and I think it's reasonable to presume that we will follow a similar path. So if we can gain some insights about their reactions to those higher penetrations, we can cut the corner, if you will, and avoid having to experience some of the negative implications, or maybe even the building up a large number of customers that we now have to manage separately or manage distinctly once we do decide to make some change. You know, I hate to offer this because it'll probably get back to my wife in some way, but you know, in a way, this is a little bit like a leak of a faucet or something. You know, if you catch it early, you know, then maybe you can avoid downstream troubles. But if you ignore it and let it continue, even though it's small, there could be a point in time when things really get bad. And so I think that's the spirit of what we're trying to do here, is to catch it while it's manageable and learn from others who have let it go and experienced the pipe burst and had to respond under that scenario. And that's where some of the testimony that Dr. Faruqi offers would be very beneficial, because he has a view on that industry and can help show where others have been and what they're doing today that might help us make a better choice at this point in time.
Thank you, Mr. Lutz. At this time, I'd like to take a 5-minute break. It is 11:43. We'll be back at 11:48, and we'll probably plan on a lunch maybe around 1 o'clock. See how many we can get through. Thank you. We're at a 5-minute break. It is 11:48. We are back on the record. And if I could turn to our first presenter, Ms. Kafer, finally. Yes,
Chair Duffy, if I can interrupt
Yes.
before we start the cross-examinations, just to clean up the record a little bit and to be sure the court reporter's on. When Commissioner Keene introduced Exhibit 1, I'm not sure we labeled it properly. It was a Southern Pioneer slide, so we might want to just be sure that the record reflects that it was Southern Pioneer Exhibit 1. We may have labeled it as Evergy Exhibit 1.
And could we just call it Pioneer, since that is what we've been using?
That's fine too. Pioneer 1 is less, one less word is always good.
Yes, any objection to that?
So,
Okay, we will label it as Pioneer Slide.
yeah, Pioneer 1 I think is, or
Pioneer
Pioneer number
1.
1 is great, and then we can. Thank you.
Thank
Then
you.
we'll turn it over to Ms. Kafer. So thanks.
Very good. Thank you, Mr. Fedotin.
Thank you. Good morning again, Mr. Lutz.
Good morning.
I represent Pioneer and Southern Pioneer in this proceeding, and they were not involved in phase 1 of this case before the commission or in the appeal. And my couple of questions for you are probably going to reflect that a little bit. Can I pull up the court's decision on my screen, Mr. Fedotin?
Sure, and if not, I can try it. But yes, if you want to pull it up.
Can you see that, Mr. Lutz?
I can, yes.
Okay, what I've got up here is the Kansas Reporter version of the Supreme Court decision. And I'm going to take you down to what I've conveniently marked here. I've highlighted this yellow part to draw your attention to it. What it says here, the court said that a utility company could apportion its fixed cost among its customers at a flat rate and limit the variable rate to the recovery of actual generation costs. But utilities have traditionally sought to recover fixed costs through the variable rate as an incentive for customers to exercise prudent energy consumption. My question, on page 3 of your testimony, you go through a number of cases, rate cases you've been involved in. And have you also been involved in some cases where you didn't provide testimony?
Yes.
In the rate cases that you've been involved in or that you're familiar with, has it been the utility companies who have advocated to keep the customer charge low by recovering fixed costs and the variable rates?
No, absolutely not. And we've explored, in my experience with our Kansas Metro, the former KCP&L jurisdictions, we explored trying to expand that beyond some of the traditional costs to attempt to balance it more so in line with the cost causation, and ultimately was unsuccessful.
And who are the parties that usually resist your attempts to do that balancing?
Well, I mean, it's generally most. CURB would come to mind. Staff oftentimes would have concerns about raising that. It depends on interveners. Like the AARP type interveners would have concerns.
And later in the court's decision here, on guess what's page 5 of this document, it's actually page 327 of the reporter version of the order. It says that the utilities in this case appear to have given up on the economic promise once attached to the private generation of electricity from renewable resources. To your knowledge, had Westar, when it proposed the DG rate in your initial proceeding here, Was it because they had given up on the economic promise of DG?
Absolutely not. Westar and now Evergy Kansas Central and Evergy overall has tried to embrace private generation. The key for us is to do so in such a way that's not impactful to the non-generating customer. So it's not at all that we've given up in any way or wish things to go poorly for private generation. It's just a matter of trying to do so in such a way that's fair and balanced to all customers that we serve.
And is that the same thing for the GAC you've proposed here? The GAC isn't proposed because you've given up on the economic promise of DG.
Correct.
All right, thank you. That's all I had for clarification.
Thank you, Ms. Kafer. So you are complete.
I am. I'm happy to mark this order, this version of the order, since I did highlight and mark it as Pioneer Exhibit number 2 and move for its admission.
Any objection? Hearing none, it is so ordered. Thank you. Next, we turn to Mr. James Flattery for Liberty Empire.
Thank you. Good afternoon, Mr. Lutz.
Good afternoon or morning.
Take the
almost
5 minutes.
Could we take the exhibit off the screen, please?
I'm kind of forgetting how I did that. Okay, I see there.
All right, there we go. Thank you.
Mr. Lutz, I wanted to ask you some questions about the concerns that were raised by Commissioner French and Commissioner Keene about the lower income customers actually subsidizing the more affluent customers who can afford putting solar panels on their house. And I believe you indicated to Commissioner French that there, in your opinion, there are lower income customers with above average usage because they live in older homes or their installation isn't as good or can't afford efficient gas air conditioning or other appliances, that because of all that, they have above average usage, and as a result of that could actually benefit from the minimum bill proposal. Is that correct?
Well, yes, I would. The only word I would draw issue with would be the benefit, that being a relative term, but I would say that they would not be impacted. That, customers that are over that 278 kilowatt hour, which currently represents about a third of the average, would experience no new additional impact. So if that's perceived as a benefit, I would agree with you.
Okay, so the minimum bill that you're proposing, that would not have the result of reducing the volumetric rate that would be charged to the customers.
Right. There would be no change to the actual rate components that are on our current tariffs. It just establishes a threshold point where any consumption level below what would result in a $35 bill would be replaced with that minimum.
Okay, that's all I have. Thank you.
Okay.
Thank you, Mr. Flattery. We will move to KEC. Mr. Robert Vincent, please.
Thank you, Madam Chair. Good afternoon, Mr. Lutz.
Good afternoon.
It's been some time, but we've met before, haven't we?
Yes, sir.
It's nice to see you again.
And nice to see you as well.
Your testimony supports the company's proposed rate designs in this remand proceeding, correct?
Correct.
And Evergy is presenting 2 rate design proposals, correct?
Correct.
Your testimony refers to both a grid access fee and a grid access charge, does it not?
It does. It's a nuance where the fee is the actual rate component and the charge is the result when applied against the KW of the customer.
Right, and fee or charge, these generally refer to the same proposal, correct?
Yes, I would use them synonymously.
And the second proposal is, of course, the minimum bill, correct?
Correct.
And these rate design proposals only apply to residential customers. Is that right?
That is correct.
Your testimony uses the abbreviation DG for distributed generation, correct?
It does, yes.
For my questions this afternoon, is it okay with you if I use the same abbreviation?
Certainly.
Under the company's proposal, the grid access fee for a non-DG residential customer, that will always be $0.00, correct?
Correct. As long as that customer does not have installed generation, that element of the bill would be 0 times the rate. Yes.
Right. No matter how they use the system, no matter how much demand they place on it, that fee will always be $0.00.
Right. Under our remaining rate elements, there is no current factor to capture usage beyond kWh consumption.
And the grid access fee for a DG residential customer will always be something more than $0.00, correct?
Correct.
Even for the smallest DG customer, in terms of their system's capacity, they're always going to be charged some grid access fee, correct?
Yes, emphasis on the sum. Because it's based on their installed system, it will increment with their size of installation. So yes.
Even if they do not export any energy to the grid, they will still be charged the grid access fee, correct?
Correct. In our deployment, there is no recognition of the role of excess. That is correct.
Notwithstanding customers who have a positive demand, but no energy usage that Dr. Glass refers to in his testimony, exclude them for a moment. What is the difference between a customer who uses DG to reduce a portion of their energy usage and a customer who implements energy savings or conservation measures?
Well, yeah, a couple of things. I mean, the nuance that we have to keep in mind as well is that these perspectives are measured on a monthly basis. And so as we look at their consumption, their generation, the netting, all of those things, it's done on a monthly basis. That does not eliminate the fact that on an hour by hour basis, there could be very different results, but the net being across that hour or across that month, excuse me, that it shows no effect or no export as you're describing. But the fact that they have the ability is distinctly different than a customer who simply is reducing their load through energy efficiency measures. On an hour by hour basis, there certainly could be flows that distinctly separate a DG customer from what I will call an EE customer, an energy efficiency customer, to work with your example.
Okay, that's fair. Assume there are no bidirectional flows. Assume that DG customer never exports any energy to the grid for a monthly billing period. In that case, what is the difference between them and a energy efficient customer?
Well, I was trying to avoid getting into like technical elements as much as I could, but the act of interconnecting, even if it doesn't flow as you're describing, still creates a situation where the customer's DG system has to work in harmony with the grid. And that, to me, continues to make the customer distinct from an EE environment where there are no additional pieces of equipment that are influencing the grid in any way.
Have you familiarized yourself with the testimony of Dr. Faruqi on remand in this matter?
Certainly, yes.
I won't hold you to an exact quotation, but doesn't Dr. Faruqi indicate the ability to export energy to the grid is the key distinction with residential DG customers driving a grid access fee?
I'd accept that.
Okay. Thank you.
Well, I mean, if I may, I mean, that's the more predominant example. I would offer that your example of no exports in all periods is unlikely. So, I mean, I think it's as a theoretical exercise, I support what you're trying to understand here, but I don't think that it necessarily reflects what our customers attempt to do. You know, they're going to want to install the largest system that they can afford, and within the constraints of the net metering tariff, you know, to give them the benefit that they want. I mean, they want to generate as much power as they can to consume at their local at their home. So I think in most cases you're going to find that exports from an hour to hour view are very common.
That's fair. Just to really kind of drive this home, in the event a DG customer, a residential DG customer, went a month without any exports, some months they may have exports, but some months they may not, would they still be charged a grid access fee under the company's proposal?
Yes, the grid access fee is independent of exports.
Thank you. A little bit earlier, you were asked some questions from commissioners and for counsel from other parties regarding the Kansas Supreme Court's decision in this matter. Do you recall that line of questioning?
I do.
Do you have a copy of the Kansas Supreme Court opinion in front of you?
I do now, yes.
I'd like to call your attention to the same paragraph that counsel for Pioneer referred you to. I'm going to try and share my screen so everyone can follow along. And in my system appears to be having just a little difficulty. Mr. Fedotin, is there any way we might be able to pull it up from your screen?
Yeah, let me attempt to do that.
And Mr. Lutz, so you can prepare, the paragraph I'm going to refer to begins with the utilities in this case appear to have given up on the economic promise.
I'm there.
Which page did you need to go to, Robert?
On the slip opinion, I'm on page 9, I believe. It's 327 in the reporter's version, I think is what counsel for Pioneer indicated. And we're right at the very, very end of that page, Brian.
Do I have the relevant language up?
Yeah, on the left.
On the left, you do, yes. If you could scroll up to the top of that page, I think we'll have exactly what we need. Thank you, perfect. So in the top right-hand portion of this shared screen is the end of that paragraph counsel for Pioneer referred you to. Is that correct?
Yes, it is.
Do you see the sentence beginning with, and being the more recent statute?
I do.
Would you read that sentence into the record, please?
And being the more recent statute, the utilities argue that KSA 66-1265E preempts KSA 66-117D and allows utilities to charge more to DG customers than they do to non-DG customers, all for providing the same services and selling the same energy.
Thank you, Mr. Lutz. Have the services the company provides changed since the Kansas Supreme Court issued this opinion?
I react in that way because I don't, and I'm not a lawyer, but it's my contention and my testimony here today that this issue was not appropriately vetted before the court. I mean, I understand the words that are written here, but I rely on the more fully developed record of the commission and its plain view that these services are different, and why that did not get communicated into the record and to the Supreme Court's purview in that same depth, I cannot explain. But I maybe restate your question. I know I didn't answer it.
No, that's fine. It's a difficult question, and I appreciate the complexities in trying to address it. The question I asked was, have the services the company provides changed since the Kansas Supreme Court issued this opinion?
To answer it directly, the services prior to this opinion were the same as what we're talking about today.
Thank you, Mr. Lutz. Moving on, do you have a copy of your rebuttal testimony in front of you?
I do.
Would you please turn to page 8 and let me know when you're there?
I am there.
Excuse me. Excuse me, I'm sorry, Mr. Lutz, page 9.
I'm there.
On this page, you quote a portion of testimony provided by a pioneer witness. Is that correct?
I do, yes.
I believe this is Richard Mackey's ultimate conclusion on how the commission could establish separate rates for residential DG customers. Is that fair to say?
I believe it is, yes.
Does the company endorse the approach described by Mr. Mackey?
Yes, and I think I say that much here, yes.
I'm going to ask you some questions on this quotation. If you're not comfortable with them, I can defer them to Mr. Mackey as well. In rate-making proceedings, we use cost of service studies to identify costs. Is that fair to say?
Yes.
I've heard cost of service studies described more as an art and rather than an exact science. Would you agree with that?
Yes, and I think I responded to commissioner questions similar to that, yes.
Right. They have cost of service studies have a number of different methodologies, techniques, and assumptions, correct?
Correct.
And in any given case, reasonable minds can disagree. Is that fair to say?
Certainly.
In fact, in rate case settlements, we often don't agree on a particular cost of service methodology. Isn't that right?
That is correct.
In order to definitively define DG costs, as I believe Mr. Mackey is indicating we can do, won't we have to endorse a particular cost of service study?
Only to the extent that you're trying to be absolute and precise in your application of that resulting rate. So for example, in our situation where we, through gradualism, applied a rate that was half of what the cost of service study offered, I think that gives quite a bit of latitude to allow for differences of opinion in the cost of service methodology that I would offer would probably be less impactful than that gradualism approach.
Right. Gradualism, however, is a component of rate design, is it not? Not cost identification in a cost of service study.
Right. I mean, what you're trying to, or I think you're going with some of this. I mean, in order to be absolutely precise, it would require some form of marginal cost study. And that's just an approach that's not been used a lot in our rate making, if at all. We tend to use the fully embedded, more test year oriented, normalized rate making. And it, by its nature, is just going to be less precise than a marginal view of costs.
Okay. Thank you. I have just a few more questions for you, Mr. Lutz. In your direct testimony, you attach some exhibits that outline example tariffs that the commission would use to implement the company's proposals. Is that correct?
Yes.
Towards the end of your direct testimony, would you please turn to exhibit BDL-2A and let me know when you're there? And that note is in the top right-hand corner of your exhibit.
BDL-2A, hold on just a second. I have the Q&A portions of my testimony in front of me, but the exhibits I'm using electronically. So BDL-2A. Okay, I'm there. Sorry.
And in the top right-hand corner, do you see, it's the third line down on the right. Do you see where it says sheet 1?
I do.
And would you turn to the next page? That should be sheet 2 of schedule BDL-2A. Do you see that?
I think so. We may want to put a common view just to make sure that we're referencing the same thing, because the sheet number that you're referring is generally in reference to the tariff page itself, not the exhibit page.
No, go ahead.
Mr. Vincent, can you share your screen and put that up there so that we are all on the same page?
I can sure, yes.
Thank you.
If the commission wouldn't give me just one moment, I believe I can zoom in with a second screen.
I just want to avoid confusion because we're starting to get into tariff pages, and those headers of the tariffs have usually distinct meaning from the testimony.
No, I appreciate that. All right, I should be coming in right now. And Brian, it's saying the host will let you in soon for the second screen. All right.
You are muted.
Just admitted you.
There we go.
Oh, cool. Got two views of you. That's neat.
I got a laptop in front of me too, so if you want surround sound, Robert, we can make that happen.
Awesome.
All right, let me pull up the screen, and this should.
Now that's a cool picture. Sorry, I'm getting distracted.
Mr. Lutz, can you see the screen I'm sharing presently?
I can. Thank you for doing that.
My pleasure. Thank you for your patience. This exhibit refers to how the company would implement a minimum bill for the residential distributed generation customers, correct?
Correct.
And to show those edits, we use underlines for additions and strike through for deletions. Is that correct?
That is correct.
And that, in fact, is how we can see the company has edited this tariff under the heading minimum monthly bill, correct?
Correct.
Mr. Lutz, I don't see any deletions regarding the demand charge for the distributed generation customers. For the record, if the commission were to adopt the minimum bill proposal as described in your testimony and in these exhibits, would the demand charge continue to be in place for residential distributed generation customers?
Well, I mean, you highlight a good point, and our proposal's probably silent on that. But I think my testimony here today is that if the commission rules on the grid access charge or the minimum being the appropriate replacement, then this tariff would, in a sense, be no longer effective, and customers would be moved off of it. So there would be kind of a transitional element of this related to this particular page.
I'm sorry, maybe I just didn't completely catch that, and forgive me.
No, you're good.
So I guess maybe to ask again, as simple as I can, if the company or if the minimum bill proposal is adopted, will residential customers of any sort be subject to a demand charge?
Let me answer it this way. If the commission orders that the minimum bill is the replacement for the company's use of this demand rate, then this tariff would not, or this exemplary tariff would not reflect what we would implement.
Okay. I appreciate your answers this afternoon, Mr. Lutz. At this time, KIC has no further questions. Thank you.
Thank you, Mr. Vincent. I appreciate that and sharing your screen. We now turn to KEC, KEPCO, Midwest Sunflower, and Ms. Susan Cunningham.
Thank you so much, Madam Chair. And at this time, the KEC Group has no questions for Mr. Lutz.
Thank you. At this time, we will move to CURB and Mr. Joseph A. Stratt.
Apologies for the wait. They're getting my computer all set back up again. Thank you, Madam Chair. Mr. Lutz, I want to talk to you about two-part rate designs and your answers to some of the questions from earlier on, okay?
Certainly.
Okay. So as far as the two-part rate is concerned from Evergy's perspective, is this something that Evergy is looking to remove completely for all residential customers, or is your criticism of the two-part rate design specific to DG customers only?
Well, I want to say yes to both. I mean, well, or I guess I can't. Sorry. The two-part rate is a legacy approach that I would offer was put into place because of the reliance on metering. That metering just did not allow the company a lot of options on how it would provide its service. It was much more economic to meter and provide service on a per kilowatt hour basis. And that over time, along with policies of trying to keep the customer charge as low as possible, had resulted in a fully volumetric rate, the two-part rate that we have today, with a very high percentage of our cost recovery through a volumetric charge. Now, the issues with that have been brought to bear most plainly through the DG customer and their ability to avoid charges through the net metering process and the availability of excess generation. But the concerns about having a fully volumetric rate do extend to all residential customers. And so, yes, I think it's most prominent with respect to DG and the most timely issue. But yes, I think that as a company, we need to make sure that we're able to have a rate design that is less dependent on volumetric sales in order to ensure that we're able to, deliver to our customers the service that they need and recover the costs of that service into the future.
Thank you for that. Now, in regards to that last portion about improving the fixed cost recovery, at the present time, has Evergy indicated some sort of dire financial situation that requires full recovery of fixed costs from the DG population?
No, and as we discussed a little bit in some of the earlier questions, that it's the Supreme Court action, the remand, and some of those things that have brought this to front, to the limelight, more so than materiality. Certainly, the absolute numbers are not large related to this issue, but this issue is clearly in front of us, and through the experience of other jurisdictions, it's one that we should go ahead and address while we have this opportunity.
I understand. Thank you. And in regards to this first step into improving fixed cost recovery, Evergy does foresee at least some degree of additional study and data collection to improve upon this, correct?
Right. Most appropriately done in the part of a general rate proceeding.
Right. And currently, Evergy is in the middle of a rate moratorium, correct? So there would be a rate proceeding until the end of, or a rate case until the end of that.
Correct.
Okay. And I believe it's still about 2 or 3 more years until that cutoff date, correct?
Correct.
Thank you. In regards to legislative action, do you, I don't want you to go into specifics about what kind of legislation would look like, but do you foresee the possibility that legislative action within the next couple of years may or may not have an impact about what kind of rate design will be acceptable in Kansas related to DG customers?
Yeah, if legislative action were to occur, yes, it would influence. Absolutely. I think part of my concern around legislative action is that I have a much higher faith in the ability of the commission to act than the legislature to act, and so I put the burden, if you will, on the commission to be nimble and do what it needs to do more so than relying on the legislature.
Thank you for that. And in regards to this urgency to take action, is there some sort of command from the Supreme Court in its remand to fully eliminate this free rider problem associated with DG customers?
No, not as you've characterized it. I mean, they certainly have highlighted the quandary between the fixed and variable pricing that we have, and I think that points to a problematic situation. But no, there's no overt timing that the Supreme Court overlays on any resolution of that free rider problem.
Thank you for that. I want to turn now about your analysis of the grid access fee and CURB's proposal in regards to accounting treatment, okay?
Okay.
First, I want to start with the GAF as it's written today, or as it's proposed today. Would you be able to summarize what roles regulatory accounting mechanisms will play in implementing the GAF at this time? And why would it be done in the way that you've described it?
Okay. Yeah, we find ourselves in between the general rate proceeding that underlies our current rates and those future rate proceedings that you described at the end of the moratorium. So the fact that we're adjusting or changing rates in this window creates a situation where we could deviate from the rate design outcomes, the revenues that were contemplated in that order of that last general rate proceeding. So the accounting mechanisms that we proposed are simply to hold those changes, to hold what the company experiences through the deployment of these alternatives, such that it can be considered in that future rate case and dealt with appropriately.
Thank you for that. I guess maybe to hopefully summarize it from my understanding, the specific differences here that are being booked into this regulatory liability are the differences in revenue collected from this new GAF compared to the prior demand charge rates. Is that right?
Yes.
Okay. Thank you. Turning to CURB's proposal now, and would you be able to summarize your understanding of how CURB is proposing to use a regulatory mechanism?
Yeah, and I addressed this a little bit in my rebuttal, and I'm trying to turn to it. I believe it was on page 8 of my rebuttal. But the way I view the CURB proposal is that they've created a proxy charge, and I think maybe even the way it's worded, it directly supports that. But there's an allowance that the company could establish an amount that we would have recovered under the grid access charge, and then have that viewed for recovery in a future rate case.
Thank you. And so, at least the high level of it, both Evergy's proposal for the GAF and CURB's proposal are working with similar numbers as far as what's being collected from the DG class. Is that right?
No, they're a little bit different. I mean, I think that in ours, I try to delineate this in my rebuttal, is that we believe our mechanism to be more of a correcting mechanism, where the proposal as offered by CURB seems to be a replacement for what we would recover under the grid access charge. By rolling us back to the 2-part rate, which is also a component of the CURB proposal, it would undo recoveries that were achieved through the demand rate. So it's not quite the same in my view.
Okay. Thank you for that. I want to talk now about the grid access fee and the $3 per kilowatt where Evergy starting at, correct? Okay.
Correct.
So this is representing roughly 50% of what Evergy seeks to recover in the future. Is that right?
No, I mean, it represents half of what the current subsidy is. It's not necessarily indicative of the future, and the reason I say that is similar to my questions with the chair. That the future has other variables that come into play that may or may not influence whether we go to that full $6.50 amount or not. That we will have to incrementally check and incrementally determine the appropriateness of increases beyond the 3.
Thank you. In regards to the $6.50 cap, that's not necessarily a hard cap. That could very well increase as inflation changes, more DG customers join the grid. Is that right?
Yeah, the 650 could change if measured at a different point in time. Yes.
And the current proposals, both for the GAF and the minimum bill, that's based off data from the last rate case, correct?
Right. The bulk of the data for this proceeding is from that time frame.
And so, again, not to speculate too much, but at least the time period between that data and when a new class cost of service study might come out before Evergy's next rate case is at least 5 years difference, right?
That's fair. I would accept that.
Thank you. And I think based on the opening statements and the graphs there, Evergy is contending that DG proliferation among private individuals is increasing, correct?
Correct.
Okay. And currently, how many DG customers are on Evergy's system, or at least the legacy KCP&L system that's relevant today?
The number that I have is approaching 1,100, but I'm sure you would understand that number changes daily.
Sure. But as far as daily fluctuations go, we're not talking a difference of tens or thousands of customers are. It's literally a handful.
Right. It's growth, 1 or 2, maybe a handful a month. Yes, that's true.
Okay. And so in regards to even the $3, Evergy intends to go above this $3 per kilowatt installed capacity, correct?
Say that again. I want to make sure I got you.
Right. Yeah. In regards to the GAF here, even though it's starting at $3, Evergy does not intend to leave it at $3 for forever, right?
again, back to our point, I think that if we look at even that first rate case, coming up in a couple of years, to me, it would be very appropriate to measure and determine if any change is needed, even at that time. If we were to come to the table with some other different rate design in general for the residential class that better deals with issues like this, then there may be a need to, or there may be no need at all to change the $3. So it's difficult to presume what 2 additional years might bring as far as information or collective thought, state policy, all of the variables that kind of come into play in judging a rate design during a general rate proceeding.
Thank you. And on that note, regarding the kind of the unknown, the uncertainty of the future, would you agree with me that there's also the possibility that further study and data collection would also warrant removal of the GAF? Is that a possibility?
I mean, no. I mean, I don't think removal makes sense. If found to be in line with the commission's rulings on these things and supported through its order, I don't know that necessarily goes away to where I could say it would be removed. It would only be removed in the context that some other mechanism was found to be able to respond to that need. So, if you're asking if the grid access charge could ever go away, my answer would probably be yes, but only if something else were put in its place to help manage that cost shifting that DG brings to the table.
Thank you for that. Has Evergy done any sort of calculations or study at what level of this subsidy, this cross subsidy is happening that will start to result in actual problems with resiliency and operations at all?
Well, there's kind of 2 parts to your question there. There's a level of the penetration that results in operational issue, and then there's also an issue or a level that results in more of a rate making or revenue impact. And I don't think that they're necessarily aligned. And let me, if I can, explore that just a little bit. On the operational side, everything happens in a much more incremental way. So as DG systems are installed, the grid is adjusted as it goes to take into account these new additions or changes that are experienced in the operation. So the operational view is completely different, where in a rate making view, we're not coming in for rate cases every year. The problems around the recovery and the rate designs can accumulate quickly, have impacts. There's a little bit of distinct difference between those 2 points of view. So I'm cautious to bring them together in the answer, if that makes sense.
Yeah, I understand.
Okay.
Thank you for that. Mr. Lutz, I want to turn now towards the minimum bill proposal, okay?
Okay.
So you stated earlier in response to some questions that Evergy does have a minimum bill of sorts, but it's set at the customer charge, correct?
Correct.
And that's $14.50 per hour.
Per month.
Oh, sorry, per month. I'm sorry. Per month, yes. And is it labeled a minimum bill under Evergy's tariff?
Could you repeat that?
Yeah. Is the customer charge that you're referring to here, is it officially labeled as a minimum bill in Evergy's tariffs?
I believe so. I think under the Kansas Central tariff, they refer to it as a basic service fee.
Mm-hmm.
And if you look at the tariff page, there's a section that determines or called minimum bill, and it refers to that basic service fee.
Okay.
Do you need?
No, I don't need to pull up. I just want to. No, that's fine. Thank you. And so, to your knowledge, do any other regulated utilities in Kansas have a minimum bill?
Kansas Metro, the former KCP&L, has the same approach.
Sure, but it's all Evergy now, though, right? outside
Correct.
of Evergy system. Okay, thank you,
And-
but not,
But I would offer those minimum bills existed when we were distinct entities. Even though we're now under Evergy, those minimum bills have been in place for a long time.
sure. And so turning to Evergy's proposal today, this $35 minimum bill is about $20.50 more above the customer charge, correct?
Correct.
And as far as how that shows up on a bill, it's just a flat number. Is there an explanation of how they calculate that number on the bill? How would that look?
We don't have that defined at this time. My approach would be to look at other jurisdictions who have minimum bills and see if there's any guidance we could get as far as the best way to show that. The other would be also to work with our focus groups and customer groups to see if there's any kind of way to best describe that on the bill. I just don't have what that bill view
Sure.
would look like.
That's fair, yeah. Thank you for that. I know this was asked earlier by, I believe, Chair Duffy in regards to Evergy's plan for the future. And so is Evergy willing to commit to only sticking to a $35 minimum bill going forward?
No, I mean, the future is just too uncertain to commit to that in any way here today. We view that that's an appropriate point for us to start and to get us to that next general rate proceeding when we would consider it in light of much broader thoughts and drivers.
Thank you. And in regards to this $77 cap for full recovery, that number is also likely to change in the future too, isn't it?
Yes.
And so at this time, is Evergy willing to commit to capping the minimum bill at $77 in the future then?
No, and I think doing so is I don't know, creating kind of just an arbitrary constraint on what we're trying to accomplish here. The issue is to try to protect the non-DG customer from cost shifts and subsidies, and not knowing where those are going to go, to somehow arbitrarily limit those here today would not be in their best interest. I think we have to be careful. We have to be gradual, use the mechanisms that we have before us through our traditional rate making to make diligent steps. But to artificially constrain it at this point, to me, doesn't make any sense.
I understand. Thank you. You mentioned that one of the goals of the minimum bill here is to protect non-DG customers from this cross subsidy, right?
Mm-hmm.
And phrased another way, you don't want non-DG customers to pay more to cover a subsidy from a DG customer, right? So you're worried about bill increases for non-DG customers.
Yes, in general, yes.
Okay, let's talk about the non-DG customers under the minimum bill.
Yeah.
So one of the aspects in the minimum bill that's attractive is the fact that it's non-discriminatory. Is that right?
Correct.
It's going to charge a minimum bill regardless of a person's DG or non-DG.
Correct.
Regardless if the person is using less than the system average required to make the minimum bill, is using less energy because they have their own solar panels or because they don't want to turn on their air conditioner. Is that right?
It's not built around the average. I noted that in your comment, and that was also an element of Mr. Kalsick's testimony. Our proposed minimum bill is currently at about a third of the average. So
I apologize for misspeaking there, but regards to the break-even level of kilowatt hours in order to accumulate a $35 bill. Is that better?
Yes.
Okay.
Yes.
Okay. And so the $77 represents an average of about 870 kilowatt hours per month, right?
Right, which again is an average and not reflected in our proposal.
Okay. And as far as the average kilowatt hour use of customers in Kansas, do you have that number on you by any chance?
For the residential, it's that 850.
850.
It's around that 850 number, yes.
Okay. So it's right around what the $77 kilowatt hour usage would look like, right?
Yeah, and I if we need to, that is in my direct testimony.
Sure. Yeah, But yeah, if it's subject to check, we can do that, but that's the assumption we're working on here. So
Okay.
in order to calculate that average, doesn't that necessarily require a number of people to be using less than 850 kilowatt hours per month?
Please restate your question.
Sure. Well, just the idea of an average requires a group of people above this average number, but also a group of people using less than that average number, right?
Right, but that distribution does not necessarily have to be normal. And when I say that, equally proportioned on both sides of the average, it's possible that those could be weighted one way or another.
Sure.
So have to presume normal distribution in order to say half.
Sure. And that's fair, but we're not talking about like a 50-50 split. We're not necessarily talking about like a 1 to 99% split, just somewhere in between those numbers, right?
Somewhere in between, yes.
And I believe in, let me pull up here, is in your rebuttal testimony or in your direction regarding sample sizes of non-DG bills that would be impacted by the minimum bill proposal, right? And so would you agree with me that as the minimum bill amount goes up and the number of kilowatt hours that must be consumed to surpass that bill goes up, wouldn't more and more non-DG customers now be paying more under the minimum bill proposal?
Yes.
And would you also agree with me that the sheer number of people affected, the non-DG people affected by this minimum bill increase is larger than the number of DG customers that would be affected by the minimum bill increase?
Certainly. I mean, you're starting to strike at why the minimum bill is the alternate. You know, the directives that we receive from the Supreme Court order and interpretations of those statutes create some mutually exclusive scenarios. So, I mean, it's kind of difficult to check all of the boxes with one approach. And so the proposals that we've offered kind of delineate two paths. One is if you're more interested in dealing with the subsidy and the recognition that service is different, there's a path for that. But if your reliance is entirely on being non-discriminatory, that's where the minimum bill will lead you. I mean, we certainly acknowledge that the minimum bill is not the perfect solution. And maybe that's the byproduct of it being non-discriminatory. Once you enter that space, then you're going to have impacts that are not what you intended. It's the shotgun approach, you know, where I think, you know, it'd be much preferred to have something more precise or surgical.
Thank you. I want to talk with you about your rebuttal testimony. Do you have that available on you right now?
I do.
Okay. I want to turn your attention to page 10, lines 18 to 23, and then it bleeds over into page 11, 1 through 3. Are you there?
I am.
Okay. This section talks about, you're referring to Mr. Kalsick's testimony regarding this break-even level at the $77 minimum bill. And I want to turn your attention now to lines 22 and 23 of page 10, and then leading to lines 1 and 2 of 11. Okay, I'll read those out.
Okay.
And halfway through, the first full sentence on line 22 of page 10 is, quote, "Nothing has been proposed or estimated as to how a future rate design would account for the proposed minimum bill, period. It is just as likely that the better recovery of revenue from the residential class would reduce future rate increases for all residential customers, period." Did I read that correctly?
You did.
Could you explain how it's just as how the minimum bill is likely to reduce future rate increases for all residential customers?
Sure. You know, the issue here is around revenue recovery, and by having that minimum floor, that minimum bill, you create a floor level where a certain amount of revenue recovery is assured. And so as you roll into that future rate case and you have a revenue requirement need, you know, as calculated by your jurisdictional cost studies, when you look at the residential class, you're likely to see a higher level of recovery from that class through the minimum bill. And as a result, when you need to go to that class to get their apportioned part of the increase, it would be reasonable to think that because they've paid more as they've went along, that their rate of return relative to other classes would be higher. And then that would allow them to experience a smaller increase as part of this general rate increase as a result. I mean, there's some steps in the middle, certainly, but the point being is if you're recovering revenue at a higher certainty, where today we have uncertainty because of the DG rate, but if we have higher certainty, then it serves to lead you to believe that the rate of return for that respective class will be stronger than it would absent a minimum.
So in that sense, then it would justify either reducing the amount of an increase or even considering reducing rates for that particular class. Is that right?
Right. In the exercise of allocating a rate increase, we will often, or we almost always consult the rate of returns for the individual classes. And so if by example, we were to look at the residential class and by nature of having a minimum bill, their rate of return exceeds the company average return, then certainly their apportionment of that increase would be smaller, or maybe even none of the increase potentially. I mean, it's hard to speculate, but the point being is that the more certainty around revenue recovery, the more likely you're going to meet your costs, and the subsequent application of rate increases would be less of an impact.
I see. And so this change, this possible reduction to cost and the ROR for this class, wouldn't that necessarily need to be done in the volumetric charge since you can't mess with the customer charge too much?
If we're constrained to a two-part rate, yes. I mean, yeah, absolutely.
Right. And doesn't the minimum bill require a two-part rate?
Oh, no.
Okay.
I mean, to me, a minimum bill is just a threshold that could be applied to any rate. The rate design itself is completely independent. The minimum bill just assures that you've reached a certain recovery point for each of the customers affected by that minimum.
Right. But at this point in time, though, you're only applying the minimum bill to this two-part rate structure currently in place, right?
Yes, I'm just trying to make sure it would apply to all of our residential rates. And I think that they are currently all two-part, but for our TOU pilots and our demand rates. I think there's a optional demand rate in the Kansas Central portfolio.
Thank you. I want to turn your attention now to some of the answers you made in regards to low-income customers, okay? I can't recall this possibly from the opening or from your answers to questions, but you mentioned about adding some sort of exception in the minimum bill to accommodate low-income customers in specific situations, correct?
Correct.
And I think one of the possible changes that Evergy could make is monitoring and identifying those customers who have some sort of enrollment with like LIHEAP or energy efficiency programs. Is that right?
Well, the nuance is that would be the driving factor. I think we still would prefer to have the customer identify themselves and request that change, and then that's when we would allow it. I'm not saying that we have the ability to proactively identify that as part of the billing and remove that charge proactively. We need the customer to come in and contact us in some way and notify and support their need.
Okay. So again, probably the details need to be worked out, but it's a question of getting low-income people, these customers, to reach out to Evergy first, right?
That's the safest way. I mean, definitely to your point about the deployment. I mean, we could we could find some way to reach out to them through, let's just play, with the scenario. If this were to be the approach that's ordered by the commission, we could use time somewhere around that to reach out to customers and notify them of this change. We could give them other vehicles of contacting us, whether it be phone calls, web pages, maybe even responses to a letter. But there are certainly ways to roll this out in a way to kind of catch up and capture those customers that are already existing. But on a go forward basis, it would make sense for, or wouldn't be as impactful to have, customers identify that as part of their normal interaction with us.
Okay. And so this would require some sort of new educational program for Evergy to roll out, because Evergy doesn't currently have some sort of low income program available to customers to get assistance, or am I mistaken on that?
Well, no, we do have a number of programs, and we certainly could incorporate the minimum bill element into those. But more specifically, just to the deployment of a minimum bill, to do that appropriately, I think it would make sense for us to have some kind of a communication ahead of that, to make customers aware, number one, but also to give them an easy path to self-identify and help us get the right people the relief that they need.
Okay, thank you. That's all the questions I have.
Thank you, Mr. Astrap. Okay, it is. We're right at 1 o'clock, just about. Mr. Bender, may I ask, will you be taking more than a few minutes? Not seeing you on the screen.
Can you hear me?
Oh, there you are. Yes.
I think it's fair to say my cross will take more than a few minutes, and frankly, I don't want to be the one that stands between people and lunch.
Okay, thank you. At this point in time, we will reconvene at 1:30, and we will start off with Mr. Bender.
Thank you.
Thank you.
Thank you.
Good afternoon. We are back on the record. It is 1:30. First of all, I'd like to apologize to Mr. James Flaherty. It is Flaherty. I don't know what I said before, but I've been told it wasn't correct. So as one Irishman to another, Mr. Flaherty, accept my apology, most please.
Sure, I've been called a lot worse.
Okay, thank you.
This week.
All right. We will start with Mr. Bender, please.
Thank you. Good afternoon, Mr. Lutz.
Good afternoon.
Some of my questions have already been covered, so I think this will be briefer, but may jump around a little bit more than I had planned. I want to start with, I think there's a few kind of themes to some of the questions that have been asked so far and some of the answers, and I just want to see if I can kind of fit those together for kind of an overall understanding. As I understand your response to questions from this morning about a two-part rate design, I think your testimony was that the quandary, I think was your word, underlying much of this is the kind of the fixed nature of cost and variable nature of revenues for the utility. Is that fair?
That's fair.
Okay. And so if that's kind of the overall problem or quandary, within that, then there's kind of the problem that you see with the two-part rate design. As I understand from your testimony, that's because the two-part rate has the most amount of variable revenue among rate designs. Is that fair?
And further, that under the net metering concept, it accentuates the potential for the subsidy or that cost shifting that we're concerned about.
All right, you beat me to it. That was my next question, which is within the two-part rate, you said you focus on DG customers, because I think you said it brought to bear kind of the broader issue that you have, which is that DG customers avoid volumetric revenues. And that's kind of, so I guess within the Venn diagram, we're just narrowing the circle. Is that fair?
Yeah, and the great analogy. I mean, that's certainly what we're doing. We have multiple drivers that all kind of contribute to that same picture. So I like that optic.
All right, well, let me see if I can continue with it then. So the two proposals from the company in this case kind of look at different widths of the aperture, right? So talking about the minimum bill first, as I understand it, the minimum bill is looking at the kind of the larger fixed variable issue, or maybe the two-part rate issue, and addressing it for kind of all residential customers broadly. Is that right?
Right, and it directly speaks to where the Supreme Court suggested we look. Okay. Was the other element to it.
I appreciate that. And so to kind of frame up that proposal, in your testimony, in your direct testimony at page 11, you look at $77 as kind of how you set this up, is that there's $77 worth of fixed costs per residential customer. Is that right?
Yes, and derived from Dr. Faruqi in his in one of the prior proceedings, yes.
Right. And the way that Dr. Fruki got to 77 is he took all of the customer and demand allocated costs for the residential class and divided it by customers in the class. Is that right?
I believe that's the case, yes.
Okay. And so we're looking at that, as I understand the proposal, the company is saying that's how much fixed, that's the cost responsibility of every residential customer. But for gradualism reasons, we will look at $35 and try to recoup that in revenue through a minimum bill, at least at this step. Is that fair?
That's fair.
Okay. So what that's getting at, the minimum bill rate design, what that's getting at is a broader cost shift issue among customers who use too little electricity and therefore return too little of revenue through the two-part rate.
Right. When applied through a absolutely non-discriminatory approach.
Okay. So in that case, when you refer to free rider, I think on page 12, and how the minimum bill addresses the economic free rider problem, we're talking about an economic free rider problem across the residential class, not limited to DG customers. Is that right?
It is. I mean, I think in this context, we all know that the free rider terminology was most distinctly associated with the DG customers. When we set out in this proposal, it wasn't to address global free ridership necessarily. We were taken here by the Supreme Court remand.
I appreciate that. I think the point here of my question was just that the focus of the minimum bill is to increase revenue beyond the DG subclass across, to essentially increase revenue from any customer who'd otherwise contribute less than $35 a month.
I only pause because I don't know that it was necessarily the driver as when we set out to establish the rate. The issue has always been very much focused on the DG related subsidy and that cost shift. But the requirements and frankly the wording of some of the Supreme Court action or opinion kind of compelled us to look at these more broad measures as a solution. And so by proposing the minimum bill, it achieves ultimately what we do, or what we were trying to do, but it's certainly a much more broad result than we would have proposed otherwise. And that's where my last sentence in that section that you quote about, plainly satisfying the non-discrimination provisions, that was certainly a driver, was to come up with a scenario that addressed that as plainly as possible.
Okay, so it addresses what you see as a subsidy for DG customers, and at the same time addresses a subsidy for kind of low energy use customers at the same time. Is that fair?
Yeah, it's a byproduct of the design, but it was not a driver that substantiated our decision to use it. It was more of an unintended result, more so I would offer.
Okay. So going back to the analogy of the Venn diagram, right? We're looking at the smallest circle, the DG customer specific circle. As I understand, you calculate the proposed grid access charge looking at a different kind of framework or metric for that. And you looked for that, you identified what you call a subsidy for DG customers specifically, but rather than using the $77 per month value, you looked at some costs and some revenues from a cost of service study to calculate the difference between those two. Is that fair?
That's correct, yes.
Okay. And specifically, I try to share this. So if I did this right, you should be able to see on here what the company produced in response to a discovery request, Sierra Club 8-7. Do you recognize this document?
I do.
And what is it?
It's the calculation that Dr. Faruqi prepared and referenced in our testimony to support the 650 number. I believe was the purpose of the data request.
Okay. Madam Chair, I'd like to mark this and make it as an exhibit. I don't know if we're starting over or if I need to find out where Sierra Club left off in summer of 2018 with our exhibits.
I think it makes sense to we can start over at this point. You can make it Sierra Club or 1 or whatever. If you want to call it something else, since you're representing a consortium, however you want to call it, but I think we can start over with 1. And if you could, when you get a chance, it can be at a break or at the end of the day, send me a copy of your exhibit via email, and then I can forward it to the court reporter just to be sure she has something, because normally we would just hand the court reporter something, but over Zoom. So thanks for that, allowing me to weigh in for so long.
Hey, can I ask one more clarifying question?
Sure.
This is an Excel spreadsheet. Do you want it in Excel format, or do you want us to try to put this in a PDF format?
If it's not too hard, I think in a PDF might be the easiest for the court reporter to deal with.
Okay. Thank you.
Would you like to offer this then, Mr. Bender?
I would like to offer this. I guess we're calling it Sierra Club 1.
Is there any opposition? Hearing none, it is so ordered.
Mr. Lutz, directing your attention then to what's now been marked as Sierra Club 1. So I understand this is how the company kind of scoped the grid access charge, calculated in your testimony, in your direct testimony at page 8, you said $6.53 grid access charge would be necessary to address the subsidy, but for gradualism purposes, it'd start at 3. Is that right?
That is correct.
Okay. And so here in the Sierra Club Exhibit 1, see, you start with total cost of $217,688. Do you see that?
I do.
Okay. And then you divide that by number of customers to get the kind of the per customer cost. Is that right?
Correct.
For $13.95, that's BE12 is the cell.
Yes.
Okay. And then you compare that to revenue, existing DG revenues of $133,994. Is that right?
That is correct.
And then you also divide that to get a per customer revenue of $859. You then take the difference per customer, divide it by the average per customer DG rated generation to produce the charge amount. Is that right?
Ultimately, yeah, this cross subsidy is identified first, the delta, and then the grid charge comes out of that.
Okay. So as I understand, the $217,688 cost, that comes from then Westar's witness Amon's cost of service study. Is that right?
Correct.
Okay. That's not the revenue for the DG class that was approved in the settlement. Is that right?
Where your cursor is on the cost side. So that is just the cost for that class. The revenue would not be in that number.
Right, so let me rephrase it. The $217,688 that you represent as cost, that comes from Mr. Amen's class revenue requirement.
There you go. It's the class cost of service study, which is a subset of the revenue requirement study.
Okay, this is actually the functionalized revenue requirement attributed to the DG subclass. Is that right?
Correct. There you go. Yep, I agree with that.
Okay, so it comes from Mr. Amen's revenue requirement value. Is that right?
His class representation of that revenue requirement. Yes.
Right. So there's the utilities overall revenue requirement according to Mr. Amen, and then the DG customers portion of that, correct?
Correct.
Okay. The Mr. Amen's revenue requirement that kind of feeds into this number reflected an increase of like $15 million from existing revenues as of the end of the test year. Is that right?
Something like that. Yeah, it was an increase. That's for sure.
Okay. And then what the commission approved was a decrease from existing revenue requirement. Is that correct?
That is correct.
Okay. So the $217,688 here comes from a revenue requirement that was larger than the ultimate approved revenue requirement. Is that right?
Yeah. Yes.
Okay. What's the DG subclass's share of the approved revenue requirement?
This is where things start to get a little bit more problematic. It has not been common to produce cost of service views, cost views based on the resulting order. You know that the class cost of service studies are usually indicative at the beginning and utilized to help shape the rate design. But then at the closure of the case, it's rare for you to go back and to re-perform those studies under the ordered amounts. So that information is not available for that time. So from a cost perspective, I can't give you row 11 on the ordered outcome of that case.
Okay, but it's going to be smaller than 217 since the entire pie shrank by more than 70,000. Is that right?
Sure, it's possible. I mean, we considered that or considered tested for it in a sort of a way when we considered how to apply the grid access charge that we calculated in 10, row 10 down there, row 25 labeled as 10. But the point being is that we acknowledge that these numbers certainly would move around a little bit, and it helped complement or reinforce the desire to be gradual in applying those charges. And that's where we believe the choice to apply a $3 charge instead of $6 provides more than enough latitude to account for potential variation in the costs or revenues, but serve as a reasonable, and just place for us to start until we can get to the general rate proceeding following the moratorium.
I understand that. I think that assumes a limit to how much the cost or revenue values are going to change, of whether or not the $3 is within that amount of change or not.
Well, I mean, to be honest, what's going to change is what's on row 4, what's labeled as 4. It's probably the revenue, the costs, unless there was any kind of material disallowance incorporated in that order, which I don't recall any, the cost side is not going to change as much as the revenue side. So if your interest is the cost line itself, I feel pretty comfortable that number, although the rate increase was reversed or changed to be a decrease ultimately, that doesn't really affect the cost part of this argument as much as it might affect the revenue side?
On the cost side, if we use Mr. Ammon's revenue requirement, which is $15 million higher than then existing revenues, and compare it to revenues under the approved rates based on a $66 million revenue requirement decrease, most classes are going to show a difference, because we're comparing a revenue requirement that assumes across the board $15 million decrease, whereas rates are going to be set at the approved revenue requirement, which is going to be a $66 million decrease. So every class is going to show a delta between revenues and revenue requirement or cost, as you reflected here. Is that fair?
I pause only because I'm trying to visualize where these are attaching back to the actual cost study itself. As these are, kind of extracted for the purpose of this calculation. I'm uncertain. I mean, I guess I still stick by the question, or by the point, that any of the changes that resulted from that difference between the direct and the ordered are not going to influence this calculation to the point where the $3 proposal is not just and reasonable.
So I think your answer was you don't know where this came from. As I understand, this came from Dr. Faruqi's rebuttal, so we can ask him.
Right. I think if you want to drive into the weeds on it, then certainly that would be probably more appropriate. But I think my hesitation is just being able to recollect exactly from where the cost studies, these numbers come from. I sense that you're familiar with class cost of service studies, and they're very they can be very complex as far as the way they represent the different numbers. And so it's very important to know where those numbers are coming from to make sure you can judge what they're telling you. So I just hesitate because I don't want to necessarily accept something that's not true.
Well, I'm not asking you to accept something that's not true. And if you don't know, that's a fine answer. I think that you pointed to the revenue, which is row 15, which is marked as row 4 in this exhibit, Sierra Club 1, as potentially changing. Do you know where this $133,994 value comes from?
Let me see. I'm looking at the Faruqi testimony on that. That's the footnote there on that line. I believe it to be from the ordered the order, or the stipulation that supports the order in that particular case. So I do believe that revenue number was at the end of the proceeding.
I'm sorry, you're gonna have to clarify that for me.
It's the DG class revenues that support the ultimate order from that case, from the 18 case.
So the non-unanimous stipulation settlement agreement has, you believe, a $133,994 revenue approved for DG customers?
Or represented as the underlying rates for that agreement, yes. That's my understanding.
And where is that understanding? Where do you get that understanding from?
The preparations for this hearing, I guess. I mean, I don't know. I mean, I could go try to find the document and link it back, but that's, as I prepared for this proceeding and reviewed this document, that was my understanding of what it meant when it said from Faruqi rebuttal testimony, and my references to it, that that was like an appendix or, somehow represented in that stipulation that was ultimately ordered by the commission.
Yeah, sorry, I'm not trying to be complicated about this. Did you go obtain that number from the settlement, or are you relying on Dr. Faruqi to have obtained that number from the settlement?
Oh, yeah, I'm relying on Dr. Faruqi. This calculation was ultimately produced by him for us, and we accept it as being true.
Thank you. I just want to talk a little bit more about this grid access charge. In your rebuttal testimony, end of page 4, you state that your understanding of staff's position in this case is that staff doesn't have any direct disagreement with the grid access charge. Do you see that?
Yeah, I do.
Okay. The staff's testimony, though, Dr. Glass's testimony, says that staff believes that the grid access charge has a legal problem. Is that right?
Mm-hmm. Right, and I think that's how I characterized it on page 5, row 3. That I viewed his concerns to not be about the rate design, but to be about the legal elements or the legal overlay on that rate design.
So what you're saying is Dr. Glass doesn't have a problem with the grid access charge, except it might be illegal.
No, I wouldn't. I hesitate to use that word, I guess. I mean, I think the judgment of illegal was in the record before the Supreme Court. I think what he's saying is that he sees parallels to what transpired with the demand rate. If you correlate that with our testimony, I think that there's an outcome or approach that could be used such that it's not illegal, but it's just a matter of support, not a inherent change to the rate design. It's more about the record than about the rate.
Okay. You had communications with Dr. Glass about the grid access charge outside of the testimony of this case, correct?
Yeah, early at the time of the remand, certainly we reached out to discuss what we heard or what we saw from what the Supreme Court said. I know I personally had some confusion about what was being communicated, and so certainly we reached out to kind of compare notes and impressions.
Okay. And after the initial round of comments in this case, you also reached out to Dr. Glass to talk about staff's comments. Is that correct?
Yes.
Okay. And you reached out by email. Is that right?
Yes.
Okay. And Dr. Glass responded to you in email and said that the difference between staff's comments about the legality of the grid access charge and the company's was that staff didn't see any way that it passes, the grid access charge passes the court's restrictions on discrimination. Is that right?
I think I recall that, yes.
Okay. I'm going to, figure out how to do this. Sharing with you a set of emails produced by staff in response to discovery. Do you recognize these emails?
Yeah, I believe I do. The names look familiar. The format is familiar.
Okay. I'd like to mark this as Sierra Club Exhibit 2.
Is there any opposition? Seeing none, it is so ordered.
So if we turn to this email, August 18th, 2020 from Dr. Glass to you. This is an email that Dr. Glass wrote to you in response to you reaching out about staff's comments in this case. Is that correct?
It looks like it. As you were scrolling, I was trying to track it. That's fair.
Okay. And we're talking about in the company's comments, company suggested a time of use rate that would be combined with a grid access charge. Is that correct?
Let's. Are you referring to the first paragraph there?
Yeah, I'm referring to, I'll highlight here.
Okay. Okay.
Dr. Glass says the difference between the comments being staff's comments and the company's comments are interpretation of the court's decision. And he concludes by saying staff doesn't see any way that time of use of the grid charge passes the court's restrictions on discrimination. Is that correct?
I see that, yes.
Okay. And then you had additional email communications with Dr. Glass after the company's direct testimony was filed mid-October. Is that right?
I accept that.
Okay.
I mean, just be transparent. I mean, it's our goal generally, to work with staff on rate design issues. It's been our experience that they are active in this front. I mean, if time allows and the situation allows, we would extend that also to curb. But it's been common for us to try to compare notes and achieve a mutually, I don't want to say beneficial necessarily, but mutually agreeable kind of approach to rate designs if we can achieve it.
I appreciate that. I wasn't trying to suggest otherwise. My question is just what was said in those discussions, not that there was anything improper about them.
Yeah. Well, I mean, because what a lot of these timeframes that you're talking about was in reaction to the Supreme Court opinion, and at that point there was just a ton of uncertainty about how do you deal with that puzzle that was delivered back to us, and so yeah, I mean, we were trying to explore the realm of potential solutions, and as it progressed, and we started to develop opinions, we just wanted to share where those were at and make sure that there were that they were aware of directionally what we were thinking.
Sure. So to set out the timeline, the company files, I think, October 13th, a proposal for a grid access charge. And then October 22nd, you have some email communication with staff about that proposal, in which Dr. Glass tells you, try to find the email here. Dr. Glass tells you that we, meaning staff, doubt that the grid charge will pass the Supreme Court ruling. He said that in response to your testimony proposing it. Is that correct?
Yes. Now I will add, in my context here, my dialogue is with Bob and Lana. So to me, that's how I interpret we.
Okay. Bob being Dr. Glass.
Correct. Dr. Glass and Lana Ellis, who are on the economics team together.
Okay. And then you respond the next day, October 23rd. This is actually goes this way in the chronology of the emails. You respond, thank you for the feedback. I'm not sure there's any path through the interpretations laid out by the court. Objectively, I prefer the grid charge over the minimum bill as applies the charge where it belongs, but I see the potential conflict with the court position. Is that correct?
Sure. Back to my original sentence there. I think the interpretations by the court were a little bit conflicting, in my opinion.
Okay. Then after after staff's testimony was filed in this case, and after staff's comments were filed in this case, you also looked at alternatives to the grid access charge and the minimum bill. Is that correct?
Sure. I mean, we were trying to be as open-minded as possible relative to other proposals that had been offered, but also new solutions. Was there anything else that could potentially help unwind this and give the commission a clear path to a rate design?
Okay. And sure. In those communications, you said that you were trying to focus on, quote, universal design only. Can you tell me what you mean by universal rate design?
Right. It goes back to the issue of that discriminatory language. That can be such a challenge. I think I spoke to it earlier today. You know, that when you try to do things in a universal manner, it's hard. But in this case, that's one of the challenges that the Supreme Court has put out there, is to try to come up with solutions that are universal in nature. And so that's certainly where I was going, to see if there was anything that we could do that was superior to what we had already proposed.
Okay. And along those lines, one of the things you considered was designing a demand charge rate for all residential customers, being one example of a universal rate.
Yeah, and maybe going back to where Commissioner French was at this morning, as we kind of unwound the documents and the proceedings that led up to the Supreme Court remand, it felt like that the demand charge was okay, that there was detail in how it was supported, or how the Supreme Court viewed the services rendered, but the rate itself made some sense. And so we started to toy with the idea of falling back to that in a universal manner. But ultimately we abandoned that idea.
Okay. By universal manner, meaning like all residential customers would have a 3-part rate?
Correct. We've observed that being deployed successfully in Kansas. There's a cooperative called Butler County Cooperative who had deployed it. And when we learned of that, it kind of gave us reason to believe that might be achievable for us. But ultimately, like I said, we abandoned that idea and stayed with our 2 proposals offered indirect.
When you say Butler Co-op has adopted it, you mean a residential class-wide 3-part rate?
Correct. Mandatory 3-part rate for all of its members, residential members. And I think they've had it now for about 5 or 6 years, I want to say, and have had pretty good outcomes as far as customer adoption, savings in their peak. They were able to lower, I think, their requirements with their transmission generation provider. So it worked really well for them and gave us hope that it might be something we could do. But again, it just, I don't know, the timing just didn't feel right. And so we abandoned it for now. And I don't mean anything clandestine by saying for now. It's just that, you know, the future is wide open, and we want to look at rate designs that meet our customers' needs and help the company be more flexible in the future as things continue to change in our industry.
Understood. I also wanted to get some clarification because this was in the testimony, and after reading it, I'm even less clear than before. So this is a question of the proposed grid access charge and which DG customers it would apply to. The issue of some people call it grandfathering, other people call it vintaging. So if I read your rebuttal testimony at page 16, to understand it, you talk about 2 different types of vintage or grandfathered DG customers. Right? One defined by statute 66-1265D, who interconnected before July 1, 2014.
Correct.
And then another set two, would be those DG customers who were kind of grandfathered or after the fact grandfathered through a settlement that would cover everyone, I guess, between July 2014 and I think October 1, 2018. Is that right?
That sounds right, yes.
Okay. So the grid access charge as proposed by the company, which of those two groups, if either, would the grid access charge apply to?
And well, and this was a little bit of the complexity that we were trying to capture, is that embedded in this is the need to understand where the commission falls as far as the deployment of the rate. And I think there's some room for guidance or direction there on how we get there. But it would be our intent, and this is what I tried to communicate in the rebuttal, is that we certainly want to observe and respect all of the grandfathering terms that are meaningful. But if we end up in a situation from the commission's out order in this case, where we have similarly situated customers, I mean, that ultimately are on the same rates, but they are differentiated in our systems because of settlements and other grandfathering steps that we've taken in this interim, it's our desire to try to get rid of those artificial grandfathering designations if they no longer have a valid purpose. So if by the actions of this commission, we end up with no difference between what was called the grandfathered customers and the going forward customers, then we propose that we apply the rate across all of them consistently and get rid of that grandfathering determinator for that group, that it no longer has meaning. But if there are others that simply by like the wording of the statute, there's no way around that. Those customers are going to be treated differently almost regardless of this proceeding. I would characterize, then they would remain grandfathered and treated according to those terms. So it's just a designation that we are interested in trying to clean up this situation. And if we can bring groups together under a common rate design, I think that's better for everyone if we can do it. So I think that's what I'm trying to communicate in that section.
Okay, to be honest, I'm not sure. I'm not sure I followed that exactly. So let me try to summarize it. You can tell me where I get it wrong. The statute 1266 has a carve out that says customers before July 1, 2014 can't be charged any rate that's at all different from residential customers, right? And so Correct. You're saying that's an immovable object. You're just all of those folks are going to be grandfathered, full stop. And then what we're talking about is those folks after July 1, 2014 through present. Yeah, I understand you just say you'll respond to whatever the commission orders, as you must, I guess. And then my question though is what is the company's proposal? Does the company have a specific proposal on how to treat those customers?
So yes, like for example, under the minimum bill, where it would result in all of those customers being treated the same.
So no grandfathering of any customer after July 1, 2014 for purposes of the grid access charge. That's a company's proposal.
Say that one more time for me.
Now, the grid access charge would apply to every DG customer who interconnected after July 1, 2014 is the company's proposal.
It's certainly our preference, but I would understand if the commission chose to apply it on a go forward basis only and perpetuate further grandfathering. But I would say it's our preference, yes, to cleanly apply it after the 2014 date associated with the other statute.
Okay. I think I'm more clear on that now. Thank you.
Yes.
Wanted to turn to minimum bills and specifically the impacts on low-income customers and kind of solutions, potential solutions to that. So I understand from your responses to commissioners' questions that the company's preference is to have some kind of self-identifying opt-out for low-income customers from a minimum bill. Is that right?
Yes.
Okay. So if I understand what that means for self-identifying, it'd be up to the customer to know about and then respond to some procedure in which they could trigger, and then there'd be some determination by somebody of whether or not they met some unidentified criteria of whether or not they are low income and then qualify for some kind of opt out of the minimum bill.
And we discussed that a little bit earlier today, that there could be a process ahead of that to help streamline those steps. It does not have to be onerous at all. But I think to try to apply some protection in a general form probably brings into a risk of providing cover or providing relief to those who don't need it. This is a certain way of giving the relief to those individuals who need it the most. The concepts of interacting with the company, making payment arrangements, utilizing payment support, those kind of things are probably not unfamiliar to these customers, and we could leverage a lot of those channels to communicate this additional piece of detail. So I really don't see that it's particularly a big barrier to customers. It's just a matter of being diligent about how we deploy it and making sure we give them every opportunity to identify themselves.
Is there any evidence? Are there any studies? Are there any experience at other utilities you can point to that to support the idea that it's not a big deal for low-income customers to self-identify and then proactively take steps?
No, that's a very, that's so specific to our context. I can't think of anyone that would even have a comparison situation necessarily. The point being here is that we have a small minimum bill that we're proposing. It's 278 kilowatt hours of energy use is the threshold. So right away, we perceive that we're talking about a small number of customers who are going to be impacted. And then within that, we believe that there's a smaller number that are low income. So, I don't want to characterize this as it's going to be some kind of a global difficulty for our customers. This is something that certainly could be navigated, and I don't have any reason to believe that our customer support people and our methods to communicate with folks can't achieve a high level of action for those customers that truly need it.
So the answer to my question is you don't have any evidence and support, but you don't have any reason to believe that it would be a problem. And that's effectively your testimony, right?
Well, sure, that's fair. And it goes back to my earlier conversations about low income as being, kind of hard to identify. If we were to go run a query against our database, I can't give you a high level of confidence that we would identify all of our customers. They just simply don't fit a small number of criteria. They take all shapes and sizes. And the only way to accommodate that reliably is to bring them into the equation and give them an opportunity to speak for themselves and claim this exemption if it's helpful to them.
I also, preparing for today, looked at some of your testimony from several rate cases back. And there was a reference in there to, there's another low income proposal, I believe, by Curve at the time, and you responded that there'd be a legal problem in implementing a different rate for low income customers because of a commission order from 20 years ago that found a low income rate for customers would be unjustly discriminatory. Does that ring any bells?
Certainly. I think we operate under the belief that there's a statute, or maybe if not a statute of practice, that the act of overtly subsidizing between classes is not allowed.
Okay. Do you have a concern that that would apply to what the company is proposing as low income opt-outs of a minimum bill?
No, I mean, I think it's probably directionally there, but I think that if the commission takes that into account as part of their criteria for approving this rate, then I think that gives us the support that we need to move forward. I think they have broad authority, to implement rates that are just and reasonable, and if this exemption is part of that definition, I think then that gives us what we need to be able to go forward comfortably.
So in your testimony, you identify the number of customers or bills that would be impacted by a minimum bill. And I think you point to Dr. Faruqi, who did a calculation, but it's in the tens of thousands. I want to say like 60,000 customers. Is that right?
I think I expressed it in bills, not customers. So that could be, it's not equivalent to customers.
Okay. The question is still the same. We identify it whether it's bills or customers, but I haven't seen, and maybe you can point me to it, a calculation of how much additional revenue we're talking about.
Yeah, see that was the challenge. We were unable to do that kind of an analysis, because in order to do that, you need to be able to have every bill and then compare every bill to the minimum to derive the delta. And we just don't have that data on hand at this time to do that analysis.
So we don't know if the commission implements a minimum bill, we don't know how much additional revenue the company is going to be taking in because of that change. Is that right?
Right. And on that, I mean, the two steps that we took, number one was the gradualism, to apply the charge at a discount from where it might otherwise be, but then also to create the provision for a mechanism to true that up in our future rate proceeding. Our goal here is not to profit from the interim rate at all, but we recognize that we're within a time window where our opportunities to really affect the change is limited. So if we were to, capture those costs and hold them for that future rate case, we can get it corrected then.
Let's drill down a little bit on that. There'll be two effects of a minimum bill on revenues, right? One is it'll increase revenues, and I understand the proposal is to defer that and deal with that in a future rate case. But then there's also an impact because more of the company's revenue is going to be certain. There'll be increased certainty to the revenue recovery for the company. Is that right?
I would characterize it, yes.
Okay, and that translates into lower risk, lower investment risk for the company.
Well, I mean, that's a big leap in my mind. I mean, in order for that to translate into investment risk, I think the dollars would probably have to get quite a bit bigger. I mean, this is, Commissioner French went there earlier. I mean, this is not in that category. So no, I don't agree with that characterization.
Right, so you're saying it wouldn't be material. We're not talking about enough dollars to make it material.
Well, material's relative, depends on who you're talking to, but I don't think it's impactful to our investment risk. It's certainly worthy of tracking. It's worthy of us getting it right, but it's not necessarily worthy of us adjusting our risk profile because of it.
I wouldn't expect you to say anything different. Thank you.
You're welcome.
Mr. Bender, I'm assuming you have more questions.
I'm actually checking my note. I'm near the end. I made a few notes during commissioner questions. I'm just trying to determine whether we've hit them all or not. Your Honor, I don't know if I've moved to admit Sierra Club Exhibit 2, but if I haven't, I would make that motion now, and I would not have any further questions.
I believe we did. Brian?
It was moved and admitted.
Yes.
I have nothing further then. Thank you.
Thank you, Mr. Bender. At this time, we'll turn our attention to Ms. Massatein. Good morning or good afternoon.
Good afternoon, Chair, and good afternoon, Mr. Lutz.
Good afternoon.
I wanted to start out by saying thank you for your participation in this docket and at this hearing today. I know you've now been on the stand, so to speak, for quite some time, so hopefully I can make these short and relatively easy questions to get through.
Okay.
And I would like to start out because after some of the commissioner questions, I did formulate some just clarifying questions I would like to ask you.
Okay.
So if you'll recall, when you were being questioned by Commissioner Keene, he asked if whether under an identical rate for every single customer, a subsidy would still occur. And I believe your answer to that was yes. And correct me if I'm wrong on that, but I wanted to clarify, so going to my question, if you have a 3-part rate and everyone on that rate, every Evergy customer, residential customer, had the same energy charge, same customer charge, and same demand charge, could you eliminate the subsidy?
I think you make great steps towards eliminating it, but I don't think it would be fully eliminated because the nature of the net metering and the existence of the excess creates still a pretty high potential for a customer to avoid some level of cost. Now, the goal is to avoid all subsidy. I don't know if that's the right goal. I think directionally that's what we want, but no, I think to answer your question directly, I don't think a demand charge by itself eliminates the potential for subsidy under a DG scenario.
Okay, thank you. Moving on then, isn't it true that DG customers, they also use the grid for standby capacity?
Yeah, certainly. I would characterize it that way.
Okay. Would you please explain then how a DG customer's reliance on the grid for standby capacity is different for a DG customer than for an energy efficiency adopter?
The presumption changes when the generation is added to the equation. In my opinion, when a customer is simply deploying energy efficiency, they're fluctuating their usage. When you introduce generation, you're not simply fluctuating, you are replacing your consumption. And the nature of being a producer of energy, to me is a distinct difference compared to like an energy efficiency customer.
Okay, thank you. So throughout the questioning today, there's been some discussion of how many customers will be impacted by the implementation of a minimum bill. On page 13 of your rebuttal testimony, you estimated that there were approximately 139,000 bills that are less than $35, or in other words, are less than that threshold. And I just want to clarify that number, that 139, I think it's 688, that's in reference to bills received, not individual customers, correct?
Correct.
Okay. Now, I know in parts of his testimony, Dr. Faruqi also talks about this same group of bills. Would you agree that there are only a couple months of the year that those bills would be impacted by the minimum bill? For example, not every month, typically, would that customer's bill be impacted?
I think that's fair. I mean, again, you can always find examples that defy the typical or defy this, but what we normally see is that there's a higher level of usage in the winter months and a higher level of usage in the summer months. And there's a shoulder period where you transition between them where that could come into play. Yes.
Thank you. Now, of that grouping of low usage bills, or in other words, bills that are charged for less than 278 kilowatt hours of energy, would you agree not all of those bills are being received by low income customers?
Oh, absolutely, I agree.
Would you also agree there's at least 3 subsets of low use customers? And by that, I mean, you do have low income, but you also have energy efficiency advocates and self-producers, correct?
And maybe the fourth category, which are those, maybe you mentioned the low users, but I mean, like the garages, the empty apartments, those kind of interim. I don't know, that's not quite a fair descriptor. I was unable to come up with a good descriptor for them, but they're the low usage, but it's intentional.
Perhaps not actively being used.
Right.
Which
That's
results
fair.
in the low usage.
Right.
Okay, so adding that in, you would agree then that there's 4 subsets of low use customers: low income, energy efficiency advocates, self-producers, and non-actively used dwellings or other structures.
Those work as broad categories, yes.
Okay. So what I'm trying to get at essentially is you would not characterize all low income customers as also being low usage customers, correct?
Correct. That's been very difficult to connect. I know it's a logical or a presumption that's easily accepted, but honestly, it's not. We've been unable to prove that definitively. In what studies we have done, to me it looks like low income customers fit in the same general categories as our other customers. There are high use, there's low use, there's moderate use. They're all up and down the spectrum, and their life condition drives where they fall.
In fact, would you agree that sometimes low-income customers can also be high users or have high usage?
Certainly. We see a higher occurrence of cohabitation of multiple families in older homes. So the combination of an old, maybe less efficient home with large numbers of people does translate into that higher bill and higher usage.
Thank you. Mr. Lutz, I'm going to switch gears a little bit now and focus on the income status of solar customers. You mentioned earlier that you were aware of a federal subsidy for customers who purchase solar panels. Is that correct?
Right. Tax related things, yes.
Could you explain to us how that subsidy works?
Probably not to the fullest extent that it deserves, but as I understand, particularly within your federal tax returns, you have the ability to disclose and claim investments in energy efficiency, or not energy efficiency, solar production equipment in your home, and receive credits on your tax in return.
Okay, kind of going off of that, the tax incentives. Are the tax incentives for high income customers stronger when it comes to purchasing solar panels than a low income customer? Or to rephrase, would it be more appealing or more likely that a higher income customer would take advantage of that?
So are you exploring that maybe in a lower income perspective, the tax codes are configured in such a way that the credits might not be as advantageous as someone who, you know, is fully exposed to the tax laws?
Yes.
Yeah,
That's correct.
yeah, that makes sense. I mean, if you've got thresholds to your income or something that keep you from having to pay high levels of income tax, a tax credit probably does not give you much value.
Okay, thank you. Are you aware of any research done by Evergy in the past about the income status of solar panel owners in Kansas, specifically in the Evergy service territory?
I did not obtain it for this proceeding, but that does ring a bell, but I don't remember the context or the result.
Okay. Well, to kind of push further, wasn't there a $20 million state solar subsidy instituted in Missouri?
Under the Senate Bill 564, is that the reinstatement of the solar rebates that you're referring to?
Yes.
Yeah.
Okay. Of the customers who took advantage of that, was the majority higher income?
I don't know that specifically.
Okay.
I mean, that those points underlie my comments earlier. I mean, I think we have a belief of that, and I could certainly, you know, search for documentation if that's helpful to the commission, you know, to support what you're asking about. But as I sit here today, I don't know that I can answer that truthfully.
Okay. Well, I appreciate the honest response, and I'll move on to my next question. Are you aware of any research done by any entities other than Evergy about general income status of solar panel users?
I am anecdotally, I did not compile it for this proceeding, but I do recall, I believe it was work done either in the EEI level or maybe even the RAP level. I'm not certain, but there's been some exploration of this academically. I've fallen short to adopting it because many times it has to be done at a regional level, and it starts to lose, I think, some of its potential applicability to the given situations experienced in Kansas. I mean, I use it as a directional indicator, but not as an absolute measure, you know, partly for those reasons. I think, you know, in this proceeding, I know that Mr. Gilliam looked at some EIA data, but you know, it was similarly positioned where it was limited to regional views, and sometimes those regions can be quite large, and I just hesitate to accept that they're necessarily representative of Kansas.
Okay. Well, thank you for your response.
Yep.
So I'm going to move on to what will be my last line of questioning. So you'll be done soon, Mr. Lutz. Evergy has a community solar program, correct?
Correct. Yeah, in all of our jurisdictions,
Could
both
you
in
tell
Kansas
me,
Central and Kansas Metro, yes.
okay, could you tell me a little bit about that program and how it works?
Right. These are voluntary programs where customers can choose to receive a portion of their energy from renewable resources. In our case, solar. They subscribe to certain levels and can have that reflected on their bill through a predefined charge. These programs were originally designed to be a alternative for customers who maybe can't or have some aversion to actually putting the solar panels on their homes, whether it be just maybe a concern about putting holes in their roof, or potentially they're renters, or maybe they don't perceive they're going to be in that home for a long time and they want some flexibility with their renewables. But the programs that we've designed allow them to incorporate renewable energy into their service.
Okay, great, thank you. Does that program recover all of Evergy's fixed and variable costs for solar?
Yes.
I should say all the fixed and variable costs put into the program. Does it recover all of those?
Right, for that program cost. It represents an adder to the customer's normal bill.
Okay.
Yes.
Now, if in theory, this is hypothetical, if all DG customers were to switch to using Evergy's community solar, would the subsidy still exist?
No.
Okay. And final question, would you agree that community solar is more efficient in terms of output to cost compared to rooftop solar?
Yes, simply because in most cases you can put in larger systems, which reduces your dollar or your cost per kWh cost. So yeah, you get economies of scale from those types of approaches versus smaller individual systems.
Okay, thank you. And with that, Mr. Lutz, I don't believe I have any further questions. I appreciate your time.
Thank you.
Very quickly, following up on the line of questioning, if I could, Mr. Lutz, community solar arrays versus personal, then probably we would all ride the bus instead of have individual cars because it might be more efficient.
Right. Reasonable parallel. Yes. You know, maybe the one difference is that within the solar option, it is at your full convenience, where in the bus scenario, you're constrained by schedules and paths, and, you know, some of those constraints on ridership probably aren't directly paralleled in the solar.
That's true. So about your solar program, I understand there's a wait list. So what is the wait list and why is there a wait list?
Right. What this is an attempt to be prudent in our build out. We want to make sure that we're not entering into a speculative type approach on this. So we queue up the customers and then build is the approach, as opposed to building and having excess available and waiting. It's just a more prudent approach to make sure that we don't overinvest in that particular resource.
Okay, so you're saying when I sign up for that solar program, I am always, quote, getting it from your community solar and not from an individual solar that they've are supplying their own energy at 5 o'clock on a July 14th And so I've signed up for the program. So mine is coming from that community solar and not from my neighbor next door, Marilyn, who's got panels on her house.
Right. No, let me differentiate here. The program that I describe is largely an accounting exercise.
Right.
If you want to look at the electrons and the flow of things, the analogy that I always use is the grid is like a big swimming pool. And when you need energy, you dip your cup in the pool and you take the energy out. And when energy is produced, whether it be by our Iatan power plant or by an individual DG, it flows into that pool. So to be able to account for electron by electron it's not a worthwhile experiment. I mean, you're from a practical point, if you are closer to Maryland, you're probably going to get those electrons before you get electrons that are miles away. It's this big collective of energy that exists on the grid. But what we're trying to do is you overlay on top of that an accounting or a financial transaction that replicates the movement of that energy. It's not the true movement of the electrons, but it's an accounting mechanism to do the same thing. So
exactly. All right, let me just follow along that, because you're right. It is an accounting exercise. So that said, why aren't we including rooftop solar in your community solar? Or, and that could be from somebody who lives on, in a house, or that could be the energy that's coming back from a government building. Why does it have to be a community array?
Well, the part of it is for that accounting purpose. Right now, the customer that has that on their house is making first claim on the production.
Right.
So they are going to consume every bit that they can from that particular array. So it's very possible, and to use some of the lines of questioning in today, in the same way there are many hours where there's excess, there are many hours where there is not. And so because of that consumption at the point, it's not a reliable source, to offer for subscription, because you don't know what you're actually going to get from that DG system. And so the accounting becomes very, very complicated if you're going to try to allow for that level of fluctuation, whereby the company installed approach, you have a constrained connection that can be metered and you know exactly what it's producing, and that can be reliably transferred to other customers through the accounting process, and the timing can be done so that in a way to fit the billing cycles. To expand it into what might be called by some that virtual net metering world is a whole different level, and I think honestly has not been allowed in Kansas, I think due to the perception that you have to be a utility to provide that service. So it really changes the game if you're going to try to look at it from that collective view.
But it is just an accounting maneuver. The bottom line is it's just an accounting maneuver, how you do that. All right, let me ask one other thing, because I know time is running late. So let's say I've got panels on my rooftop and I buy an electric vehicle. And I actually put a charger in the garage, a 240 prong charger. I didn't travel anywhere today, tomorrow, yesterday. So now I've got energy flowing back on to the grid. are you going to start differentiating on my movement of energy through my charger? My understanding is that Evergy is really pushing the EV way of doing things, and I think that's great. But if I have my personal charger and there's energy going back on the grid, so how are they accounted for?
Yeah, it may be easier in that scenario just to treat the car like another load. And I don't know that it's necessary to differentiate the fact that it's an EV.
But isn't that a different type of service that they're getting? In that you just said, if they push something back onto the grid, that's a different type of service. And that's really what's differentiating the DG customer.
Right.
So
Now,
I guess I'm confused.
No, I get where you're going. And in this case, you're referring to the car as serving as a battery. Is that what you're saying?
Exactly.
Okay, because I think in some situations now, those cars they don't act as a battery. I think you can charge them, but I don't know that their software always allows you to turn it around and push that power out. I know that was a thing that recently Tesla commented about, but yeah, if a customer were to install a battery, I think that does start to enter into the potential of changing the level of service. We don't have a rate for that today. I can't say that we've explored that fully to be able to tell you how we think we should best respond to a battery in a residential situation, because in those cases, it's not really a generation source. If you're just strictly talking about the battery and not the solar panels, a battery could be just taking our own grid power and holding it and then using it for a different time or a different purpose. But if you put a battery with a DG system, then that also starts to change its behavior. So
but the battery is in the car and it's just reversing the direction. That's one. And two, with a DG customer, you're calling the service you provide them at night as a backup alternative source, like a battery.
From their perspective, I would offer that, yes, because under the net metering concept, if they have that excess, they're delivering that to the grid, and there's a kind of a presumption or a feeling of an offset through that monthly period, that their gives and their takes are being netted out across that period. So, I mean, the trouble is with your hypothetical, is right now we don't see that EVs behave that way, that they can be used as a grid battery. Right now, they're just really a load. So that allows us to view them in this way as being, just a load. In the future, if car makers want their batteries to be dispatchable and be part of the grid, then I certainly think that changes a lot of things. Those customers are now providing services back to the utility potentially. They're under that scenario, I think the net metering rules would need to be modified to allow for a higher level of service just beyond excess, to help reflect those services that a battery could provide, to the grid.
I think that future is here. I don't think we have to wait. I think it's, it's here.
It's getting there. I mean, you're right. There's a lot of talk, a lot of work within the industry to deal with batteries, to how to best represent them and give them their proper place in the grid. Certainly.
Thank you. And why don't we turn to Evergy and Kathy or Ms. Dingus for redirect, please?
Thank you. Just briefly. Mr. Lutz, you were talking with Mr. Bender about the difference between the class cost of service values and the revenue requirement allocation that was ultimately approved by the commission. Do you recall that?
I do.
And I believe in your answer, you were referring to Dr. Faruqi's testimony where he had stated an amount of the difference between those two numbers. Is that right?
Yes.
And you also reference, I think, the appendix to the stipulation and agreement that was approved by the commission earlier in this docket. Does that sound familiar as well?
It does.
All right, I am going to share my screen here if I can. And what I've got is Appendix C from the stipulation and agreement previously filed in this docket that was ultimately approved by the commission. Is this the agreed upon revenue allocation of the settled decrease among the classes, Mr. Lutz?
Yes, I believe that to be what you're showing.
And what was the agreed upon decrease for the DG class?
It is that $4,103.13 number.
And that was the difference that you were referring to that also shows up in Dr. Faruqi's testimony. Is that correct?
Right, and that's a quantification of the delta between what was filed and what was, or not what was filed, but that's the decrease that was observed by the customers in that class. So that gives some shape to the amount that Mr. Bender was trying to quantify in examining the grid access charge calculation.
Thank you. And this is already part of the record in the docket, so I don't think we need to make it an exhibit or anything. Thank you. Mr. Lutz, you also, I think with several of the attorneys, have talked about the difference between energy efficiency and customers with distributed generation. And I guess I just wanted to ask some follow-up questions on that. Is it correct that distributed generation only reduces a customer's usage when the sun is shining?
Right, and net of their consumption, yes.
And I think there's been a lot of discussion around this from you and Dr. Faruqi, but we typically don't see a decrease or a significant decrease in demand for those DG customers. Is that right?
Right, and that goes into also some of the work that Dr. Glass did in his analysis, yes.
When a customer installs energy efficiency, so maybe a more efficient appliance or other measures to reduce their usage, is that I guess a permanent or consistent reduction as opposed to kind of a reduction that would fluctuate?
Yeah, certainly it depends on the measure, but yes, generally, particularly in the areas of lighting or heating and cooling, things that are very regular in the use of that home, yes, I would agree with that.
And you would also expect to see a reduction in the customer's demand when they install those types of measures?
Generally, yes.
Thank you. You had a conversation with Mr. Astrab with Curb about, I think you said something about the minimum bill not being discriminatory. And I just wanted to explore your understanding of discriminatory a little bit. Do you agree that typically discrimination is when there's different treatment of similarly situated people or individuals?
Correct, yes.
And are distributed generation and non-DG customers similarly situated?
Right, no, they're not. There's, as we've asserted throughout the testimony today, there's a different level of service being received from DG customers.
And so is it your position that both the minimum bill and the grid access charge, in fact, should not be considered discriminatory for that reason?
Right, right. The more proper emphasis would be probably to represent alignment with what the Supreme Court was communicating more so than that use of the term. Yeah, good, excellent point.
And just one more question. If the commission were to approve a grid access charge of $3 or a minimum bill of $35 as the company has proposed, would any future change to those amounts have to be vetted in a rate case and also approved by the commission?
Yes.
It's not something the company could just change on its own.
Correct, correct. It would be under the commission's authority before we would make any changes whatsoever.
Thank you. I don't have anything further.
Thank you. We will push on, and we are ready for Recross. And Ms. Kafer with Pioneer.
Thank you. Excuse me. Mr. Lutz, again, I think it's because I came late to the party, but I do need to get some clarification on one point from you. This morning, Mr. Vincent, he asked you some questions about the Supreme Court order, which I'll put up here again so that you can look.
Thank you.
Well, I thought it would. He asked you about this language in here.
Right, at the tail end of that section.
Right, and if I could refer you to page 10 of your rebuttal.
I'm there.
And at the very top on lines 1 through 3, when I read this in your rebuttal, I took away from this that you were saying that during the first part of this proceeding and the appeal and the record that was presented to the court and arguments that were made at that time, they were focused in a different area that really and then coupled with what you said this morning in response to someone else's questions about Supreme Court proceedings seemed to not focus in that, but as you went through it, it changed its focus to the actual outcome or impact of the rates. What I understood you to be saying is the court hadn't really focused on this question of whether it was different services, because that really wasn't what was being posited and argued during the first phase.
Correct. That is my opinion. Yes.
Okay. So this language in the court's order here, when they talk about all of this was providing the same services and selling the same energy, would you agree that looks like that was an important aspect of the court's decision, or at least a foundation upon which it was relying in making its decision?
I think it was, but again, as I read the order or the opinion and parts of the discussion of the case itself, that it really didn't feel like it got all of the support that it needed to be reflected properly in the court's opinion. And again, I'm not a lawyer. I mean, I've declared that many times, but to me, the commission was very clear in that determination. And for that to get lost here was confusing to me. And I do recognize the words that are on the page, and this was causation for my pause earlier when this was brought up. That I see what the words say, but I don't feel that it occurred in the way that was sufficient to reflect what the commission has already determined on this point.
So in light of the record, the way the record stood at the time, this language then shows that the court assumed the DG service was the same service. It was making that assumption, but to the extent the additional evidence, whatever might come out from this phase would establish that it's different services, that would show that this assumption was incorrect. Is that?
Madam Chair, this is Dave Bender, I'm going to object. I mean, that we've gone down this a little bit, but the witness can't testify to what the Supreme Court knew or didn't know or assumed or didn't assume.
No, but the witness, if I may respond, the witness has been involved in all of this and can give us an idea of what was presented by the parties, what happened the first time around, and this decisions of the court. The attorneys will argue what it means, but to have that basic understanding of what happened does change what this language right here means. And, ultimately the commission will make that interpretation, but I think that's an important fact to get out from the people who were involved in the proceeding the first time around.
And Your Honor, I would just say that was not the question. And I don't think the foundation has been laid for whether this witness does know what or wasn't argued at the various stages of appellate litigation in the case.
As we've been on this discussion several times, I am going to allow it, but let's get to the point, Ms. Kafer, because we've been back and forth on this, and Mr. Lutz has said several times he is not an attorney. So that said, continue on.
That was my question. It was putting these words in context based upon what Mr. Lutz had already testified to in the record in his pre-filed testimony, as well as this morning's testimony. Thank you. And that is the only question I have.
Thank you very much. Okay, we will move on to Liberty Empire, please.
No further.
Clarity.
Yeah, no further questions. Thank you.
Thank you. KIC, Mr. Vincent.
Maybe just one or two questions on this.
Excuse me, Ms. Kafer, if you could take down the page, that would be great. Thank you. All right, proceed.
Thank you, Madam Chair. Maybe just one or two questions on the Supreme Court's decision and the record on appeal. Mr. Lutz, a few moments ago, you were testifying, or you offered some testimony regarding the Kansas Supreme Court's opinion. Do you recall that?
I do.
And I know you're not a lawyer, so I won't ask you for a legal conclusion, but I believe the point you were trying to make was the different types of services that might be offered by a utility were not a key issue in the appeal before the Kansas Supreme Court or the record preceding it. Is that a fair summary?
Yes.
Okay. Do you have a copy of Mr. Gilliam's rebuttal testimony in front of you?
Allow me a moment.
Madam Chair, I'll go ahead and share my screen again for the convenience of other parties.
Now, are you referring to the cross answering?
I believe I am referring to the cross answering. I'll pull it. I'll get it on the screen for everybody. This is Mr. Gilliam's cross answering testimony filed on November 23rd, and I'll direct you to, I believe it's page 5. Well, I believe it was page 5. Oh, here we are. Yes, it is page 5 of that testimony.
Okay, I'm there.
Okay. Do you see footnote 9 that's referenced on line 18?
I do.
And can you follow that down to the actual footnote where it's presented on this page?
Right, the highlighted word.
Well, not necessarily the highlighted word. I want to get the whole parenthetical into the record. Do you see in footnote 9, on the second line of footnote 9, the beginning of a quotation that says, "as the evidence presented here shows"?
Yes.
Will you read that sentence into the record, please?
As the evidence presented here shows, users of renewable energy, mainly solar power, constitute the entire RSDG class. As a result, we find that the KCC's attempt to distinguish between customers using renewable energy sources and partial requirements customers is disingenuous.
Now, this language that I just read, or that you just referred into the record, is from the Kansas Court of Appeals, not the Supreme Court. Suffice to say, though, would you agree that the record on appeal did contain elements of different services between distributed generation customers and non-distributed generation customers?
Sure, Duffy, I'm going to have to object. That's a total mischaracterization of what that's saying and what it's referring to. This is talking about the difference between renewable generators and the potential to have an individual generate power with a non-renewable generator. And the court's saying, you know, you don't have any customers who don't have, this is all solar panels. We're not talking about a customer that has some other kind of generator. I don't think this language is relevant at all to the issues before the commission or the issues that have been discussed today.
Madam Chair, may I respond to that objection briefly?
Briefly.
The issue is whether different types of services were before Kansas courts on appeal, and the utility has indicated that they were not. As a result of that, we are trying to show that the commission actually did present an argument before Kansas courts that distributed generation customers took different service than non-distributed generation customers, and the court rejected that argument. To say that this argument wasn't presented or before the court is not an accurate recitation of the record on appeal, and that needs to be recognized here.
Michelle, if you could move us into a break room, please.
And Chair Duffy, may I just respond briefly before you go to your breakout room? Or
okay, quickly.
I just would say again that that's absolutely not what that quotation says. And if we had the full context of the order, I think that would become even more clear.
Quick. Okay, thank you.
Thank you.
Michelle or Brian?
Hey, Robert, you're still sharing your screen. I don't know if you intended to do that or not.
Oh, I do. I just, I've got the actual full opinion in front of everyone now.
Understood. Just letting you know in case it wasn't intentional.
No, I might turn off my banners though. Here, we'll turn it off for now.
I believe we're all back and we are going to sustain the objection, please. So if you can move on, Mr. Vincent, with your line of questioning.
Thank you, Madam Chair. Just for the record, I don't know if I necessarily have any more questions for Mr. Lutz, but for the benefit of the parties, I was going to have him read from the entire paragraph of that section for context, since that issue has been raised with the commission's permission.
Same objection, Chair Duffy. I think you already written that.
Let us move on. Thank you, Mr. Vincent. I'm sustaining.
KSE has no further questions at this time. Thank you, Mr. Lutz.
All right. Thank you, Mr. Vincent. And we move to Susan Cunningham with KEPCO, Midwest and Sunflower.
No questions at this time. Thank you.
Thank you. Curb, Mr. Asterat.
Curb has no recross this time.
Thank you. CEP, Sierra Club, Vote Solar, Mr. Bender.
Yeah, I will have a couple of additional questions. Thank you, Your Honor. Mr. Lutz, you were asked on redirect. You were shown the appendix to the stipulation and settlement showing a $4,103.13 reduction for DG customers. Is that right? You have to turn your mic on.
Correct. Thank you.
What was that $4,103 reduction applied to?
In the context of that example, it was applied to the rates at the time of that general rate proceeding, reducing those rates going forward out of that case.
Right. So the existing revenue in the test year ending June 2017, correct?
The
yeah.
Say that again. I want to make sure that I'm precise here.
So it's a revenue reduction from existing revenues, right? And existing revenue is being defined as under the existing rates before the rate case was filed.
Yes, I agree with that. Yes.
So it's not a $4,103 reduction from Mr. Amon's cost of service revenue requirement. It was $4,000 less than the then existing revenues, correct?
Correct.
Okay. And I think your testimony earlier was you don't recall what the then existing as of the end of the test year revenues were from DG customers, correct?
Correct. But I think that exhibit would tell you that, because didn't one of the columns was the beginning revenue amount? Is that correct? I'm trying to recall. There were multiple columns on that exhibit, and I think one of them would have been the.
I can share my screen with you.
Yeah, if you've got it, that would refresh my memory. Thank you.
I believe this is the exhibit you're talking about. This is okay. Appendix C to the settlement.
I withdraw my statement. I thought that first column was reflective of the revenue requirement, but this is the decrease only. This is the delineation of the decrease only.
Correct.
Yep, I stand corrected.
Okay. So my original question was, do you know what the end of test year 2017 revenues were from the DG customers?
Not as I sit here today, no.
You're also asked whether DG only decreases customer loads when the sun is shining. Do you recall that question?
I do.
Do you know the coincidence between system peaks and hours when the sun is shining?
Are you wanting to refer to just the residential class peak or the true utility system peak?
Either.
I mean, I'm generally familiar, yes.
Okay, and the company's system peaks and residential class peaks have all occurred in sunlight, daylight hours in recent years, correct?
Yes.
You were also asked by Ms. Kafer about your understanding of the Supreme Court arguments and what went into its decision. Are you also familiar with the arguments made to the Court of Appeals?
Not as directly.
Okay. No further questions.
Thank you, Mr. Bender. Staff.
Staff does not have any recross questions of Mr. Lutz. However, kind of a procedural question. Back when Commissioner Keene was asking Commissioner French was asking cross-examination questions of Mr. Lutz. He shared his screen to include a report from the company, and I just wanted to double check. Does that need to be entered into the record?
Sounds like a question for Brian.
Yeah, I'm looking for Brian.
I would say it could just be an illustrative, but I mean, it's a filing with the SEC. If the company has no objection, I think we could also take an official notice of that document.
Okay, seeing no objection, it is so ordered. Thank you.
So
all right.
It was an Evergy docket, document, so we will mark it as, I think that's Evergy 1.
I believe there's, and not to be a pest, but I do believe there's already one Evergy exhibit in the record that came from Commissioner Keene's questioning of the witness.
It was
So
changed. It was actually changed to a.
Yeah, that's been renumbered Pioneer 1.
Okay,
So,
I apologize. Thank you all.
No, that's, I'm glad you're keeping us honest.
All right, very good. We are now ready for Commission Recross, and in case you're wondering what's going to happen the rest of the day, we will bring up witness Faruqi, and we will finish with him today. So there'll be a break after Commissioner Recross for 5 minutes, and then we'll jump into our next witness. So I'm looking at commissioners and Commissioner Keene. Or let me just start with Commissioner French, since I think he was first out of the chute. Is that correct?
Fair enough.
All right.
I am going to endeavor to be as quick as possible. I had hoped to have no further questions, but some of the things the parties asked, led me down a couple paths. Unfortunately, I want to ask you a question about some of the language in the Supreme Court order again. And let me preface this, that if you have any discomfort at all in answering this, and you feel it's more appropriate for counsel to brief it or for counsel to answer it, I'm fine with that. Because I do have some level of discomfort of asking a witness your view of Supreme Court's words. So let me I'm going to share my screen. I'm going to share the slip opinion here. If I can find it. All right, can you all see this?
Yes, sir.
I'm at page 4 of the opinion, and you can see the first sentence I've highlighted here is, all along the utilities arguments have been driven by their view that the ongoing viability of their economic model depends on fixing the inequities created by DG customers by not paying their fair share. And when they talk about the inequity of DG customers not paying their fair share, that they're talking about the purported subsidy flowing to those DG customers. Is that correct?
That is my understanding. Yes, sir.
And then they have sort of this aside that maybe puts some blame on the utility, but then they move on and they say, in any event, we are not insensible to the economic arguments. We find that in this particular case, we can move past them with relative ease. This is because the policy of favoring customers who generate a portion of their energy from renewable sources was chosen by the policymakers in our legislature and is cemented in Kansas law. And in interpreting and enforcing the statutes as they are written is the job of this court, not deciding whether those statutes affect good or bad policy. I think this was in Kerb's opening statement, but it hasn't gotten much discussion. and I find this section interesting because I think it could be read to say, you know, this is one subsidy that Commission, your hands just need to be off of it. It's not something to be fixed. It is the policy of the state of Kansas that we have this subsidy or a policy favoring DG customers. Is that how you or the company have read that portion of the opinion? Do you have a different thought on this portion of the opinion? And again, if you want to reserve this to briefing, I understand.
Well, I would offer we probably should do both. I'm certainly willing to offer my opinion, but I think that the briefing would probably be the more authoritative and informative response. But for my part, I am unaware of an overt policy that says anything about favoring customer generation. Now, as I read this, and especially as you transition into the following sections, they start talking about PURPA. And my connection here is to say that Kansas follows PURPA is in a way how I viewed this, that I don't know, the word favoring feels generous to me, but you know, Kansas certainly you know, has abided by what PURPA has set out to do, and we as a utility as well. I mean, it's not at all beyond what we're wanting to do, but as far as an overt policy, this is news to me, that, you know, if there is something, it has not been offered in any proceeding up until this point, whether that be the rate cases or the general proceeding in 2016. So I don't know how to interpret that phrase.
That's fair. Let's see. You know what? I think I will just stop there in the interest of time. Thank you, Mr. Lutz.
Thank you.
Thank you, Commissioner French. Commissioner Keen.
Yes, could we, am I on? I guess I'm on. Thank you. Two questions from me, Mr. Lutz. I think we're going to award you the Endurance Award of 2020, for sure. I appreciate your indulgence. You seem to respond to all the questions still with a maximum acuity. Two questions for me, one of which I'll end with is the most obvious one I should have asked the first time around. The first one is, since the minimum bill proposal, if adopted, would, if adopted by the commission, would affect all residential customers, DG and non-DG. I'm not saying alike, I'm just saying it'll affect them. As contrasted with the grid access charge, is there any risk that an effect of the minimum bill proposal will be to further defer the prospect of either narrowing or eliminating the purported subsidy or free rider problem?
Yes, I think I would say yes. I mean, because the minimum bill approach is more generic or more unfocused is the word that I'm trying to work around. I mean, it's broadly applied, And although that does generate, a certain amount of revenue from that action, it's not specific to the subsidy issue that's created from the DG and net metering situation. So I think although it does provide some relief, it's maybe not targeted in such a way that it addresses the subsidy as precisely as I think the grid access charge does.
All right, thank you. My last question is so obvious. I'm disappointed in myself from having not asked it at the outset of your cross-examination with me. So here it is. It's a very generic kind of thing, but it's so basic. And if it's been asked and answered before, my apologies. I haven't heard it, but if I missed it, but please indulge me. Here's my question. As between the grid access charge and the minimum bill proposals that you're suggesting we basically consider and choose between, that's basically, I think, the Evergy position.
Mm-hmm.
Why did Evergy prefer the grid access charge?
I'm going back to the question we just answered. I think that it's a more appropriate design to address the key concern of the company, which has been the cost shift all along. Going back into the rate proceedings, going back into the general proceeding. In both of those contexts, the issue was driven by the cost shift and the problematic nature of the two-part rate. And so this grid access charge is structured in such a way that it helps us respond to that need. So to me, it's just about the nature of the design and how it addresses what is ultimately the need of this proceeding.
All right, very well. Thank you, Mr. Lutz, for your indulgence and for your excellent answers. I appreciate it.
Thank you.
Mr. Lutz, I just have one question following up on Commissioner Keen. Whether it is the grid access charge or the minimum, the fee, both of them have an element of gradualism embedded. Is that correct?
That is correct.
And if we have another year, like we did this last year with the growth of rooftop solar, distributed generation, will that put the gradualism? I mean, you admitted that we don't know how we're going to ratchet it up, but would it make it ratchet up higher or quicker, I guess?
Certainly. It's driven by that number. But with that said, I don't want to discount the ability of us collectively to come up with rate designs in the future that can address this. If you look at the other jurisdictions that have high penetrations of solar and have moved beyond net metering and are starting to move into what they call net metering 2.0, or whatever those replacement rate designs are, there is a path through this. So I think that it would be to our collective advantage is to learn from those and explore those in a future rate case. And I used the phrase earlier, cut the corner, and maybe that's what we could do. So I don't necessarily want to accept that just because solar will continue to grow, that it's a foregone conclusion that we have to continue to raise these charges. That there may be a more elegant approach that we can come up with that can address it and do so more appropriately.
I think that is the issue that we face in every industry, that technology is pushing the boundaries beyond our rewriting rule and reg, coming up with new ways of transacting business. So I would agree with you. With that, commissioners, one more look. You have no more questions. Thank you. We will take a 5-minute break before we bring up the next witness. I have it's 3:35, so we'll begin at 3:40.
Chair Duffy, just briefly before we take our break, I just found out that Dr. Faruqi is only available until right about 5 today. He's got a phone call with someone in Asia that he's got to take at that time. I just wanted to let you know in case that affects order at all.
Okay, so we will probably talk about that. Thank you for sharing that with us, Ms. Dingus. And when we go on our 5-minute break here, please mute yourselves. Thank you. Brian, do we need to talk about the order at all? Let's go into a breakout room, commissioners, if we could. Thank you. Michelle or Brian?
Do you see the option on your screen to join?
It's not there.
It's open. It's just waiting for you to go into it.
Okay, it's 3:40. We are back on the record. Our witness is Mr. Ahmad Faruqi for Evergy, and we will begin with commission questions. And I do believe
Before cross-examination,
she's got to be sworn in. All right. Yes, thank you.
and his testimony introduced.
Ms. Smith, if you would do the honors of swearing him in, please, and admitting his testimony. You are muted.
Sorry about that.
That's all right.
All these details.
Yes.
I don't see the witness yet. It's not on my screen if he could speak, so.
That's me. Can you hear me?
Yes, now I can. Thank you. Do you solemnly swear to tell the truth, whole truth, nothing but the truth, so help you God?
Yes, I do.
Thank you.
Dr. Faruqi, can you please state your name and business address?
Yes, my name is Ahmed Faruqi. I am a principal with the Recross Group. I am located in San Francisco at 2800 Mission Street.
Did you cause to be pre-filed in this docket 16 pages of direct testimony on remand with 2 attachments and 26 pages of rebuttal testimony on remand with 1 attachment?
Yes, I did.
Do you have any corrections to that testimony today?
I do have one correction in my rebuttal testimony, and I would like to point that out. It's on page 4 of my rebuttal testimony, line 9, where it says DG, it should be non-DG, and where it says non-DG, it should be DG. So that's on line 9. So it should read, the annual cross subsidy from non-DG to DG customers had risen to $200.
And with that correction, if you were asked the same questions today under oath, would your answers be the same?
Yes, they would.
I ask that the testimony and exhibits be admitted into the record and tender the witness for commission questions and cross-examination.
And Madam Chair, I have an objection to make to parts of one of those pieces of testimony. We'd object to the rebuttal testimony, page 2, line 20 through 21, page 3, line 1 to 2. Similar objection on the next page. The first objection is to testimony that repeats some advocacy statements made by California utilities in California proceedings, which are hearsay, in addition to prejudicial. We don't have the actual witness who said those things to be able to cross-examine. Similarly, rebuttal page 3, line 18 through page 5, line 3, and page 6, line 10 through page 8, line 5, include long block quotes from similar California utilities. And then the fact sheet that's attached to the rebuttal testimony as well is an advocacy piece by a California utility that's being admitted for the truth of the statements contained.
Okay. All right. Commissioners, let's just go briefly into a breakout room. Thank you, Brian.
Ms. Duffy, may I just respond briefly?
Yes.
I apologize. He was jumping around pretty quick there, but I think I understand the gist, which is that there are references to testimony and documents from a California docket. The point of those references in Dr. Faruqi's testimony is to give examples of how other utilities are proposing to deal with the situation that we face. And so truth of the matter as Mr. Bender suggests, but instead to demonstrate that this issue exists in other states and how those utilities are dealing with the same issue that we face.
All right, thank you.
Before we leave, could I have Mr. Bender repeat the exact lines that he identified?
Yeah, and there's actually three.
Okay.
So there's a similar objection, which is hearsay, prejudicial, and irrelevant to the rebuttal line, page 3, line 18 through page 5, line 3. Page 6, line 10 through page 8, line 5. And then on page 5, line 16 through page 6, line 9 is a testimony about a settlement that's, or at least the witness's rendition of a settlement that's not in the record, which would also be hearsay. It also falls under Rule 60, 467, best evidence rule. It's testimony about a written document rather than introducing the written document. And then the fact sheet that's attached to as an exhibit to the rebuttal is it's the California Utilities advocacy pieces. Page 2, line 20 and page 3, 1 to 2, those are statements about purporting to quote the Supreme Court decision, but in a similar vein to some of the testimony we've had today about what certain things mean, I think omits pieces or misrepresents pieces of what's being quoted there. So that's that objection, which is separate, but the other two are similar.
Brian, did you get all that?
Yes, enough of it, yes, for a breakout room.
Okay, very good. All right.
And I guess maybe I'll just respond if I can, because I think there were like 3 new objections added there that he didn't indicate the first time. So, the discussion of the Supreme Court order, we've already had extensive questioning of Mr. Lutz from Mr. Bender about the Supreme Court order. I don't think this is any different than the nature of what has already been going on. And I think it can just be taken for what it's worth. Everybody can read the order for itself. The discussion of a settlement, he referred to a Rule 60, which I have no idea what is. I don't think that's a Kansas rule. But Dr. Faruqi's testifying to his understanding of something that happened. I don't think there's any prohibition against that. So thank you.
Thank you, Ms. Dingus. Okay, Brian, if you would, please.
Yeah, we'll go into a breakout room.
Thank you, everyone. I believe we're all back. I am going to overrule the objection. We'll give it the weight it deserves. Please move on. Thank you.
Chair Duffy, then I guess was actually witnesses ready for commission questions.
Okay, thank you. You're right. So commissioner questions.
Did we admit the testimony?
Yes, we did.
Yeah, we admitted it before the objection, but we can admit it again if we need to clear the record, so.
We'll admit the testimony. Thank you. It is so ordered. All right. So Commissioner French, please begin.
I have no questions for Mr. Faruqi. Thank you.
Thank you. And Commissioner Keen, please.
Yes, thank you. Mr. Faruqi, I have but two questions for you. I would say as a preface to that, in fairness to you and your testimony, both the pre-filed as well as today, we have, I think, collectively benefited from a fairly exhaustive questioning process with Mr. Lutz. And I think we're disinclined to try to repeat those again for, I don't think that's of any value. The two questions I'm going to ask you are the two last questions I asked of Mr. Lutz today. And they're overview kinds of questions, but I think there's benefit in asking the same questions of you, because each of you, while experts in your own regard, may have different takes or slightly nuanced different takes about the same question. And I think the question is such that it deserves that. You can judge the latter for yourself after I've asked it. But my first question it has to do with the alternative suggestion that Evergy is suggesting. Basically, I think they're indicating that their preference would be to do a grid access charge. The fallback to that would be the minimum bill. I want to ask you about the minimum bill and compare it to the grid access charge in this way. Since the minimum bill proposal, if adopted by the commission, would affect all residential customers, both the DG and the non-DG. I'm not saying that it could affect them alike, but it would affect all of them. As contrasted with the grid access charge, is there any risk that an effect of the minimum bill proposal would be to further defer the prospect of narrowing or eliminating the purported subsidy or free rider problem?
Great question. Thank you for asking, Commissioner. As indicated in my testimony, my preference is to go with the grid access charge. And a backup plan is the minimum bill. And the simple reason for that is that the issue we are talking about specifically relates to DG customers. And it relates to the fact that they reduce their energy consumption by a significant amount. Under a volumetric rate, they end up not paying their full share of the cost of being connected to the grid. And that has to be recovered from other customers. It's a cost shift issue, primarily originating from the presence of DG on the roofs of those customers. And by the way, I should indicate that I am a DG customer myself. Of course, I live in California. I have solar panels, I have battery storage, I have electric car. So 4 years ago, I did a massive home energy efficiency upgrade. From my viewpoint as a customer, my bill didn't go down enough. So 4 years later, last December, a year ago, I decided to do all of these other options. But the rates that I am on here in California are very different from the ones in Kansas. I am on a mandatory 3-period time of use rate. And that is because it is part of NEM 2.0. As was mentioned earlier, there's NEM 1.0, which is where Kansas is at right now. And the question is, as more and more customers in Kansas adopt solar, and I will just briefly refer to comments made earlier today, that a lot of the reasons why people adopt solar is because they are passionate about the environment. A secondary reason is, of course, the income tax credit, which is 30% last year and 26% this year, is going to decline to 22% next year, but might be restored by the incoming administration and be set back at 30%. All of these measures are specifically focused on encouraging solar, plus there's the cost of solar falling. So I think Kansas would be no exception. You're going to see significant growth in Kansas, regardless of what the rate design is or isn't, whether or not there's a grid access charge or a minimum bill. People who are passionate about solar are going to do what they are going to do. They might do it at a little slower rate, but the graphs that Witness Lutz showed, there has been no slowing down, even in Kansas, despite the institution of a three-part rate. Now, clearly the Supreme Court, and again, I'm not a lawyer, my daughter is a lawyer, but that doesn't help me at this moment. I am an economist by training, and what I will do is I'll simply say that as I read the decision, I pondered as to what it meant, and I was also given the opportunity to watch the live Q&A that took place with the Supreme Court, with the lawyers from the utility and Mr. Bender. And the impression I got was that they recognize there is an issue, that there is a cost shift, there's the free rider problem. Again, I'm not speaking as a lawyer, just as a person watching the show and then reading the document as it came. I got the impression that hardly anybody will dispute the fact that a solar customer puts those panels on their roof to change their behavior and their consumption pattern. Otherwise, why would they spend $15,000 to $30,000 before their tax credit to do something like that? The result is a dramatic change in their load shape. Well, the court said no discrimination. So I thought hard, working with, of course, my clients at Evergy, as to what could be that solution. And the way I interpreted it was that on the consumption side, they would pay the same rate. There would be no discrimination. But they are not just consumers, they are prosumers, right? They also produce the power. And that is a fundamental and striking difference between consumers and prosumers. As I said, 4 years ago, I was a consumer, invested a lot in energy efficiency, but I was not a prosumer. I was not sending any power back to the grid. I was not exporting. And there's hardly any solar customer who is not going to export at some hour of the day. It's almost an impossibility to imagine such a person existing, even though hypothetically people can exist of all kinds, but it's very rare for the solar capacity not to have a surplus at a certain hour or several hours. So my own behavior, my load shape, which I monitor very closely, changed dramatically. I had the negative load shape of a typical solar customer. Now, the court said, well, you cannot have discrimination. So some of the parties are saying that the demand charge has been reborn essentially as the grid access charge. That is not true. The demand charge would apply to them as a consumer. The rate will stay the same. It'll be a two-part rate for all customers, whether they have solar or not. What will change is the grid access charge will come into the picture. And that obviously will be based on the size of the panels. If you don't have the panels, you have a 0 panel size in KW, you'll pay nothing. But this is a charge to reflect the fact that they are being provided a different service, import as well as export, and battery storage at the other end, at the grid end. So those unique features are impossible to capture with a minimum bill. The minimum bill is sort of a general way to deal with the cross shift issue. There's no doubt about it, but it doesn't capture the unique elements of the solar customers. And then it puts all customers on the consumption side into the same bucket, so to speak. It's a charge on consumption, whereas the grid access charge is not a charge on consumption. It is a charge on the fact that they are producers, they export power, and the size of their production is tied to the size of the panels. So it's getting to them in their behavior as producers. The other consumers who are not producers don't have to pay. They're not producing, so why should they pay? But they're all consuming, solar or not solar, and that's why they will all have the same two-part rate. That's my understanding. And that's why I prefer the grid access charge over the minimum bill. But as a fallback, the minimum bill is there.
Dr. Fricke, I thank you very much for an incredibly articulate and very nuanced answer. It was so much so that it consumed my second question. So I have no more questions. I do appreciate your testimony very much and your perspective as well. Thank you very much for this.
Thank you, Commissioner.
Thank you, Commissioner Keen. Commissioner Faruqi, I did find one question. I am on page 9 of your rebuttal, and I'm on line 3 that starts, this bidirectional interaction with the grid is the key distinction between DG and non-DG customers. This is just what you were referencing. It is that the key direction or the key difference is that they're going both ways.
Correct.
And if they were just importing, that's like every non-DG. So others have characterized the import as battery storage. Is it really battery storage, or are they just acting like every other non-DG customer and using the electricity?
I'm a little confused by the reference to the import being viewed by some people as battery storage. I would think the export would be viewed as battery storage, because when they have surplus power that they cannot fully utilize themselves, then what they're doing is they're sending it back to the grid, and the grid is keeping it for them until the sun goes down. I mean, that's what happens in my house. I charge my battery in the morning. About noon or 1 p.m., the battery is fully charged. Now it's on standby, and the sun is shining. And so the panels are directly sending power to me. My air conditioner is running in the summer months. The power is coming. At some point around 6 p.m. or so, depending on which month of the year it is, the sun is no longer producing. And now I draw power from the battery. So when I had that, if I didn't have the battery, I would send the power back to the grid. It's just that I purchased my own battery because I have a time of use rate to deal with. So I'm using the battery for arbitrage against that. Most people don't have a battery. They just have solar. At this point, as you know, only 5% of the 2.1 million customers in the US have battery storage. The others are just sending it back to the grid, and the grid keeps it until the sun goes down. And then this person imports power back. When one of my neighbors, I have a court with 10 homes, I am one of the 10, 4 of them have solar, me included. I'm the only one with the battery. I just had to do something different to get ahead of the curve here, right? Keeping up with the Joneses phenomena. And I got the electric car as well. Not to show off, but just to indicate I'm testing to see, like, living this life, how does it change my interaction with the grid? None of my neighbors with solar have a battery. They just send it back to the grid. The grid stores it for them, but the grid doesn't charge them for the battery. It's a free battery in a sense. So I don't know if that responds to your question, Commissioner, Madam Chair.
I'm thinking prior to you being so smart to purchase your battery, but in the evening, let's assume you didn't have your battery. When you're importing energy from the grid, you're like everybody else. Is that correct?
Absolutely no difference. Yeah, it's running my air conditioner, it's running my refrigerators, it's powering my computers, my TV. I am just like anyone else. I mean, it's sort of the illusion of being superior goes away when the sun goes down. Then we are all equal. We are just buyers of power. If I didn't have the battery, I'd be just like that, except that the battery lets me until 10 p.m. The battery is powering me. It depends on how hot the day was. But the battery just extends the window in which I feel self-sufficient.
Okay, so the fact that the energy is going back to line 3, the bidirectional interaction is the main distinction, is what for a DG customer, right?
Madam Chair, I would say that is a significant distinction. The other distinction is the fact that if you look at the load shape of these customers who are now producers, the load shape is totally different from the load shape of an energy efficient customer. The energy efficient customer will never export power back to the grid, right? They'll just use less. But this producer, the solar customer, will export and import. So their load shapes have a very, it's called the duck curve in California and in some other jurisdictions. It has that unusual shape. And there are some people who argue that you cannot look at a customer having a negative load shape. And I agree, but this is not a customer that we're dealing with. This is a producer who's also a consumer, a prosumer, in other words. They are totally different. I mean, not as human beings, but just as how they interact with the grid.
Okay, thank you. All right, I appreciate.
Madam Chair, if I may ask a question, one more question.
Yes, Commissioner Keen.
Yes, thank you. I appreciate your indulgence. Yours as well, Dr. Faruqi. My question would be this. It just occurred to me again, thinking back on the day. I'll try to ask this as succinctly as I can. With regard to the rate impact on those ratepayers that are least able to pay, does either the minimum bill approach or the grid access charge approach provide any kind of protection?
The customers, just so I understand the question, Commissioner, the customers who are least able to pay, who are not DG customers themselves? In other words,
no, for those who are DG customers.
Those who are DG customers?
Yes, I'm sorry, right.
Okay, I mean, obviously there are two separate questions, and then both are valid questions, but you're asking for the ones who are DG customers. And the question is, can they afford to pay either a grid access charge?
I'm sorry, I probably did confuse you. Obviously, with regard to the minimum bill, it applies to all ratepayers, where the grid access charge will only apply to the DG customers. I didn't mean to confuse you with that aspect of my question, actually.
Okay, so let's look at the grid access charge first. It only applies to those customers who have invested $10,000 or $20,000 or maybe even $30,000 to install the solar panels. They either have the cash or they got a loan or had a lease. And to do all of those, they need to have very solid credit ratings because these are thousands of dollars. It's highly unlikely, not impossible, but highly unlikely that low-income customers earning $40,000 a year or something like that would even think about investing $20,000 to put solar panels on their roof. They have much better uses for that money. So the people who are low income, very few of them will have solar panels. And those, yes, the issue will arise about the grid access charge. Is it fair and equitable to put a grid access charge on them? And my answer would be, they had the money to put the solar panels. Their bill dropped a lot because of the solar panels. Some of their bill is now being paid by other people, and that's not fair. There's a cost shift. And so the fact that they installed the solar panels tells me that affordability for them is not an issue. They should be able to pay a small grid access charge a month when they were able to pay tens of thousands of dollars to install solar on their roof. So it kind of answers itself. I mean, I don't know of low-income customers struggling to make ends meet with a large family. They're struggling to put food on the table 3 times a day, to send their kids to school and college. They are not the typical solar customers. I mean, I would seriously doubt that. As far as the minimum bill goes, yes, there will be, because of the nature of the minimum bill, it has nothing to do with whether or not you install solar panels. It's just the fact that you had a small bill and now you'll have to pay the minimum bill of $35. So the question arises, what was their bill before? If their bill was above $35, there's no impact on them. And many low-income customers will have a bill higher than $35 to begin with. I mean, they tend to have larger families, inefficient homes, poorly insulated homes. They tend to have inefficient appliances as well. And so for all of those reasons, and all the studies I've looked at as an economist across many jurisdictions, low income does not automatically mean low usage. This minimum bill is applying to low usage customers. It's not applying to low income customers. It has nothing to do with income, actually. It is expressed in the usage or bill characteristics. And as the company has indicated, as witness Lutz indicated, the company is sensitive to the issue that there might still be some low-income customers who may fall into that category, and they will take steps to redress their issues. I think a question arose of how would a customer even apply for a low-income opt-out provision? How would they be found? It's not difficult to find them. In California, there is a low-income program called CARE. It stands for California Affordable Rates for Energy. You are given in your bill a schedule of income levels. It's all related to the federal poverty guidelines. If you make less than the federal poverty guideline and you're a single person, there is a line item there for your income. If you see that your income is lower than that, you're going to say to the utilities, whichever one it is, that I am a low-income customer, I'm qualified for CARE. And as a result of that, you're going to get a 30% discount on your bill. And we have about 2.7 million customers out of 10 million taking service on the CARE rate. It's in their interest. Why would they not? I mean, they're struggling to make ends meet. Somebody's giving them a 30% discount. Every month they get a bill which mentions this. It's advertised on the website of the utilities. So it's all a question of how do you engage through the media, through your website and through your bills. It is not difficult to identify them. So if you are a low-income customer today in Kansas, hypothetically speaking, and we have this charge in place, maybe 2 years from now or whatever, the low-income customers will see, okay, my bill is less than $35 and I qualify as a low-income customer, so I'm going to ask for an exemption. I think it can be addressed.
Thank you, Dr. Faruqi, for the nuanced answer again. Thank you, Madam Chair.
Thank you. We will move on to Pioneer, Southern Pioneer, Glenda Kafer, please.
Thank you. No questions.
All right. Liberty Empire, Mr. Flaherty.
No questions.
Thank you. KIC, Mr. Vincent.
No questions.
Thank you. KEC, KEPCO, Midwest Sunflower, Ms. Cunningham.
No questions.
Thank you. CURB, Mr. Astrap.
Hi, I'm here. Yeah, I do have a few brief questions for Dr. Faruqi.
Please.
Good morning, doctor. Or afternoon, rather, I think we're at this point. Sorry. I want to turn your attention to, have you been listening to the hearing all day today?
I have done my best.
Sure. Specifically regards to Mr. Lutz's testimony and cross-examination, were you present for that?
Yes, I was.
Okay. Did you hear the questions from Ms. Kafer and others regarding the text of the Kansas Supreme Court order?
Yes, I did.
And were you able to listen in on Mr. Lutz's responses to some of those questions?
Yes, I was.
Okay. In one of those responses, and I believe the question was posed for Ms. Kafer, regarding the Supreme Court's observation that the utility has appeared to have given up on the economic promises associated with private self-generation of renewable resources. Do you remember that question?
Actually, to be honest, that particular one, I don't remember. I'm sure I was there, but if you wouldn't mind repeating that discussion, I would appreciate it.
Not at all. I'll just cut to the point there. Mr. Lutz, in response to this statement from the court, disagreed that Evergy had given up on the economic promise of self-generation from renewable resources. Would you agree with that sentiment?
I'm not sure what the question is. Given up on the promise of self-generation through renewable energy? Is that referring to solar? Or is
yeah,
it referring
I think phrase another way. The Supreme Court was saying that from their perspective, that Evergy is essentially abandoning trying to promote the economic benefits of having self-generation on their system.
If I can ask just to make sure I understand the context, is the court saying that Evergy has given up because they're proposing to change the rate design to minimize the cost shift?
Sorry. Do you believe that Evergy is committed towards trying to unlock the potential benefits associated with having DG customers on its system? Or do you think they don't care about that?
First of all, I do not work for Evergy. I am a consultant to them. I'm not privy to all of the internal discussions that management has on strategy. But from all of the work I have done for them over the years and the travels I've made to Kansas going back to 2009, when the commission had a conference on new rate design options to encourage more efficient use, more renewable energy, I've always had the impression that there are opportunities, and looking at the numbers that I see of customers signing on to DG, I see the numbers growing and rising. I have not picked up any sense that the company is trying to sort of shut off this opportunity. I don't think the company is anti-solar, if that's what the question means.
Okay, thank you for that. You mentioned that solar proliferation in Kansas is rising, right? Let's talk about some of those factors that go into this phenomenon currently, okay? In response, I believe, is one of Chair Duffy's questions to Mr. Lutz about solar proliferation. Mr. Lutz refers to tax rebates and other kinds of economic incentives that are designed to essentially encourage customers to install DG panels, solar panels. Are you familiar with these kind of programs and incentives?
Yes, I am. Yeah.
Okay. And in your opinion, are these incentives effective at promoting or encouraging people to go out and just buy solar?
So let me mention that I'm not particularly familiar with utility-specific incentives in Kansas, but I can comment on the federal incentives.
And that's what I'm asking about. Yeah, federal and state.
So the federal incentive was 30% until last year. On your income tax returns, you could have 30% of the amount you spent on solar apply as a deduction. Now that meant that you had to have enough deductions and enough income for that to make sense for you. It only made sense for those people who had sufficient income that the deductions would kick in. If your income was not high enough, then you wouldn't get that benefit. In other words, for you to deduct, you need to have the income against which you're going to do the deduction. But most solar customers, as I said earlier, based on my evidence and my reading of the literature, tend to be customers who have high bills, they have big houses, they have big usage. The economics for them is to lower their bill. That's one factor, but it's only one of three factors. It's an important factor, and some people can debate endlessly as to why is that not the only factor. And we can perhaps have a discussion on that some other time. But the reality is economics is one element of the picture. The income tax credit shortens the payback period. And for those people who look at the payback period as an indicator, like, will it take 6 years for me to get my money back, right? I spent $25,000. How long will it take for me to get it back? Otherwise, if it takes 25 years, why should I be doing it? However, I can tell you in a place like Quebec in Canada, where the payback is 25 years, people are still putting it in. And I have had discussions there with the people. Electric prices there are very low. It's entirely a hydro-based system. They are putting it in because they are passionate about being organic, about the health of the planet, as well as the pleasure one gets from doing your own gardening. Some people only eat vegetables they grow themselves. It's an organic phenomenon. It's the greening of taste that we are witnessing. It's not just an American phenomenon, it's a global phenomenon. Australia is way ahead of the US in that regard. But yes, price is a factor. The solar panel prices have been coming down, and I present data on that, as you probably have seen in my two testimonies. So a combination of the income tax credit, any applicable state income tax credits, plus any utility incentives, along with the falling price of the solar panels, plus the organic nature of the customers, their tastes becoming greener. Those are all the factors driving solar sales, but it doesn't end there. There is another factor that comes in, and I'll mention it because it is probably the most important factor. If you look at the 50 states, you will see some states are very active, and in some other states, there's nothing happening. All of them have the same federal income tax credit until last year of 30%. Why is it only 14 states have any activity and the others are pretty much asleep? Simple reasoning is because the solar industry has focused on those states. And as soon as they add a 15th state to that list, you will see the activity ramp up. A lot of the reasons why people put solar on the roof is because suddenly their neighbor put solar on the roof. And why did the neighbor put solar on the roof? Because somebody knocked on the door or somebody sent them a message. They woke up to this opportunity. So it's a combination of marketing by the solar industry, economics, and the greening of customer taste. Each state is different, right? I mean, I was talking to Indiana legislature just a few weeks ago. They don't have much solar there, but it'll come. It's coming.
Sure. Thank you for that. So I guess back to my original question, though, do you believe that these federal and state tax rebates and incentives play an important role in encouraging people to buy solar panels for their house?
Absolutely, without a doubt. 30% is a big number.
Yep.
I mean, when I put $20,000 for energy efficiency on my house upgrade 4 years ago, the rebate I got from Uncle Sam, hang on to your seat, was $500. It didn't matter if I spent $100,000 in energy efficiency, they only pay $500. So the federal policy is hugely tilted in one direction, is to promote solar. 30% is a bigger number than you'll probably get for any other kind of federal income tax credit. And with the new administration coming in, I am quite confident that Congress is going to bring it back. And otherwise it's going to fade away, go from 30% to 26% this year, to 22% next year, and then 0%. That would be devastating to the solar industry if that income tax credit goes away. I'm sure they'll do their best to make sure it doesn't go away.
And as kind of an aside on that point too, anything that decreases the economic recoverability of solar panels would hurt the promotion of DG proliferation in an area, correct?
In other words, something like removing the income tax credit or the state rebate.
Yeah, or increasing the cost of having solar in a particular location. It costs more money to have it installed in your house. That would
absolutely. Yeah, in other words, if the cost of the panels goes up, either because labor costs rose, or because a tariff was put on solar panels, or because solar just became an impossible task, they ran out of the raw material and the panel prices went up. Absolutely.
Or the sun stopped shining, right? Okay.
That would be catastrophic for other respects as well.
We'd have more problems at that point, sure. I want to turn now to the proposals from Evergy, the GAF and the minimum bill, okay?
Sure.
And you've reviewed both these proposals, correct, in your testimony?
Correct.
And under either of these proposals, some, if not most, DG customers will see some kind of extra charge or an increase in their bills. Is that right?
That's correct.
Okay. And this will be specific, not just to these people, but future solar customers as well, if they decide to install solar panels, right?
That's correct.
So wouldn't this increase in DG customers' bills in Kansas necessarily discourage more customers from buying and installing solar panels themselves if the economic payoff is going to take longer?
So there are two ways to answer your question. The one way is if you just look narrowly at the payback period, yes, it'll become longer. There's no doubt about it. And that should cause some discouragement to occur. But the reality is the solar panel prices are continuing to go down. So it's not immediately obvious to me that the payback will become longer, because even though their bill went up because of these charges, one of these two being put in, the solar panel prices in the future will keep falling.
And that's because market forces and technology is why the panel prices are falling?
It's technological improvement.
Sure.
Exactly. I mean, it's economies of scale, and they keep coming up with better. Many smart people, many universities, et cetera, are all working on lowering the cost of the panel prices. And I have full confidence based on the history and the projections that they will come down. But if I can just add one footnote to that answer, it is not just the economics that matters, as we were discussing. There are two other factors at play. One other factor is the greening of customer taste. As more and more people accept climate change as being a factor, they're going to put solar, even if the economics is not as attractive.
Okay. And Dr. I want to just focus on the economic portions of it as far as people's preferences for protecting nature and their tolerance for increased cost to do so. Let's leave that aside for right now. I know those exist, but I just want to focus on the financial aspect of it. So if there is an increase to the cost of installing solar panels from whatever source, does that necessarily diminish the value of these economic incentives and the decrease of pricing and technology?
It's a complex question. Would you mind restating it just so I make sure I understand the question?
Okay, sure. Isn't installing a solar panel without any extra charges from a utility company seen as more economic versus installing that exact same solar panel, but then having to pay an additional cost on top of that to the utility? Is there a difference in perception of which option you prefer to go?
The only way to answer that is to look at the data. And the data that Witness Lutz showed that despite the institution of a three-part rate, solar installations kept on rising. Now, maybe somebody will say, well, they would have risen even faster had you not instituted a three-part rate. That's a hypothetical question.
Sure,
but
yeah.
The fact of the matter is, it didn't flatten the curve. It didn't kill the curve. It didn't eliminate the solar industry.
Okay. Well, no, I'm saying it's eliminating the solar industry, but you would agree that by adding additional costs to a customer for installing solar, that one, diminishes their return on their investment, but also two, could possibly discourage other customers from choosing to do the same thing, right?
I agree with that. Other things equal, if that's the only factor and it's like a chess game, you're going to make a move, other things equal, yes, it will cause some inhibition to occur. But all the data we have, Hawaii ended net metering in 2015. It didn't stop the growth of solar.
Sure.
So,
well, and you'd agree with me, Hawaii and Kansas are two different states and demographics and everything possibly different about them, right?
So I totally agree with you. And I'm not suggesting that Hawaii is like Kansas, but I'm just saying if you look at the data from Arizona or California or any of the other states, and you go overseas and look at Australia, solar is on the march. It is unstoppable. It will, by 2020, you will see just about every other house with solar panels in the roof, regardless of what we do with this grid access charge in Kansas.
Okay, fair enough. So in essence, you said that Evergy is still mindful of the potential economic benefits of having DG on the grid. But at the same time, Evergy's proposals will now present an additional increased cost to encourage to using solar, thereby decreasing people's willingness to install solar. And so, assuming the Biden-Harris administration turns course and wants to promote it more again, wouldn't the governments and other agencies have to spend more money to get the same level of economic benefits in light of those price increases in Kansas?
There is, as you know, a balancing act in rate design. We are not talking about the solar industry without looking at the cost shift it creates. There's an issue of fairness and equity between solar and non-solar customers. That's what this rate design is really, this proposal is designed to address, is the cost shift. How fair is it that people who cannot afford to have 3 meals a day, who are clearly not solar customers, that they are paying a portion of the bill of the solar customers? That doesn't sound good to me, at least as an economist, as a human being. The best way to incentivize solar is not by creating a cost shift from non-solar to solar customers. It is by providing an income tax credit to the solar customers. That is the best way to do it. And that's what we should rely upon to encourage solar penetration, not a cost shift from people who cannot afford to have 3 meals a day, subsidizing people who have fancy cars and big houses and who have thousands of dollars lying around to put solar on the roof to reduce their bill.
So under that logic, wouldn't it make sense to remove cross subsidies associated from, say, the whole residential class and industrials under that logic?
So there's a distinction. The distinction is that those customer classes are not changing dramatically. They're pretty much constant. You have so many residential customers, so many commercial customers, so many industrial customers. You have so many people in the rural areas, so many people in the urban areas. There is no big dramatic seismic shift taking place. But if you look at this solar phenomena driven by economics and changing tastes and everything else, it is really taking off very fast. So this is a subsidy or cost shift that really needs attention. Otherwise, it'll become a huge challenge in 5 to 10 years.
Okay, thank you. I have no further questions. Thank you, Doctor.
Thank you. We would turn to Mr. Bender.
Thank you. Good afternoon, Dr. Faruqi.
A pleasure, Mr. Bender. It's good to see you again.
Yeah, likewise. I have a few questions to follow up on the last line of questions. and then some questions that Mr. Lutz punted to you. So I'm hoping that you can answer for us. On that last answer you just gave, that unlike the cross subsidies that exist for the residential class as a whole or industrial class as a whole, the DG subsidy is taking off fast. That was the testimony, correct?
That is correct.
Okay, but let's talk about magnitude, right? The DG cross subsidy is in in the tens of thousands of dollars under your calculations in Evergy's service territory right now, correct?
That's correct. Yeah, it's a couple of $100,000. I mean, that's the revenue going to the class, and the subsidy is like 88,000 or something.
Okay, so putting aside some issues we'll have with how you calculated that, which we'll talk about, but we're talking about a cross subsidy for residential customers in the hundreds of millions. It will take a lot of growth for the solar industry to catch up to that, even if it is taking off fast, as you say.
So there was a question for me, which was, is it a small number?
How long will it take for the DG subsidy, even as you calculate it, to approach the residential class as a whole subsidy, the cross subsidy there?
I think there are two issues here. It certainly is a small number today in Kansas. There's no doubt about it. Other states have huge issues because they have hundreds of thousands of solar customers. Kansas certainly is not even close to that. But the issue is one of principle, and the issue is one of the nature of the subsidy. It's going from people who have a difficult time making ends meet to people who have the ability to spend $20,000. It's sort of the reverse Robin Hood scenario, as it has been mentioned by some people. I think that is an issue that certainly concerns me and concerns many people who look at this issue.
Let's talk about the cross subsidy. I think you heard the testimony of Mr. Lutz. And I think from my understanding of your testimony, you have a similar framework, which is you understand, or you say that there's a cross subsidy of low use customers under a two-part rate. Well, I guess starting out from the large circle, there's a lot of utility costs that are fixed or sunk, and revenues are variable based on
correct.
use.
Yes, correct? Yeah, correct.
And then within that, a two-part rate is part of that overall problem. And that's true because low use customers produce fewer revenues towards sunk costs, correct?
That's correct.
Okay. And then the DG subsidy that you calculate is a subset of the low use customer two-part rate subsidy. Is that correct?
That's correct.
Okay. Let's talk about that, the medium circle. In the 403 docket, which you refer back to in your testimony in this case, you calculated a subsidy in that case based on, you came up with about $77 per residential customer as the fixed costs of residential service. Is that right?
Correct.
Okay. And you got that by taking the 2015 cost of service study and all of the customer and demand allocated costs, adding them together, dividing by the number of customers in the class, correct?
Correct.
Okay. So that effectively says every residential customer has a cost responsibility equal to the class average of customer and demand costs. And then we're going to solve for that as the metric for whether or not there's a subsidy. Is that right?
So obviously it's an approximation, because you could argue that some really small customers don't need much capacity support from the grid, and some really large customers with bigger demand need more capacity from the grid. So the $77 is an average number for the class as a whole. It may not be exactly the correct number. If a more granular cost of service study was done on a customer by customer basis, you would find variations. The only way to deal with that would be to have a customer capacity charge, which is what they have done in, for example, in European countries.
Okay, to save time, I'm going to cut you off. I think you had already answered my question. It's just what you did in 2016. And I think, well, I know this because we talked about it before, but your position on cost shift is that all low use customers under a two-part rate result in a cost shift, correct?
That's correct.
Okay. And DG customers are just a subset of low use customers, correct?
They are different, if I can add in one important respect. They are not just a customer who is small, like other small customers. They're also a producer at other times. They're exporting power, and they have a very pronounced difference in their load profile from their other small customers.
You also said in the 403 docket that the individual customer, the load shape difference of the DG customers can actually reduce the cost to serve them below the $77 average, correct?
Yes.
Okay. And in the 403 docket, you claim that reduction was roughly 34% based on an analysis you did outside the cost of service study, but based on the peak 100 hours of the utility. Is that correct?
To be perfectly honest, I don't remember that specific detail, but subject to check, I'm going to accept your statement.
Okay. And then you also calculated in this case, and directing you to page 15 of your direct testimony.
Okay, page 15. Direct. All right, I'm there.
Okay. So you have a figure here, figure 1 on page 15, where you calculate a subsidy under different rate designs. You see that?
Yes, I do.
Okay. And you also describe your methodology in Appendix B to your direct, or Attachment B to your direct testimony, correct?
That's correct.
Okay. And as I understand it, this took a cost to serve DG customers as a class and subtracted revenues from the DG customers as a class under different rate designs. Is that right?
That's correct. We took the cost number, which is shown on the bar on the very right, and we showed the composition of that cost number in that attachment, figure 1. And then we said, okay, how much revenue would we recover from the DG customers using several different rate design options?
Okay. I'm going to show you what is marked as, or what I've asked to be marked as Sierra Club 3. Do you recognize this document?
Yes, I do. That's my figure 1.
Okay. This is actually the work papers that you use to create figure 1 on page 15, correct?
Yeah, I mean, it's also a spreadsheet that goes with it, but yes, this is the figure that you have projected is exactly the same as figure 1.
Okay. And maybe, I don't know if you can see the full screen. This is actually an Excel spreadsheet, and there are tabs at the bottom that contain the spreadsheets that calculate
yes,
the values. Okay. So if we go to the subsidy tab, these are the calculations of the costs and revenues. Is that right?
Yes.
Okay. And for all, I'll highlight here, which is column H, rows 10 to 16. These are the constant costs that you used for all of the calculations, correct?
Correct.
Okay. It's $217,688. You see that?
Yes.
What's the source of that value?
That's a value that came from our previous case. It was the number included in my. It did not originate with Brattle. It came from what was at the time Westar Energy, from their cost of service study.
Okay. This is actually Westar's witness, cost of service witness Amen's revenue requirement filed with the original application. Is that correct?
I believe that's correct.
Okay. You heard testimony earlier from Mr. Lutz that the original application proposed a roughly $15 million increase in would have been authorized revenues in the beginning of 2018. Do you recall that?
Yes.
Okay. And do you recall what the actual approved change to revenue was?
I don't recall that, but some checking I've done on how much would the revenue requirement change for the DG class, and I cite this on page 14 of my rebuttal testimony. It's $4,103. That's a number that was mentioned earlier by Mr. Lutz.
Right, and that's the approved decrease in revenue, correct?
Yes.
And what was the baseline revenue that decrease was applied to?
I don't have that number, but my impression is that the $217,000 number here that I have would go down by that 4,000 something number.
So you believe that the $4,103 is applied to Mr. Almond's cost of service revenue requirement?
That's my impression.
And where does that impression come from?
From conversations with Evergy.
Okay. They didn't tell you that the revenue reduction in the settlement agreement was applied to the then existing revenues?
When I was doing this calculation that you have pointed out here, and we were looking at the $217,000 number, my impression was that the 4,000 would basically adjust that number downward by 4,000, and it wouldn't materially change the shape of figure 1.
So your testimony in your rebuttal on page 14 that there's no material change assumes that the $4,103 reduction is applied to the $217,688 value.
Correct.
And you also calculate, I scroll down here, revenues based on some billing determinants in it'd be rows 37 through 54. See that?
Yes, if you could make just a little bigger just by enlarging the text, because I'm just looking at the screen. I think at the bottom right, if you have that.
Oh, okay.
You can move that slider. Yeah, great, thank you.
So those rows 37 through 54 are the billing determinants you use to calculate revenues under the different rate structures that you present in figure 1 on page 15 of your direct testimony. Is that correct?
That's correct.
Okay. And so we see for DG customers a total of 1.1 million kilowatt hours as the billing determinants you used.
Yeah, it's a combination of the summer and winter.
Right, so you divide it between summer and winter and then the tiered rates, but
Yes.
they total to 1.1 million and change, correct?
That's correct.
Okay. And that's the value you use to calculate these revenues up in line rows 10 through 15. And it'd be columns C, D, E, and G, correct?
Yes, correct.
Okay. And so it's those revenues based on the billing determinants you use that you compared to the 217,000 cost number that derive the subsidy values that you present in your testimony, correct?
Exactly. So just to make sure we are on the same page, I believe we are, but just to make sure, the 217,688 number for inclining block rate is compared to the 133,994, which is being recovered from the rate design, the inclining block rate. And the subsidy is the difference between the two numbers, the 83,694 number, which is the 38% delta there, the subsidy.
So and this is basic math, but I guess to complete the thought, if the cost number were to go down or the revenue number were to go up, the subsidy would change, would reduce for each of these.
Correct. Yes, that's correct.
Did you compare the billing determinants you used of 1.1 million for DG customers to the billing determinants in the approved settlement?
No.
You also testify, and we heard some of it today, that the problem, kind of the overarching problem, in your opinion, for DG customers and why they're different from maybe efficiency customers is that they reduce their volumetric bills and revenues by more than they reduce their demand, correct?
Correct.
Okay. And that's in your direct testimony on page 5. You use the numbers 49% reduction in kilowatt hour billing determinants and a 5% reduction in demand. Is that right?
Yes.
Okay. The 5% reduction in demand value that you present, that's the reduction in the customer's individual demand, regardless of when that demand occurs, correct?
I believe it's based on our analysis of their, if I can answer by referring to a diagram in my rebuttal testimony, perhaps that'll help. We are looking at the timing of their demand as well in the load shape comparisons that we provide. Each customer, of course, will have different times at which their individual demand will go down. But the challenge with solar customers is that when the sun begins to go down, their consumption begins to rise and their demand begins to rise. So the figure I'm referring to is on page 10 of my rebuttal. It's figure 2. And you will see that their demand, the net demand, just does go down in the middle of the day, but not towards the later part of the day, which is when the system peak tends to occur. So their coincident peak demand doesn't move much when it needs to move for demand benefits to arise. The demand benefits are not significant when the system is peaking.
When you say demand benefits, you mean demand during cost-causing peak hours on the system?
Correct, yes.
And you're looking at figure 2 in your rebuttal to the left-hand shape, which is the winter load shape, correct?
Well, I'm looking at both, generally speaking, looking at winter as well as summer. In both, there is this issue that the sort of the duck curve does begin to rise around 5 p.m. and it sort of begins to hit a peak around 6 or 7 p.m. And that's the challenge because the sun has gone down, solar generation has gone away, and their air conditioners are still going at full blast.
Okay, let's look at that summer load shape. You understand that
just a quick reminder that my understanding is that the witness has limited availability and it may be another 10 minutes. I'm not sure, but so be mindful of that with the questions because we still have other questioners. Thank you.
Yeah, I'm not sure what, I have several more questions. I'm not sure what the instruction is.
Okay. It's my understanding, Dr. Faruqi has to leave at 5. Let me ask staff, do you have a number of questions?
Staff has no questions for the witness.
Okay, all right. Very quickly, as we look at Recross, a shout out to anybody who's going to Recross, because we are down to about 7 minutes. 10 minutes. All right. Hearing no response, Mr. Bender, you can continue on, but you even have limited time as well.
Thank you, Anna. Dr. Faruqi, directing you back to figure 2 on page 10 of your rebuttal.
Okay, I'm back there.
Okay, the top line is the DG customer before they install generation before their solar panels go on. And the green line is after, correct?
Yes.
Okay.
The version I have is black and white, so I'm just going with your judgment. But basically, the line at the very top says pre-DG, and the line which has a big dip, that's the post-DG. And then the other line is the non-DG customers on average.
Okay. Your testimony was that during system peak hours, DG is not producing much. I'll represent to you, for the interest of time, that it's already in the record that the system peaks used for cost allocators in the rate case, so from the test year, were in the 4 summer months, it was 4 p.m., 4 p.m., 3 p.m., 5 p.m. So that'd be 1,600 hours and 1,500 hours, 1,700 hours. In those hours, the DG customer's load is reduced based on their generation compared to pre-DG, even compared to non-DG customers, correct?
Yeah, in those hours, it's certainly reduced, and it's a question of what the future cost of service studies would look like. More and more systems are shifting the shape of their system load curve, and I would expect the same would be true in Kansas. They have a lot of solar on the supply side coming in, and that's what causes the curves to shift, the cost of service curves.
So for this record, we have the DG customers' cost reduction based on those summer cost causing peak hours in this load shape, correct?
Yes, that's the current situation.
And those reductions during those 4 cost causing peak hours in the cost of service study, the reduction is more than 5%, fair to say, correct?
Yes, certainly.
Okay. Do you know how much of the total demand allocated costs are reflected by those 4 summer hours we just discussed?
Actually, I don't, but I could certainly look into it.
And very briefly, since I guess I have limited time here, your testimony earlier was that the grid access charge is, in your opinion, preferable to a minimum bill because it's based on the solar customers, the fact that the solar customer is a producer in addition to a consumer, correct?
That's correct.
Okay. If we look at what the grid access charge collects, what bucket of costs were used to calculate the grid access charge, none of those costs are specific to the production function, correct?
That's correct. But basically, if I can add just one more sentence there has to be some way to make that tangible. And what we're using is a measure of the cost shift to come up with the grid access charge.
Okay. And that cost shift is based on what we already talked about. It's the customer, but mostly the demand allocated costs being recovered in a volumetric rate, correct?
Mostly that, but there's also the fixed cost. The fixed cost to serve them is not $14.50. It's probably more like $20 to $25. So there's an element of fixed cost in there as well.
And those are from shared plant that the DG customer shares with other customers and customer classes, correct?
Right. So it would include the line transformer. It will also include metering, billing, and customer care. And some utilities include something upstream of the line transformer, a portion of the distribution grid, if you will, the feeder or the circuit.
Sure. And those are costs that are also incurred to provide service to non-DG customers, correct?
Correct.
Okay. So the grid access charge is collecting costs that are incurred for DG and non-DG customers to provide them with utility service, correct?
Well, I would phrase it slightly differently. I would say that the grid access charge is collecting the costs that they otherwise would not be paying because, excuse me, I'm just going to turn it off, sorry, because their usage went down dramatically and their demand didn't go down equally proportionately.
you're talking about recouping additional revenue. My question was whether the costs, the bucket of costs used to calculate that charge, were costs common to the same production plant, distribution plant, transmission plant that's used to serve non-DG customers' loads.
It's their share of those costs that they're not paying because their volumetric sales went down dramatically.
So that's
It's
grid
not all
access
of those.
charge.
Sorry, please.
So that's a yes, the grid access charge is collecting those costs. It's just through an additional revenue source, correct?
It's sort of, it's reallocating the cost more fairly between, because if they were not collected, if the grid access charge was not there, then somebody else would have to pay those costs because they still have to be recovered for the utility to be viable. And so instead of having other people pay those costs, the DG customers will now pay that through the grid access charge or the minimum bill.
Right. So my question was, you keep saying those costs. I'm just trying to clarify that when you say those costs, we're talking about the costs that are common to DG and non-DG customers. It's the same, we go back to the same FERC accounts and the same cost of service study that's allocating those across classes to DG and non-DG customers alike, correct?
Yes, they are common costs. It's just a question of how to share them. And that's what we're talking about, is they have to pay their fair share. That's all I'm saying.
I don't think I have any other questions given the time constraints, Madam Chair.
Thank you. It is 4:58. If you could remove the document that's up there, I would like to turn to the commissioners real quick. And is there anything you want to know from Commissioner French? I see him shaking his head. Commissioner Keen?
No, thank you.
No. And Ms. Dingus, I did not ask if you wanted to redirect. So is there anything very quickly?
No, I don't have anything. Thank you.
All right. Well, it appears, Dr. Faruqi, we are finished with you. Thank you. And I would also like to thank Mr. Lutz today. He definitely held up well throughout the entire day of questioning. So thank you very much. At this point, it is 5 o'clock. We did get through both of Evergy's witnesses. Tomorrow, we will start off with Richard Mackey, Pioneer, Southern Pioneer.
Yes,
And, I'm sorry, yes.
I'm sorry, I thought you were asking me.
You will, I'm not asking, perhaps just telling you, we will begin at 9 o'clock.
Okay, and at the pre-hearing conference, we did advise the parties that the only time Mr. Mackey's unavailable during the 2 days of the hearing is tomorrow morning. However, he's let me know that he can work it out so that he's only unavailable from 10:15 to 11:45, but he can't get out of that problem. So if we start at 9 o'clock, we may very well be done by 10:15. I just want to make you aware.
Okay, I was not aware of that. I believe, why don't we go ahead and start with him and see if we can get through.
9 o'clock, going to be directly following the business meeting then tomorrow?
We have our commission business meeting moved to 9. Looking at the agenda, we could probably start as early as 9:15. There's one noticed item and a consent agenda. So I would think we could start by 9:15.
If we have any concerns about Mr. Mackey, it seems also a possibility we could shuffle the witnesses behind him and take them first and let
Sure.
Mr. Mackey come, at 11:45 or whenever it is that he's available. Just a thought.
That works too.
I guess the danger is we get through all those witnesses and we're ready for him, but.
Why don't we you're right. We do. I'm sorry. We do have the business meeting. We should be done by 9:15. Why don't we go ahead and start with Mr. Mackey? And then if we have to come back, we could do that. Would that work, Ms. Kafer?
Yes, that'd be great.
Okay. So with that, are there any other comments or issues that did come up today that we need to know about in terms of technical? I don't believe so. Thank you, everyone. We will stand adjourned for today. We will begin immediately following the business meeting tomorrow. Everybody have a good evening. Thank you. Thank you, technical staff. Thank you, court reporter. All right.